All persons are commanded to keep silent under pain of penalty while the impeachment court is in session for the trial of Vice President Sara Duterte.
The impeachment trial of Vice President Sara Duterte is hereby called to order. We shall be led in prayer by Senator Judge Risa Hontiveros.
Sa ngalan ng Ama, ng Anak, ng Espiritu Santo. Amen. Ama naming Diyos, pinupuri ka namin, Panginoon ng langit at lupa, ang pinagmumula ng lahat ng karunungan, katotohanan at hustisya. Sa Ebanghelyo ngayong araw, ipinaalala sa atin ni Jesus na ang tunay na karunungan ay ipinagkakaloob sa mga may mapagpakumbabang puso. Sa pagpapatuloy ng mga pagdinig o paglilitis na ito, hinihiling namin ang iyong gabay. Pagkaloob niyo sa amin, ang mga senator judges, ang karunungan na matukoy ang katotohanan, pagpapakumbaba na makinig ng may bukas na isip, at lakas ng loob na gawin kung ano ang tama ayon sa aming konsensya at ang rule of law. Palayain niyo kami sa pagmamayabang, prejudice, at lahat ng klaseng impluensya na maaaring pagpalabo sa aming paghuhusga. Naway manaig ang katotohanan, katarungan, at ang kabutihang panlahat sa bawat desisyong aming gagawin. Naway ang inyong espiritu ay gumabay sa amin na maglingkod ng may integridad, katapatan, at pagmamalasakit. Laging sinasaisip na ang pinakamataas naming responsibilidad ay sa sambayan ng Pilipino at sa katotohanan. Inihiling namin ang lahat ng ito sa pamamagitan ni Jesucristo. Amen. Sa ngalan ng Ama at ng Anak, ng Espiritu Santo. Amen.
Sama niya na sila. Sama niya. Senator Mark.
The Clerk of Court will now call the roll.
Roll call of members. The Honorable Senator Judge Aquino, Senator Judge Cayetano Alan, Senator Judge Cayetano Pia, Senator Judge De La Rosa, Senator Judge Ejercito, Senator Judge Estrada, Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the presiding officer, Senator Judge Escudero, Senate President Gatchalian.
With 20 senators present, the chair declares the presence of a quorum. In accordance with the rules of procedure on impeachment trials, the chair now recognizes the duly elected presiding officer to preside over the proceedings of the impeachment court.
Thank you, Mr. Senate President. Before recognizing Senator Judge Padilla, Chair would first like to dispense with the journal. If there are no objections, we dispense with the reading of the journal of July 15, 2026 of the Senate sitting as an impeachment court and shall consider the same as approved. The clerk of court will please call the matter before the impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances for the parties. Appearances for the prosecution.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honor. Same appearance for the respondent accused. Thank you, Your Honor.
Noted. Senator Judge Padilla, sir, what is your pleasure?
Maraming salamat po sa ating tagapamahalang hukom at sa ating pong Ginoong Pangulo Nais ko lamang pong basahin ng napakaigsing manifestasyon po.
The gentleman may proceed with his manifestation.
Maraming salamat po. A'udhu billahi minash shaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Aming mga kasama, ako po'y humihingi ng paumanhin sapagkat dito pong nakaraang linggo, lumabas po sa mga balita na may aligasyon na ako daw po ay hindi sumusunod sa batas. Ito po ay nakalulungkot para sa isang senador, sa isang senator judge, ang masabihan na hindi sumusunod sa batas. Samantalang nung tayo po ay merong mahal na saksi dito, pinaalala po natin sa kanya na harapin ang batas. Noong nakaraang linggo, ang atin pong kaibigan na ombudsman, ang sinabi po ng mahal na ombudsman na ako daw po ay hindi sumunod sa kanilang pasabi na mag-file ng aking counter affidavit. Nakakalungkot po ito sapagkat hindi po ito totoo. Inaamin ko po sa inyo, kung ICC lang, hindi po talaga ako susunod. Hindi ako magpapasakop sa ICC. Pero dahil ginagalang ko po ang ombudsman, dahil siya po ay aking kaibigan na itinuturing, dahil nagkaroon na po kami ng napakahabang kwentuhan sa aking opisina nung siya po ay kalihim ng hustisya, nag-file po kami. Ito po, hawak ko po ang original. Dahil sa akin po, importante ang original. Ito po ang original, nakalagay po dito. Nag-file ako. Nakalulungkot po na pati ang media ay nakikisama sa ganitong klasing propaganda na ang isang senador ay hindi sumusunod sa batas. Isang senator judge. Ito po, maaari ko po kayong bigyan ng kopya, mga mahal kong kasama, para mapatunayan na hindi ko po kayo ilalagay sa kahihiyan. Ako po ay nag-submit ng aking counter affidavit. At ganun din po, humihiling din po ako sa aking mga kasama, lalong-lalo na po sa aking kaibigang Ginoong Pangulo, na sa mga ganitong pagkakataon, hinihingi ko po na tulungan din po ninyo kami. Na maipaliwanag din po namin sa media na meron din po kaming mga pagkakataon na ipagtanggol din ang aming sarili at kami wag husgahang kagad na kami hindi sumusunod sa batas. Yun lamang po, Ginoong Pangulo at tagapangulong hukom. Maraming salamat.
Senators Erwin Tulfo, Senator Judge Alan Cayetano, thereafter Senator Judge Tito Soto are recognized. What is your pleasure, Senator Judge Erwin Tulfo?
Mr. Presiding Officer, Senate President, ladies and gentlemen, this impeachment court was established to try the Vice President of the Republic. Ang punto ko po rito, kasi napapansin ko po ilang araw na nagagamit po natin ang impeachment court, ang oras po ng impeachment court sa pagpapaliwanag. Naintindihan ko po ang posisyon ng aking kaibigan, si Senador Robin Padilla, yung kanya pong frustrations. Pero gusto ko lang po sana ipaalala sa ating presiding officer, sa ating pong Senate President, at matanong ano po ba ang ating ginagamit na rules ngayon? Pwede po ba yung mga problema po labas sa impeachment court na ito o labas sa kaso ng Vice President ay dadalhin natin dito? Di po ba ang korte na ito na itatag para po sana kay Vice President at kay Vice President lamang? Mga ebidensya, mga testimonya, mga pahayag patungkol lamang po sana sa impeachment ng Vice President. Kasi dito pong mga nagdaang araw, Mr. Presiding Officer, Senate President, mga kasama, napansin ko po na nagagamit ang oras po ng impeachment court sa pagtatanggol po ng mga nakaraang araw ng sarili, ng ilan sa mga kasamahan natin, sa mga akusasyon. This is not the right forum and the right venue and not the right time to explain your situation. Kung gusto po ninyong mag-eksplika ng inyong mga saloobin, problema, maaari naman po ninyong gawin yan sa labas po ng oras ng impeachment court. Maaari pong sa press conference, nandyan naman po ang Senate media. Anytime po, nandoon sila sa Senate briefing room, press briefing room. Maaari din po sa Facebook o sa YouTube magpaliwanag. Huwag po nating gamitin ang oras ng impeachment court sa pagpapaliwanag o sa pagtatanggol ng ating mga sarili simula pa po noong nakaraang linggo. Because the time we waste here to defend ourselves, defend what we believe or what have you, is an injustice to the Vice President. Yung oras po na ito dapat ilaan natin sa pakikinig sa depensa ng Vice Presidente, sa mga akusasyon laban sa Vice Presidente, hindi po pagdidepensa sa mga sarili natin kung tayo inaakusahan ng kung anong mga ahensya, kung tayo po ay may mga kaso, may mga investigasyon. This is not the right forum, Mr. Presiding Officer, Mr. President, Senate President. This is not the right place. This court was established, was created, the impeachment court, for the Vice President and Vice President only. This should be her time. This should be her forum, not our forum here, na ilabas natin ang saloobin natin, mga sagot natin sa mga akusasyon, mga kaso laban sa atin. And this is not also the time, Mr. President, Mr. Presiding Officer, na hanapin yung mga kasama nating nawawala, nakakulong, dapat po doon sa Senado natin, sa sesyon natin, and not here in this court, Mr. Presiding Officer, Mr. Senate President. Kaya pakiusap ko lamang po, sana, sa ating mahal na Presiding Officer and Senate President, let us follow the rules. May rules ho tayo. Kung hindi naman ho patungkol sa Vice President na sasabihin natin, hindi naman po patungkol sa depensa o prosekusyon ng Vice Presidente natin, then wag na ho natin payagan na magsalita pa po dito because nasasayang. Because every minute, every hour that we waste away from the defense or from the prosecution of the case of the Vice President, it is injustice. It is called injustice to the Vice President, to her family, yung anguish, yung kanyang sama ng loob, yung oras na nakabinbin ang kaso na ito. Let us do this impeachment trial as quickly as possible. If we have to clear the Vice President, then let's clear her. If we have to prosecute, then prosecute her with the evidence kung meron. Not waste our time kung ano-anong sinasabi natin dito to protect ourselves, to defend ourselves. This is not the right forum, Mr. Presiding Officer.
Kindly wind up,
Mr.
Senator
Senate
Judge
President.
Erwin Tulfo.
This is not the right forum for us to defend ourselves. Bring it somewhere else. Bring it to the press. Bring it to the social media, but not here. Thank you, Mr. President.
The remarks of the gentleman are noted. Earlier, Senator Judge Allen asked to be recognized. Are you yielding in favor of Senator Judge Padilla? And thereafter, Senator Judge Soto, thereafter, Senator Judge
Thank you,
Padilla,
Mr.
before the
Presiding
chair
Officer.
makes a ruling on the matter. Yes, Senator Judge Allen Cayetano is recognized.
Thank you. I'm happy.
You may proceed, sir.
I'm happy I finally heard Senator Judge Erwin Tulfo is concerned about the justice or injustice to Vice President Sara. That's good news. Regarding the waste of time here, sabi ni Senator Joker Arroyo, it is useless to argue a legal point with a non-lawyer. When Senator Marcoleta brought that up here, nagkaroon ng commotion. Senator Miriam stood up here many times and said, kaya ka nga nagpo 4 years na law school at nagbabar. So let me give my own interpretation. The impeachment court is formed with lawyers and non-lawyers. And we interact, and it's for everyone, and we're equal. But if there's an engineer here or a doctor, and they talk about medical principles, I have to either study and argue on medical principles. Hindi ko pwedeng sabihin, hindi, ganito lang yan, logic lang yan, etc. Diba? So, ang legal principle natin today is simple, integrity ng court. So, allow me to mention that to the people and help educate my colleague here. The integrity of the court and the justices or judges is always relevant. So if the Supreme Court or COMELEC, Court of Tax Appeals, Sandigan Bayan is being heard and the judges are being threatened, you give them time. So we cannot take the impeachment out of context. May nangyayaring flood control scandal, may nangyayaring gulo sa Team Unity na hindi na united ngayon. We consider Senator Marcoleta and Senator Jinggoy political prisoners, weaponized yung Blue Ribbon Committee at weaponized yung ano. So Mr. President, hindi tama na sabihin na I wasn't, after we brought up the problem with NBI, they doubled down, naggumawa pa ng task force. I mentioned 2 colleagues sa Salian, I didn't accuse them. Sabi ko lang, just like Vice President Sara, just because tumaas ang Salian, can we already ask for the BIR, for the AMLA and the bank accounts? So sabi ko, yan ang i-discuss namin sa Monday. Nag-react na, nag-accuse. I did not take up your accusations here today. Si Secretary Vince Dizon, 3 beses na nag-verify sa Taguig. Sinabi na 3 beses na walang ghost. Ngayon, i-verify ulit. I wasn't going to bring that up, but then i-question ninyo si Senator Padilla. It was all over the news na hindi niya inintindi or he snubbed the ombudsman. I was going to stand up before Senator Erwin stood up just to say, may registered mail. So nung una pa lang, 5 minutes si Senator Tulfo, so I'll take the 5 minutes also if you don't mind.
The gentleman may proceed and kindly be mindful of the time.
Yes, I will now. So I'm just saying, Senator Padilla just stood up to say, sumusunod siya sa batas, tapos. Kaya humaba to, dahil nga, hindi importante ata dito yung integrity ng judge. Lastly, kaya sinabi kong it's useless to argue a legal point. Ilang beses ko na narinig dito. It's our job to clear or prosecute the Vice President. Hindi po. It's our job to try and to decide. It's the prosecution's job to try to prosecute, and it's the defense job to convince us na wala. Our job is to try and to decide. And when you decide, you acquit or you convict. Why is that important? These are legal terms. Hindi pwedeng yung nanonood na law student ngayon sasabihin, trabaho pala ng judge to clear or to prosecute. Thank you, Mr. Presiding Officer, Mr. Senate President.
Thank you, Senator Judge Alan Cayetano. His remarks are noted. Senator Judge Soto, thereafter, Senator Judge Padilla, thereafter, the presiding officer shall make a ruling. You may proceed, sir. You have 2 minutes.
Yeah, thank you, Mr. President, the presiding officer. I do not have 4 years of law, but I have 29 years of lawmaking. And I move that the manifestations of that we have heard be referred to the Senate proper.
We will act on it at the proper time, Your Honor. Thank you. Your remarks are noted. Senator Judge Padilla is recognized. You may proceed, sir. You have 2 minutes.
Maraming salamat po, aming tagapamahalang hukom. Ito pong kasuotan natin sa mga oras na ito, hindi lamang po ito nire-represent ang impeachment ng ating pangalawang Pangulo. Ang nire-represent po nito ay ating karapatan bilang mga Pilipino at unang-una na ang due process. Ito po yun ang ibig sabihin. Kaya ikaw ay pangalawang Pangulo, ikaw ang Pangulo, ikaw ay Senator Judge, ikaw ay magsasaka, ikaw ay mangingisda, kailangan may due process. Yung pong nangyari sa akin, na ako po ay nahusgahan na kaagad bilang Senator Judge, ang Pinaglalaban po natin integridad ng korte na ito at ng mga senator judge. Kaya sana po wag nating kalimutan na ang bawat Pilipino ay may karapatan, lalong-lalo na sa usapin na ikaw, ako, sa oras na ito, ay senator judge. Yun lamang po, napakaiksi lang. Due process, mga mahal kong kaibigan, mga mahal kong kababayan, maging prosecution, maging defense, sa ating lahat, wag nating kalimutan, pantay-pantay tayo sa batas. Maraming salamat po.
Senator Judge Pangilinan, what is your pleasure, sir?
Yes, just a very quick manifestation, Mr. Presiding Officer. Earlier, former Senate President Soto moved that these matters be referred to the Senate. This is precedent, actually. During the Estrada impeachment trial, the father of Senator Cayetano Alan, Senator Rene Cayetano, made a manifestation regarding a case that was supposedly being prepared, a criminal case to be filed against him. It was raised in the impeachment court, but ultimately the impeachment court agreed that the manifestation was referred to the Senate as a legislative body. So there is precedent for this. Yes, the court allowed then Senator Rene Cayetano to make his manifestation, but eventually it was resolved that the matter be referred to the Senate as a legislative body. So we share. We move for the previous. Yes, we move. We call for the previous question, Mr. President.
Senator Judge Cayetano?
I think the presiding officer ruled that we will take it up later on, but if Senator Judge Pangilinan will insist, then I have to object on a point of order. Rule 6 says, the last part, the provisions of the rules of the Senate and the revised rules of court shall apply suppletory whenever applicable. And in the rules of the Senate, whenever the senator feels threatened or anything happens, whether pinatayan ng aircon, whether may nakatutok na barel or sinaran ng pinto, he can rise on a point of personal and collective privilege. We didn't do that para umikli. Now, if we're going to argue today rather than ask them about due process with a simple manifestation from Senator Padilla na hindi totoong binabastos o binabaliwala ang ombudsman, registered mail lang kaya hindi pa nadagdag, so, hindi kami ang nagwe-waste ng time. We can have a caucus, we can talk about it. You want to debate that now?
With the permission of Senator Judge Pangilinan, to abbreviate the proceedings.
May I just, Mr. President, because I was alluded to, Mr. President. May I just very quickly, Mr. President, Rule 6 on...
You may proceed, sir.
Thank you, Mr. President. Rule 6 of our impeachment rules, Mr. President, which was quoted by Senator Cayetano as being suppletory. Mr. President, that refers to evidence, rulings on evidence in the impeachment trial. It does not refer to privileged speeches. Therefore, the suppletory nature of the rules of court, as well as the Senate rules, refer to matters pertaining to evidence and no other, Mr. President. But in the spirit of liberality, we will allow that. That's precisely why we did not object when he spoke last week. But let us not abuse the liberality of this court, Mr. President.
With the permission of Senator Judge Tulfo Erwin, the chair will make a ruling because I believe it is also his position not to prolong this matter in discussing collateral matters not pertaining to the articles of impeachment that we are hearing and trying before the impeachment court. The chair rules that the manifestation of Senator Judge Padilla shall remain in the records. We cite as a precedent to the precedent mentioned by Senator Judge Pangilinan, where the speech of the late former Senator Rene Cayetano was not expunged from the record, but referred to the Senate as a legislative body where it may be taken up. I ask the indulgence of the parties to this case. Wala po kasi kaming sesyon. Ito lang po ang pagkakataong nakakapagsalita at nagkikita-kita kami habang recess kami. Pero umaasa ako, within hearing distance of my colleagues, na kapag ka nag-resume na po ang Senado sa susunod na linggo matapos ang sona ng Pangulo, may pagkakataon na po ang bawat miyembro ng Senado bilang senador, hindi bilang senator judge, na mailabas yung mga hinaing o anumang nais nilang sabihin kaugnay sa anumang nagaganap o nangyayaring hindi tama sa kanila o ginagawa laban sa kanila. And that, I think, is the proper forum for us to ventilate, discuss, look into, and if necessary, investigate the allegations and or accusations against senator judges in their capacity likewise as senators. So ordered. What is the pleasure of Senator Judge?
I will just manifest, I correct myself, it was stamped, not registered mail. And since I agree with the ruling, I will not anymore argue the
Thank you,
other
sir.
rule that correlates with Rule 6. Thank you.
Thank you, sir. Noted that it was stamped. The Senate President, thereafter, Senator Judge Erwin Tulfo.
Thank you, Mr. Presiding Officer.
Hopefully we can move on after the manifestations of the gentlemen.
Let me appreciate and thank the ruling of the presiding officer to refer the manifestations as well as the comments of our colleagues to the Senate acting as a legislative body. 8 days na lang po ay magko-convene na ang Senate at doon rin ho natin pag-uusapan itong mga mahalagang bagay na pag-usapan ho natin ngayon. At kanina po ay narinig ko po yung komento ng ating kasamaan si Senator Romy Padilla. At ito po yung mga bagay na dapat rin po nating talakayin pag nagbukas na po ang Senado in 1 week's time. So with the indulgence of our colleagues, importante ho yung oras ng trial sa mga darating na panahon. Nasabi ko nga nung mga ilang araw na mahaba pa yung ating dadaanan. Ito ay 7th day pa lang out of the 102 days na dadaanan ho natin. Kaya bawat oras, bawat segundo ay napakalaga. At nagpapasalamat po ako sa ating mga kasamahan dahil po sa kanilang masusing pag-participate ho dito sa ating impeachment. Pero dadating rin po tayo doon sa pagtatalakay nitong mahalagang issue pagbukas po ng Senado. Maraming salamat, Mr. Presiding Officer.
Senator Judge Erwin Tulfo, briefly, sir, so that we can proceed to the matter on hand.
Very quickly, Mr. Presiding Officer, can we start now, sir?
I was about to, sir.
Thank you, sir. We wasted 26 minutes for nothing. Thank you po.
Proceeding now to the matter on hand. The presiding officer already made the ruling, referring it to the Senate as a legislative body, Senator Judge Soto. Without expunging it from the records, let it remain there. We will now proceed on the matter at hand. We now resume consideration of the prosecution's requests for the issuance of subpoenas duces tecum number 1 for the banks and the Anti-Money Laundering Council on one hand, and to the Bureau of Internal Revenue on the other. And as previously agreed and discussed not only in caucus but also directly by the presiding officer with some members, Chair will now recognize, as I understand, Senator Judge... Ikaw ba una? Senator Judge Alan or Senator Judge Villanueva? Or Senator Judge Pia? Who would want... No one's raising their hand, that's why I don't know who... Senator Judge Villanueva is recognized. You may proceed, sir. Thereafter, Senator Judge Pia Cayetano. Thereafter, Senator Judge Alan Cayetano. You may proceed, sir.
Thank you, Mr. President. Thank you, Mr. Presiding Officer. As much as I am more than willing to give way to our dear colleagues. But Mr. President, before I make I inquire and pose some questions to the prosecution and the defense, may I also raise something, Mr. Presiding Officer? Gusto ko lang pong malinawan tungkol po dun sa procedural aspect, Ginoong Pangulo, dun sa motion na ito. Kasi sa regular courts, hindi naman po unusual na ang isa pong motion ay i-grant in part at i-deny in part. Depende po sa legal and factual basis ng bawat relief na hinihingi po, Ginoong Pangulo. So, pwede ko po bang malinawan lang, Mr. Presiding Officer, tama po bang sabihin ganun din yung kapangyarihan ng ating impeachment court? Maaari po ba na suriin ang bawat hinihinging sabina ng magkahiwalay at magpasya po batay sa legal at factual basis ng bawat isa sa halip po na tratuhin ang buong motion bilang isang all or nothing proposition?
Tatratuhin ng hukumang ito bilang nag-iisang motion ang tag-isang motion na inihain ng prosecution. They only filed 2 motions, Senator Judge Villanueva, and the court will act on these 2 motions separately, regardless of the number of issues or sub-issues underneath each motion. The reason is simple, because the court should be a passive body. By amending the motion into several parts and voting on it separately, we are essentially acting as if we were one of the parties. In voting for or against the grant of the motion, we should take into consideration all of the factors that may be raised for or against it. And it may be cited by the Senator Judge in explaining his vote or voting for or against it. Pangalawa po, bilang mga hukom, hindi tayo pwedeng masyadong aktibong makilahok sa paraan ng mga motion which is essentially a relief being asked for by a party sa pamamagitan ng paghahati ng mga motion na yan para pagbotohan ng hiwa-hiwalay. And there is precedent insofar as this position taken by the presiding officer is concerned. In the impeachment of the former Chief Justice, late former Chief Justice Corona, where then Senate President, Presiding Officer Enrile ruled that the ruling of the chair on motions are indivisible and may only be appealed in toto and not in part.
Thank you, Mr. Presiding Officer. And it's clear to me now, despite the fact, Mr. Presiding Officer, Your Honors, that if there would come a time na, for example, sa isang sabina, may sinasabina na sa asawa o sa korporasyon o korporasyon na hindi naman relevant at material doon sa kaso, yun lang po, Ginoong Pangulo, ang ating nagiging reservation tungkol po dito. Ngunit naging malinaw po sa akin na magiging isang desisyon lamang doon sa dalawang motion na inihain.
Tag-isang desisyon kada motion, pero pwede, gaya ng nasabi ng kagagalang-galang na hukom na senador, na pwedeng hindi ibigay yung lahat ng korteng ito. Pwedeng iba lamang, parte lamang, at hindi eksakto ng hiningi niya. Pero yun ang pagpapasyan na bilang isang nag-iisang motion.
Marami pong salamat. Naging mas malinaw po sa kinatawan na ito ang ruling ng ating presiding officer. May I start raising some questions, Mr. President, Mr. Presiding Officer, to the two parties, Mr. Presiding Officer, just for the guidance of the court, and I think it's important that we distinguish between two separate procedural questions. Una, kung dapat po bang i-produce ang hinihinging records, at pangalawa, kung ang mga records na iyon ay magiging admissible, at kung anong evidentiary weight ang dapat ibigay sa kanila. So let me start by asking our lead prosecutor, Congressman, to our dear Congressman, would it be correct, sir, to say that the issuance of a subpoena merely compels the production of records and does not by itself amount to a ruling that those records are admissible, relevant, or entitled to evidentiary weight, Your Honor?
Before the member of the panel for prosecutors answers, he's not the lead prosecutor. The question is addressed to the Honorable Representative Chel Jokno, who is a member who is part of the panel of prosecutors who will be answering your questions. And for the record too, on the part of the respondent, I think it's Attorney Poa who will be answering.
That's correct.
Thank
Your
you.
So that we don't need to identify each one each time anymore for the record.
Thank you.
The Honorable Jokno may respond to the question of Senator Judge Villanueva. You may proceed, sir, when you're ready.
Thank you, Your Honor. Good afternoon to all the members of this Honorable Court. Naisagot na po ata yan ni dating presiding Judge Juan Ponce Enrile dun po sa Corona impeachment case. And if I may quote just a brief portion from what he said, I would like to explain that the resolution of this court was simply to authorize the issuance of a subpoena. And whether those evidence subpoenaed are admissible evidence, given the fact that they apparently appeared in violation of existing laws, is a question that must be resolved in due course. So ang ibig po sabihin, ang hiling lang po ng prosecution ay may labas ang ebidensya, pero wala pa po tayo dun sa punto kung tatanggapin ba nitong hukuman ang evidence na yun, kung siya po ay admissible o hindi.
Maraming salamat po sa inyong tugon, Representative Jokno. Kaya po, nilahad ko po yan nang sa ganoon, maitanong po natin ang defense panel if that distinction is correct. Would the defense still maintain that the mere issuance of a subpoena is by itself already prejudicial to the respondent even before the court has ruled on admissibility or weight?
Yes, Your Honor. Good afternoon, Honorable Senator Judges. Yes, while we agree with the position of the prosecution na hindi pa naman pinag-uusapan ang admissibility sa puntong ito, what we are questioning is really yung subpoena mismo po. Dahil sa ating pananaw, ang isang subpoena, at hindi lang sa ating pananaw, but even under jurisprudence, meron pong requirements bago tayo makapag-issue ng subpoena para maging valid yung subpoena na yun. At yun po yung napag-usapan natin nung nakarang linggo na definiteness and relevance. Ngayon, yung twin requirements na yun para po sa pananaw ng depensa ay lacking in this case. And that is why we maintain our position as regards opposing itong request ng prosecution sa pag-issue ng subpoena.
Well, at least malinaw po, ang pag-issue ng subpoena, not necessarily opening of records, una. Pangalawa, to be presented in court. At pangatlo, to be admitted as evidence by this court. Before I go dun sa requirements, let me ask the panel of prosecutors, si Representative Jokno, dun po sa pananaw ng depensa on alleged fishing expedition, just for the guidance of Senator Judges, this representation would like to clarify one procedural matter. We understand that the concern raised by the defense that the subpoena may be overly broad. And at the same time, we also recognize that the court has a duty naman to determine whether the records being sought are sufficiently relevant and material to the issues before us. So, Representative Jokno, maaari po ba ninyong ipaliwanag kung paano ninyo tiniyak na ang hinihinging mga records ay hindi po simpleng paghahanap lamang ng posibleng ebidensya o tinatawag na fishing expedition, kundi ito po ay mga partikular na dokumento na sa tingin po ninyo ay meron pong malinaw at direktang kaugnayan dito po sa mga articles of impeachment.
Thank you, Your Honor. Ang hinihiling po namin sa mga subpoena ay kaugnay sa Article 2, which involves charges of unexplained wealth. Kung titingnan po natin yung mga jurisprudence pagdating sa unexplained wealth, klarong-klaro po na sinabi mismo ng Korte Suprema na kailangan makita yung buong larawan, hindi lamang po ng mga salin na final ng isang lingkod bayan, kung hindi lahat ng kanyang kinita, both what we would call lawful and, if there is, illegitimate income. Ang salin po kasi ay parang snapshot lang po yan, year-end, kung ano yung mga assets, liabilities, and net worth ng isang government official. Ang ITR din po ay parang short video lang po yan ng mga transaksyon ng isang taxpayer sa kabuuan ng taon na yon. makikita lang po natin yung buong larawan pag nailabas natin ang mga bank records. Kasi doon po, yung day-to-day na lumabas at pumasok sa isang account ay mabubuo po natin. And in fact, in the case of DOF RIPS versus Merencilia, ito lang pong portion ang babasahin ko. Sabing ganun ng Supreme Court, the failure of the complainant to take into consideration respondent Rafael's net worth from the time he entered government service and the failure to take into consideration all of his possible sources of income in relation to his real and personal properties do not support the conclusion that he has unexplained wealth, considering that his true net worth was not determined. Ito po ay sabi ng Supreme Court, Ombudsman, hindi nyo nagawa yung inyong trabaho. Kaya ayaw po namin tumulad sa nangyari kay Ombudsman dito sa kasong ito. We want to see the entire picture. Kaya po namin hinihingi yung BIR records, pati yung mga bank records, and even the Anti-Money Laundering Council records para makita po natin yung buong story as far as both the assets, liabilities, and net worth are concerned, and the lawful, and if there is unlawful income acquired by the respondent.
Last question no, sa prosecution. No? Sir, binanggit po kanina nung defense panel yung requirements which should be relevant and specific, and kinikilala po natin dito sa korte na yung subpoena is an important tool na available po dito sa impeachment court in the search for truth. Pero kinikilala din po natin na ang mga records na ating hinihingi ay may tinatawag na statutory protection under our laws. Now in this regard, Your Honor, bago po ninyo hiniling ang compulsory production ng mga confidential records na ito, may we know what led the prosecution to conclude that the issuance of subpoena is the least intrusive and most appropriate means of obtaining the information sought? In other words, Your Honor, paano po ninyo masasabi na itong subpoena is not only relevant but also necessary and proportionate under these circumstances?
Ang subpoena po ang tanging paraan para makuha ng initong hukuman ang mga kinakailangan po natin na datos at informasyon at dokumento. At hindi naman po siya intrusive dahil tulad na nabanggit ko po kanina, ay hindi pa naman ito question ng admissibility. Ang kailangan lang ay ma-produce sa korte yung mga dokumentong hinihingi. The issue of admissibility will come later and the defense will have sufficient opportunity to object and to oppose. Ngayon po, as far as the particular records that we are requesting are concerned, ito ay nakabatay nga sa nabanggit ko pong desisyon ng Supreme Court na pag tinitingnan natin ang issue ng unexplained wealth, hindi lang po pwedeng snapshot ang titingnan natin. Kailangan mula sa unang araw ng paglingkod ng isang lingkod bayan, yung kanyang final na salin, lahat ng mga kinita niya, ay makita natin. And that will be shown both by the bank records that we are requesting to be produced, as well as the BIR and tax records that we are requesting.
Thank you. Thank you very much. Sa depensa po, binanggit niyo ho kanina yung relevance, and if I recall it right, last week, the good gentleman, Attorney Powa, made mention about the questions on confidentiality, sir, no? And this representation would like to better understand the legal basis of the defense position on confidentiality. We recognize that the law places a premium on protecting confidential information. And at the same time, we are also dealing with a request made in the course of a constitutional proceeding before this impeachment court. At bilang mga senator judges, it's our constitutional duty to try and decide on impeachment cases. Mr. Defense Counsel, yung Section 8-A of the Anti-Money Laundering Act. Binanggit niyo po ito last time, which prohibits the disclosure of confidential information. How should this apply to records sought through a subpoena issued by the impeachment court? Because as I read, Your Honor, Section 8-A, it imposes confidentiality, but it does not expressly create an absolute privilege against the subpoena. There is a distinction between an authorized disclosure and production pursuant to a lawful order of a constitutional body. So, again, my question, Your Honor, where exactly in Section 8A does it say that AMLC may refuse a lawful subpoena from this court, Your Honor?
Thank you for that question, Your Honor. Unang-una, sagutin ko lang po yung pretense ng inyong tanong. No? Sabi nyo, this is a constitutional body, hindi po ba? And as we all know, there is an old legal maxim that the spring cannot rise over the source. No? Ibig sabihin po nun, while the impeachment court is a constitutional creation, it cannot go up over and above the Constitution itself. And when we talk about the impeachment court under Article 11, we cannot read that in isolation. We have to also give due regard for all other provisions of the Constitution, specifically the Bill of Rights, kung saan due process ay isang bagay na nakatatak po doon at pinapakita doon, ano bang ibig sabihin ng due process? Due process is, kasama po sa kalakip ng due process, ay ang bawat na nasasakdal ay meron ding pribilehiyo na maging maprotect o maproteksyonan ng mga batas na isinagawa ng mismong Kongreso. So now let's go on to Section 8A. No? As you can see, Your Honor, that is at least for our position, it's an absolute prohibition. Unlike other laws where they created, for example, in the bank secrecy law, meron nakasulat doon, aaminin natin, in cases of impeachment is an exception. Pagdating po dyan, wala po ni isang exception. It could have been easy, especially since this is a 2021 amendment. No? It could have been easy for Congress to have cited impeachment as an exception if it did actually wish to do so. But it did not, Your Honor. And it is our position that if we were to compel and issue a subpoena against these AMLAC records, we're actually compelling the officials to violate this very section of the law. And that is why we are saying na pagdating sa 8A, absolute po yan. It does not say that there's any exception if any court processes are actually issued to compel the production of these documents. Precisely because ang nasa loob po kasi ng mga records ng AMLAC are intelligence. No? And that's why it's confidential. And once AMLAC determines that they find out that certain transactions are subject to money laundering or should be actually filed in court, the end result is the complaint itself and not the raw data. And that is why, Your Honors, as to the raw data or the information that they receive, yan po ay strictly confidential under 8A.
Thank you for that. Again, I would like to put on record that I was trying to look at that particular section 8A, and I don't see anything that says this court would not have any prerogative as to whether or not we can subpoena bank records. But let me move forward. Perhaps this could be my last question, Your Honor, Mr. Presiding Officer. The Constitution recognizes two equally important principles: confidentiality on one hand, and the freedom of information, which promotes transparency and public accountability on the other. So, Attorney Powa, gusto ko lang pong malinawan for the benefit of this representation and our dear colleagues here, being senator judges, may legal distinction po ba between disclosure of information to the general public and the limited production of records solely to this impeachment court in the exercise of its constitutional function? because we understand that the principle of freedom of information is rooted in transparency and public accountability, especially po when the conduct of a public officer is under constitutional scrutiny. Now, if confidentiality is the concern, would you agree, Attorney Powa, that this impeachment court can impose safeguards on the use and disclosure of the records? Kung maaari naman po na magpatupad ang impeachment court ng sapat po na safeguards upang mapanatili ang confidentiality ng mga records, bakit po dapat maging hadlang ang confidentiality sa isang impeachment court upang suriin ang mga impormasyon na maaari nga pong may kinalaman sa mga isyung nararapat nitong resolbahin bilang isang impeachment court?
Para sa atin po, no, kung ano man pong hakbang ang pwede o hindi pwedeng gawin ng isang impeachment court tulad ng nasa harap natin na ngayon, it must be confined to the limits imposed by the Constitution and the laws. No? So kahit sabihin po natin, we are not against transparency. I just want to make that clear, Your Honors. We are not against accountability. But again, as I've mentioned last week, hindi naman porket po that we are all looking for accountability ay transparency, ay isasantabi na lang po natin kung ano ang mga karapatan, hindi lang para sa impeachable officer, pero para kahit sinong Pilipino na nakasaad sa batas, including absolute confidentiality in terms of AMLAC reports, which we are pointing to. So para po sa atin, nakikita ko yung punto po ng ating hukom, no, na paano kung mag-impose na lang tayo ng certain conditions. However, Your Honors, those certain conditions may be allowed for other records, pero pagdating sa AMLAC po, absolute po kasi yung prohibition. And if we were to amend or at least suspend the provision of 8A, then it is as if this honorable court is actually doing some sort of judicial legislation, no? Because we are technically suspending this law for a specific person na hindi natin pwedeng gawin sa iba. That is why, ang sa akin lang po, ang sa amin, sa punto ng depensa, is paano po yun? Meron po bang instances na papayagan na lang natin, isang tabi natin yung batas, at merong instances na hindi? I think, Your Honors, we feel, the defense feels, Your Honors, that in the search for truth, transparency, accountability, we must still work within a framework, which means that we must work within the limits imposed by the Constitution, the laws, and the rules of the land.
Salamat po, Attorney. Mr. Presiding Officer, just a few seconds, just to put on record, ang Senado po ay nasa plenaryo na po yung proposed Bright Act natin na maraming sumuportang mga kasamahan natin. And ito kasama po dito yung amendments to AMLA to put in black and white the circumstances under which bank records, financial transactions may be lawfully accessed by competent authorities, subject always, of course, Mr. President, to appropriate safeguards and due process. So gusto ko lang pong banggitin that indeed, confidentiality is an important legal protection, pero hindi din po ito dapat maging dahilan naman para manatiling mailap po ang pananagutan. Ang mabuting batas ay kayang pangalagaan ang privacy nang hindi po nasasakripisyo ang accountability. Our laws must be able to protect both, Mr. President, Mr. Presiding Officer. Maraming salamat po, Ginoong Pangulo. Maraming salamat po, our councils. Thank you.
Thank you, Senator Judge Villanueva. Your remarks and responses thereto are duly noted and entered into the records. Senator Judge Pia Cayetano is next, I believe. You may proceed, ma'am, when you're ready.
Hindi na ako
I'm ready to proceed, Mr. Presiding Officer. I'd like to to start this discussion with a question that hopefully will allow our kababayans who are watching, listening, to understand the situation. Of course, I pose it also to the parties. If the government had in mind that there's a business, and of course, a particular businessman or businesswoman who is violating a lot of laws pertaining to the operation of their business, be it customs law, BIR, regulations, can they just proceed and pwede ba silang basta na lang mag-request ng dokumento o mag-file ng kaso na requiring the businessman and the corporation to produce those documents? Pwede ba? So yun ang pag-isipan natin, no? Kasi yun ang tanong eh. Similarly, ginagawan ko lang ng ibang analogy para maintindihan ng mga kababayan natin. So this is the essence, dear colleagues, parties, of the principle of due process. This is ingrained in our Constitution. Totoo po na may karapatan ang gobyerno at obligasyon ng gobyernong patakbuhin ng maayos ang gobyerno, but it is always with due respect to the rights of every individual Filipino. That is the right to life, liberty, and property. So bago mo sagasaan yung right to life, liberty, and property, siguraduhin mo lang na may basehan ka. Yun lang naman ang sabi. So of course, ako, gusto ko talaga na maayos ang patakbo ng gobyerno para if somebody's life is also in danger, then government has to step up and prevent somebody's liberty. Kasi nga, sinasagasaan niya yung life and liberty ng ibang tao. So it's a balance, no? I think we can all agree it's a balance. So I want to go straight into a landmark case and I will ask both parties for their legal opinions on it kasi it is a legal proceeding. Pero gawin nyo lang simple para hindi masyado complicated para sa mga nakikinig sa atin. So in the landmark case of Stonehill versus Diokno, 1967 pa po to, karamihan ng mga lawyers hindi pa pinapanganak. The importance of due process was highlighted and the Supreme Court discussed 2 points. General warrants are void. Sabi ng Supreme Court, a warrant must be issued on probable cause for one specific offense and must particularly describe the thing being seized. So kailangan particular ang description dun sa warrant. Warrants that leave it to the discretion of the officers serving them to decide what to seize or general warrants are outlawed by the Constitution because they place the sanctity of the home and privacy at the mercy of prosecutors. So sinabi dito na kailangan specific. Take note warrant ito ha. So naman ang pinag-uusapan natin. Alam ko po yun. Pero I'm pointing it out kasi ang magiging tanong ko later on is kung relevant ito sa kaso. Okay? The other principle that was established in Stonehill versus Diokno was the exclusionary rule. Evidence obtained through an unconstitutional search is inadmissible for any purpose in any proceeding. Ito po yung tinatawag na the fruit of the poison tree. Pag nakuha mo yung information dun sa bawal na paraan, kung ano yung information mo, bawal ipakita yon. And this is where I need to get guidance from the presiding officer. If I'm allowed, I don't have to name names, to share the discussion that we had in caucus para lang mabanggit ko na ito yung mga provisions of law na napag-usapan. Am I allowed to do that? Would you like me to approach you? Please let me know because I will abide. Basically, because ang nangyari is we had our own discussion and I want to mention the provisions of law that we discussed. I don't have to mention names.
The lady may proceed.
Okay, thank you. So, tungkol dito sa exclusionary rule, ulitin ko, fruits of the poison tree, dun nga sa aming very open discussion, and I thank many of our colleagues who were I think we engaged in a fruitful discussion for some, not for all. I think yung iba talagang gustong makipag-debate at di-debate kasi gusto ko rin matuto, no? I think all of you will attest na I also wanted to learn from all of you kung anong perceptions nyo sa batas, kung ano din yung sinasabi ng mga abogado nyo. So dun sa fruits of the poison tree, sabi ko, kung yung pinanggalingan ng mga dokumento bawal na kunin ng basta-basta, then paano mo gagamitin? And meron kasing observation na lumabas na kasi yung documents na yon sa House. So nakita na ng publiko sa House. So sabi ko, pero if I will look at, and this is where I will pose the question to all of you, no? Medyo layered so pasensya na sa medyo complicated. Yung isang concern ng defense na nabasa ko is that hindi nag-allege ng ultimate facts. Hindi klaro kung ano yung naging kasalanan at hindi na-identify ng maayos itong facts na to that lead to a conclusion of law. So wala daw yun. Later on, I will ask both parties again to also clarify that. But the point is, kung walang basihan yung paglabas ng ebidensya na yon, it is the fruit of the poison tree, then you cannot use it. So yun yung importante dito kasi I'm sure nakita nyo na sa korte kahit sabihin nyo pong sa mga legal drama na na-throw out. The case is thrown out because na-violate ang due process. So that's the discussion I want to have. I want to hear both ha. Wala akong kinikilingan dito. I'm just explaining na yun yung argument ng defense na walang due process, kulang at why prosecution would you say na nasusunod yung due process. And before I give the floor to the parties, yung sinabi kong kaso na Stonehill versus Diokno, very interestingly, involves the esteemed father of our colleague, Congressman Prosecutor Chel Diokno. In the case of Stonehill versus Diokno, the father of Congressman Diokno was the Secretary of Justice. And in this case, the government, through the Secretary and other prosecutors, suspected that Harry Stonehill and his associates and several corporations that they controlled were violating central bank laws, tariff and customs laws, Internal Revenue Code, and the Revised Penal Code. So nag-request sila ng issuance of search warrant. At ang gusto nilang tingnan is books of accounts, financial records, vouchers, receipts, ledgers, etc., and other documents showing all the business transactions. Stonehill and the other petitioners filed a petition before the Supreme Court arguing that the search warrants were general warrants because they did not particularly describe the things to be seized. So, general pa pala yun. Books of accounts, financial records, receipts, general pa pala yun. And the Supreme Court ruled that indeed, general warrants are void. Warrants must be based on probable cause. Nasabi ko na yun, ano? And then the case also adopted the exclusionary rule, holding that evidence seized under an unconstitutional warrant is inadmissible. So, I now pose my questions. Applicable po ba ang kaso na ito, Hill versus Diokno, as far as the prosecution is concerned, and then also for the defense, applicable? Take note, I've read most of the pleadings, well, all of the pleadings, mahahaba sila. I kinda know your answer, but sa dami, I like to hear it again, and I think, of course, karamihan ng kababayan natin did not read it. So explain natin sa kanila, because this is a landmark case. Kung ikaw ay law student na magbabar, ito yung mga kasong titingnan mo. So malay mo, matanong yan sa bar. So nakatulong man lang tayo dun sa mga bar students na maliwanagan sila. Baka mamaya trick question to. Is it applicable or not? That is my question. I will sit down and then I will come back for my next. Thank you.
Thank you, Your Honor. If I may be recognized.
The member of the panel of prosecutors may proceed to give his answer. Thereafter, the counsel for respondent may do so as well.
Iba po ang konteksto ng search warrant na naging main issue sa Stonehill versus Diokno. Sa konteksto po natin na subpoena ang pinag-uusapan. Ang search warrant po, ang governing law po dyan ay nasa Bill of Rights natin, Article 3, Section 3. At kaya siya nandun dahil very invasive po ang search warrant. Pag ang isang judge ay nag-issue ng search warrant, pwedeng pasukin yung opisina o yung bahay ng person involved, pwedeng halongkatin yung lahat ng mga gamit niya doon sa kanyang opisina o sa kanyang bahay. Kaya po naglagay ng maraming limitasyon ang ating konstitusyon dahil marami ng pang-aabuso, marami ng mga halimbawa ng pang-aabuso na nangyari kahit noon pa. Iba po ang pinag-uusapan natin ngayon. Ang pinag-uusapan natin ngayon ay subpoena. Hindi po ito license to enter an office or to search any place. Ito po ay mismong humihiling lang ng mga dokumentong nakasulat sa loob ng subpoena. Therefore, the contexts are very different. When we speak of a search warrant, I do agree there should be very specific limitations on how that warrant can be enforced. Pagdating naman po sa subpoena, meron din po yan, but that is not governed by the Constitution. It's governed by Rule 21 of the Rules of Civil Procedure, which basically provide that for a subpoena to be valid, it must be relevant and it must be definite. Ibig po sa relevance ay may kinalaman na may kaugnayan yan sa mga kailangan patunayan ng mga facts. At pagdating naman sa definiteness ay klaro kung anong mga iba't ibang dokumento ang hinihingi. In our case, we respectfully submit, Your Honors, that we have met both the standards of relevance and materiality. The BIR records, the bank records, and the records of the Anti-Money Laundering Council are relevant to the facts in issue pertaining to the charges of unexplained wealth. Hindi po natin malalaman kung talagang merong unexplained wealth ang Vice President kung hindi natin mabubuksan yung kanyang mga bank records, kung hindi rin natin makikita at mailalatag ang anti-money laundering at BIR records po nila. And insofar as definiteness is concerned, we have specified the particular documents that we are requesting, and we have included as well an explanation of why those are important. Kaya sa aming pananaw po ay we have satisfied the requirements for a subpoena do sestecum. Thank you.
Mr. Presiding Officer, before we recognize the defense, just a quick follow-up question.
Hindi ko may lapit eh.
Bigyan ko ng time na bulungan muna siya ng kasama.
I'm sorry.
Okay na kayo? No, it's okay.
Senator Judge Pia, would you like the counsel for respondent to answer?
Not yet, Mr.
Not yet.
My
Okay.
request was if
Okay.
I'll just ask a follow-up question.
You may proceed,
Thank
ma'am.
you. Thank you for that. I appreciate his Honor's response. May I simply point out, and again, please give me your explanation. Tama ho yung pagkabanggit nyo na yung nature ng search warrant very invasionary, di ba? Because it requires that pasukin yung bahay, halugugin yung gamit. Pero hindi kaya invasive din yung paghalughog ng records? Is that not extremely parallel? I mean, is it not very similar in the sense that what is being questioned now are the very essence of somebody's savings, earnings. So, which we have to agree. I think there's no doubt that that is protected. But in fact, His Honor is saying that it would fall under the police power. So, imbis na papasukin mo sa bahay na nandun yung mga dokumento, you will do the same by asking these agencies, whether it is the BIR, the banks, or AMLA, to now reveal these documents. So that's my question. Is it in the prosecution's, is it the point of view of the prosecution na iba yun? Hindi ba invasive yun? Kayo gumamit ng word na invasionary, no, but I'll use invasive, I think. Yeah. Anyway, please answer, and then we'll give the floor to the defense, Mr. Presiding Officer.
Counsel for the panel for prosecutors may
Thank you, Your
answer as he pleases.
Yung pong search warrant, kung ano man ang makuhang ebidensya doon, ay direktang binibigay po yun sa court, and that is now considered as evidence by the court that issued the search warrant. Iba po ang subpoena, dahil pag naglabas ang isang hukuman ng subpoena, itong mga records ay hindi po siya considered yet as evidence. Yan po ay ipoproduce lang, dadalhin lang po sa korte, and now it is up to the parties, and I refer to both parties, to decide which of those documents may be relevant in terms of the evidence that they are need to present. Yung pong nakikita po natin sa subpoena, it is not in any way invasive because, as I mentioned earlier, as pointed out by Senator Enrile when he was the presiding officer in the Corona trial, we are simply having those documents produced. The admissibility of those documents will only be determined after if offered by the parties. Kaya po sa aming mga pananaw ay malaking-malaki ang pagkaiba ng search warrant sa subpoena.
Your Honor, may I be
With the permission of the lady Senator Judge, counsel for respondent may now give his answer to her query. You may proceed, sir.
Thank you, Your Honors. Your Honors, ang posisyon po ng depensa dito ay subpoena and a search warrant are very much similar in that both are compulsory processes. No? So, yes, hindi tayo papasok sa bahay ng isang tao o ng nasasakdal, but it will be intrusive because we will be opening up all the financial transactions for, sabi nga dito, almost 20 years of the respondent. Kaya po, katulad ng isang search warrant, the things that we are asking for through a subpoena must be particularly described. Kanina po, nabanggit po ng aking kagalang-galang na opposing counsel na particularly described na po yung kanilang naisulat. However, the defense does not agree with that proposition because if you look at it, tama naman po, nakasulat po dito ng hinihingi nila ay account opening and maintenance records, KYC documents, information files, signature cards, all account and transaction records, ledgers, journals. Basically, Your Honors, this is everything. Ibig sabihin, ni-specify lang nila ang nilalaman ng lahat ng bank records ng respondent. So in our view, Your Honors, while they took pains to specify each and every document, the truth of the matter is they're asking for everything. Ngayon, pagdating sa subpoena, and even in the case they cited, yung Rocco versus Contreras, no? Nakasulat po doon that for a subpoena to be validly issued, when we talk about particularly describing yung kung ano yung hinihingi, it has to be evidence that is both relevant and material. So ang tanong namin, saan ba dito yung relevant or material? Kasi lahat na po ng records hiningi eh. So, and this bolsters our theory, of course with all due respect to the opposing side, na kaya namin tinatawag o kaya namin natawag na fishing expedition ito. Kasi lahat na ng records hiningi, pero hindi naman matukoy which would actually be relevant, which would actually be evidentiary to the accusations they have made under the articles of impeachment. So, pero dito, hinihingi natin 20 years worth of records. And then, paano po yun? Hihimayin natin, maghahanap tayo ngayon kung may relevant o wala. Which brings me back to yung BIR records. Nakaseal po yung box. So I would say, both parties, hindi natin alam kung anong nasa loob nun. Yet, we're hoping na somehow, pag nabuksan yung box na yon, meron po tayong makikitang ebidensya. And that's why, again, with all due respect, we called it a fishing expedition. Kasi hindi naman na-identify kung ano mismo doon yung pwedeng ebidensya laban sa sinasabing unexplained wealth umano ng Vice Presidente. So, with the question, for us, yes, the Stonehill case, Stonehill versus Diokno, directly applies to the current proceedings. Kasi nga po doon, sinasabi talaga na dapat specified yung hiningi, particularly described and relevant. But as of this point, they're asking, Your Honors, for all of these things. And again, while they specified each and every document, kung babasahin niyo po ng mabuti ito, they're actually asking for all bank records without, in fact, telling us which transaction is relevant to their accusation, which transaction will actually support their accusation. Yun po yung aming pananaw dito sa tanong ng ating kagalang-galang na hukom. Thank you po.
If Your Honor, please may be allowed to respond.
Hold on, counsel for the panel of prosecutors. Senator Judge Pia is the one asking the questions. Unless it's not a debate between the two counsels. You're merely responding to answers from questions by senator judges.
I actually prefer not, pero alam mo na, baka sabihin naman na may bias tayo pag di ko naman pinayagan. Di payagan.
No,
I defer to...
Senator Judge Pia, you asked the question, they answered. It is not for the opposing counsel to answer points raised. They had that chance when they did their oral arguments, rebuttal and surrebuttal. You may proceed with your question, Senator Pia.
Sige, my question is, what is your question? Or what is your comment? Go ahead. But keep it brief. Keep it brief.
Thank you so much, Your Honor. I just wanted to point out that this is the first time actually an impeachment court is faced with the challenge of determining whether the charges of unexplained wealth are valid or not. And yung previous Corona case, hindi po pinayagan ng impeachment court yung Article 2.4 ng Article 2. At kung ang magiging batayan po natin ay yung naging mga desisyon ng ating Korte Suprema, sinabi mismo ng Supreme Court in several cases na pag ang usapin ay unexplained wealth, kailangan makita yung kabuuan ng kinita ng isang lingkod bayan at yung mga dineclare niya sa salen. Just to quote just a very short portion, sabi ng Supreme Court from the same case I cited earlier, the Ombudsman's failure to account for all lawful sources of income, including proceeds from business ventures and government benefits, further weakens the allegation that Rafael's wealth was unexplained. The incomplete assessment disregarded his accumulated assets over decades of public service, making it impossible to determine whether his property acquisitions exceed his legitimate financial capacity, end quote. Hindi lang naman po dito sa harapan nitong hukom na ginagawa yung pagtingin sa kabuuan ng isang lingkod bayan. The Supreme Court has done it in this case where they looked at decades of the financial records of the person charged with unexplained wealth, and it has also happened in the cases of Rabusa and Ligot, which were decided recently by the Honorable Court. Thank you.
Your Honor, may I at least be given just 1 minute to respond to that, Your Honors? But of course, I will submit to the pleasure.
Judge
Of course, I
Pia will,
yield.
guess,
Of course,
give
I
you
yield.
the same opportunity, I'm assuming.
Yes, Your Honors. Again, hindi ko po tinutuligsa o ino-oppose yung mga na-mention na case ng aking distinguished opposing counsel. However, those cases do not involve impeachment. And why is that relevant? Because in impeachment, as we have said, merong allegation ng unexplained wealth pero wala naman pong nakasuporta na mga documents para makita natin ano ba yung basis na naging aligasyon. Pangalawa po, again in impeachment, according to the case of Duterte versus House of Representatives, meron po tayong tinitingnan kung ano ba talaga ang impeachable offense. At yun po ay again, offenses or acts or omissions committed while the public officer is occupying the impeachable office and in relation to such office. That enough, Your Honors, is very clear under the decision. That is all, Your Honors.
Thank you, Counsel for Respondent. Senator Judge Pia, may proceed.
Mr. President, Mr. Presiding Officer, I'll go to my next point, but it will kind of overlap with this point as well, so bear with me. My next point, Mr. Presiding Officer and parties, is still on due process. This is the requirement that every pleading must allege ultimate facts and must not contain conclusions of law. So again, I'll start with an example. If, for example, if there's a case filed, no, and sabi, si Juan robbed the house of Mario. So para maintindihan ng mga kababayan natin, Juan robbed the house of Mario. That is a conclusion of fact. Nangyari na daw yun. And if there's another allegation that says, therefore Juan is guilty of robbery, that is a conclusion of law. So, again, I try my best not to be technical. It's in my, I would have wanted to be a teacher if not a lawyer, so I do like to be able to explain things well. So, ang hinahanap dito is, bakit mo, gusto mong patunayan yung facts mo? Yun yung kailangan sa ultimate facts. Kailangan mo patunayan, bakit mo sinasabing Juan robbed the house of Mario. Di sasabi mo, ang ultimate fact dyan example is si Juan ay nakita dun sa vicinity ng bahay ni Mario. Tapos ito si Mario, narinig na nagsisigaw na ninanakawan kami, whatever. Tapos yun, meron siyang testimonya na ano yung nawala sa kanila. Tapos may nakakita na kamukha ni Juan yung nandun. Tapos namukhaan nila, na-describe nila na 5 feet 10, medyo mapayat, ganon. So yun yung mga ultimate facts na later on sa evidence patutunayan. That's just very general, no? And then later on, para nga maputanayan yung robbery, i-allege ngayon yung elements of the crime that constitute robbery. So, nung di pa ako abogado, di ko naman alam ang difference ng robbery and theft. Yung robbery kasi qualified yan eh. So, pumasok siya sa bahay using violence. That's what makes it robbery. So, kailangan i-allege yun. Sorry to be a bit technical. Alam kong yan ang phrase of the day. Let's not be technical. Phrase of the week, phrase of the month. But we have to be able to explain these things in a way that people understand without forgetting that these are rights of the defense and rights of the person who is being tried here, and kailangan maliwanag yung ating mga accusations. So, my question now goes to both the prosecution and the defense. I know that the defense in their answer questions the failure of the complaint or the articles to allege ultimate facts, and therefore I think they filed the case before the Supreme Court. I'll give you your time to answer because I don't really recall that I heard it mentioned in the oral argument. So again, with the permission of the presiding officer, papasadahan ko lang naman na nabanggit ko yun na nandyan yan sa nandun sa memorandum, pero hindi ko naalalang, I'm just speaking naman for myself kung ano yung mga sinabi ko dun sa aming meeting, na hindi ko naalalang nabanggit. Baka naman nasabi, hindi ko lang naalalang na-emphasize kasi nga limited yung time. But I do recall that it's in the complaint, it's in the answer, and then it's also in the memorandum. So, pinupursue nyo pa ba ito? Kasi me as a judge, importante to kasi paano ba didepensa ng maayos kung hindi nga nag-a-allege ng ultimate facts that go into the case. And then, for the prosecution naman, may I ask you kung saan because bawal ho na tanungin ko for you to state your case. I cannot do that, no? But what I'm asking is if you can point out sa inyong articles kung saan dun yung allegations of ultimate facts. Kasi public document naman yan eh. Para lang maaral ko na asan dyan yung allegations nyo of ultimate facts. And this is where, before I pass on the floor to the parties to answer, I want to go into the principle of fishing expedition. Nagkataon na I came across the trial that we had for former Chief Justice Corona, and lumabas yung issue na yon. Nasabi ko, eksakto ito yung pinag-aaralan natin for today. Yung fishing expedition, and no less than the defense had to explain it in Filipino kasi sabi, baka hindi alam yung ibig sabihin ng fishing expedition, pangingisda ba daw yun? Parang hindi naman daw yun yung translation. No? Pero ito yung naghahagilap ka ng ebidensya kasi wala kang ebidensya. So I'll go back to a case and sama nyo to sa response nyo. Doon po sa kasong Afluencia versus Metrobank in 2014, humingi dito ang petitioner ng motion for issuance of subpoena ducis tecum ad testificandum at sinabing padala daw ng documents relative to their loan to Metrobank, as well as those covering extrajudicial foreclosure. Sabi ng Supreme Court, this is tantamount to building their whole case from the evidence of their opponent. Bawal daw yun. Hindi daw pwede na yung kaso mo, nakabase lang dun sa, sasabihin mo dun sa kabila, labas mo nga lahat ng meron ka dyan. No, your case has to be built. Yung evidence mo has to be there. So I will also ask both parties, is that jurisprudence relevant to this case for the prosecution and then also for the defense? And then let us also include a discussion on why this is or is not a fishing expedition. Yun nga, napaka-importante po kasi ito dahil it is ingrained in a complaint na yung allegations mo ng ultimate facts, mapoprove mo ngayon yon with the evidence. Hindi pwede na wala kang ebidensya, hihingin mo lang ng hihingin by way of subpoena. Clear po yun sa batas. Kaya nga gusto kong ipaliwanag nyo sa akin, educate me why this applies, why this is not a fishing expedition, why the case I cited does not apply, because I assume that's the position of the prosecution. And then for the defense, ano naman po yung position nyo? Salamat.
The counsel for respondent will give his answer first with respect to the question of Senator Judge Pia on ultimate facts as well as on fishing expedition. Thereafter, counsel for the panel of prosecutors. You may proceed, sir, when you're ready.
Thank you, Your Honor. Pagdating po doon sa sinasabi namin na lack of ultimate facts, no? Ito po yung nagsimula pa lang doon sa Committee on Justice when the impeachment complaints were filed. Because the allegation, and I'll stick just with this, I believe, Article 2. No? Pagdating po kasi doon, there was an allegation of unexplained wealth. Pero wala pong nakasulat kung saan nila nakuha, ano yung basehan ng unexplained wealth na yon. Ano yung act na ginawa ng Vice Presidente, kailan yon ginawa. At so sa amin, para masabi nilang nagkaroon ng unexplained wealth. Ang basic, if I may remember, was really just the fact na yung SALN niya ay lumaki from 2007 to 2025, which sa aming palagay does not show any factual allegation whatsoever, except for the fact that it grew bigger over a span of 20 years. Pangalawa, wala rin pong naka-attach, which I mentioned in the oral arguments last week, na kahit anong ebidensya or kahit supporting document man lang, huwag na nating tawaging ebidensya, supporting document that will support any allegation whatsoever of unexplained wealth. And that is why, nabanggit ko rin, na after the allegations were made, and this is even more significant, after the respondent had filed her answer, na tinawag pa nga nilang non-answer, doon lang po naghanap ng mga ebidensya na sakaling makasuporta doon sa aligasyon na iyon. That's very important for us because we had already filed our answer before AMLAC documents were suddenly produced with the issuance of subpoenas, before the BIR box were concerned, that we are concerning ourselves with was presented before the Committee on Justice. Nasa panahon na yun, tapos na po kami sumagot. In fact, when they were saying that it was a non-answer, to be very candid with everyone, we wanted to say because it was a non-complaint. Kasi walang ultimate facts na naka-allege for us to even answer. Now, before this honorable court, I do recall that in our answer, we also took pains to discuss the lack of ultimate facts and also what we feel were violations of due process before the Committee on Justice, or at least with the proceedings that were conducted before the Committee on Justice. And that is also why we have a pending motion for exclusion na ikinalakip namin dun sa answer precisely because we were objecting to the fact that these pieces of evidence were produced after we had already filed our answer. Now, on the fishing expedition, I think on the fishing expedition, Your Honors, our main point is this. Even if we read the twin requests for subpoenas, ulit-ulit po, nakasulat po doon, because this may show context, because this may show, prove something. At para sa atin, this only shows, and at least, again, on the part of the defense, this is somewhat already an admission na hindi pa nga nila alam kung ano mismo doon sa mga hinihingi nila ang pwedeng sumuporta sa mga aligasyon na unexplained wealth. And that's why, if you read the entire request, it uses the word may several times, and it even says in one paragraph, I think it's 3.24, but I might be mistaken, that at least with the request for, with their memorandum, rather, in their memorandum, nakasulat po doon that this does not assume wrongdoing, but they want those documents nonetheless to see if something there will actually help support their allegations. That is why we are calling it a fishing expedition. Dahil in Tagalog, para po maintindihan, sa aming pananaw, sa dami ng hinihing dokumento, para po itong nagtatapon po tayo sa dagat ng isang napakalaking lambat at umaasa tayo na kahit papano may mabingwit kahit isang pirasong ebidensya. Maraming salamat po.
Counsel for the panel of prosecutors, the Honorable Jokno.
Thank you, Your Honors. The question propounded to this representation first is, what are the ultimate facts alleged in the articles of impeachment? Yun po ay nakasaad sa page 7 of the articles. And if I may be allowed to just read them briefly.
You may do so, Counsel.
Thank you, Your Honor. Respondent Vice President Sara Duterte committed culpable violation of the Constitution and betrayed the public trust when she, A, amassed unexplained wealth manifestly disproportionate to her lawful income and earnings during her incumbency as a public official. B, failed to fully and truthfully disclose all her and her spouse's assets, liabilities, and net worth in her statement of assets, liabilities, and net worth, including in her salents for the years 2022, 2023, and 2024. And C, failed to divest and instead willfully continued all her business interests during her tenure as Vice President for the years 2022, 2023, 2024, and 2025. Please allow me to briefly explain why these are ultimate facts. Ultimate facts are basically the essential factual elements that make up a party's cause of action or defense. Halimbawa po, pag murder, treachery, evident premeditation, lahat ng mga kinakailangan ng batas para mapatunayan na murder po siya. In our case, we are alleging, first of all, unexplained wealth. And based on the jurisprudence, the elements of unexplained wealth, the factual elements are amassing unexplained wealth, manifestly disproportionate to one's lawful income and earnings during one's incumbency as a public official. So, nasatisfy po namin yung requirement na pag-allege ng ultimate facts or essential factual elements sa tatlong bagay na po ito. The evidentiary facts follow in the succeeding pages of the articles. Doon po namin dinitalye kung ano yung mga iba't ibang paraan kung paano nakuha o naamas ni Vice President yung ang sinasabi natin na unexplained wealth. On to the issue of fishing expedition. Yung pong fishing expedition po ay halimbawa may sabina na baka sakali meron tayong makita. Yun po ang ibig sabihin ng fishing expedition. When the party requesting information does not know what might be produced and just as an off chance tries to use that instrument in order to gain evidence that may be used against the other party. Dito po, malaki ang pagkaiba ng sitwasyon. Maalala po ninyo, during the hearings before the Committee on Justice, the Executive Director of the Anti-Money Laundering Council testified and produced documents showing that from 2007 up to the present, 6.7 billion pesos ang dumaan po sa account ni Vice President Sara Duterte. On that basis, and if we go deeper into that report, it says that during the period from 2007 to 2013, during the time that she served as mayor and vice mayor, umabot po sa halos o lampas 3 bilyong piso ang dumaan sa kanyang mga accounts. So may basehan po tayo para ipalabas ang bank records. We are not just guessing that there is something there because the AMLA itself has confirmed that there were covered and suspicious transaction reports submitted to them in those amounts that I mentioned. Malayo po ang fishing expedition sa ginagawa ng prosecution dito po. If we had no basis at all, if we did not know what was in the AMLA reports, ayun po, maaring sabihin na fishing expedition. But in this particular case, we know, because these are matters of record presented before the Committee on Justice. Second po, ang fishing expedition, maaring magamit yan sa ibang mga alegasyon tulad ng baka meron kang hindi na-declare sa iyong SALN. But when it comes to issues of unexplained wealth, it's very clear. The decisions of the court are very clear. To know whether a government official has amassed unexplained wealth, we must look at the entire incumbency of that official. Starting from day one, we look at their SALN, we look at all the income that he or she has earned, both lawful and not, and from there we make a determination whether there was unexplained wealth or not. For these reasons, Your Honors, the fishing expedition argument, in our view, is totally untenable.
Senator Judge Pia, do you have further questions?
It's actually just a follow-up to what the prosecution, how the prosecution responded. I think Senator Alan Peter will go into it, but since this is my line of questioning, I'll follow up lang on this point. No, His Honor, I earlier mentioned the fruit of the poison tree doctrine. And ulitin ko, pagka yung pinanggalingan ng information nyo, bawal, hindi nyo na pwedeng gamitin yon. So, His Honor said, I'm referring to Congressman Prosecutor Chel Jokno, they know the contents of the AMNA report, something to that effect, because it was presented in the impeachment hearing in the House. That is correct, right? That is your statement?
Yes, Your Honor.
Yes, oo. And I asked my question, and again, I will give both parties the opportunity to respond. Ano yung basihan na i-reveal ng AMLC and their representatives sa inyo in the impeachment hearing in the House? Because ang nakasaad sa law, I don't even want to use my understanding of the law because it's what is read in the law. And I won't take up the time of this court na isa-isahin ko yun, pero nakasulat doon na confidential ito. So, ano yung basis na mailabas yun doon sa impeachment court? Because, and since the presiding officer has given me the permission to share in general the discussion in our caucus last week, isa dun sa napag-usapan namin precisely was yung information na lumabas doon. Kung yan ay walang basihan na ilabas, walang legal basis na ilabas yung information, hindi yan pwedeng idugtong dun sa mga allegations na meron kayo. So that's my question. During our caucus, isa din sa lumabas na discussion, pero allowed ang AMLC and the specific officers to share that information. But the specific provision of the law, and please, both counsels, please respond, please elaborate on how this supports or does not support your case. A specific provision dun sa batas, yung sharing of information na yun, sabi, oy, kayo AMLC Council, mag-develop kayo ng rules kung paano kayo makakapag-properly share sa agencies. I believe, and again, you feel free to elaborate on this or correct me, that's referring to the bank institutions, the AMLC hierarchy, and the agencies they deal with, not in court, because ulitin ko, nakasulat doon, confidential. So, I will leave this here, that if it is confidential, it does not allow that this be divulged in the manner it was divulged. Then how do you use that? Because that is precisely the doctrine of the fruit of the poison tree. Please take your time to tell us why That information is not the fruit of the poison tree, and obviously for the side of the defense, they will tell us why they believe that it is the product of the fruit of the poison tree. Thank you, Mr. President.
Counsel for the panel of prosecutors will please respond.
Your Honor, Section 8A of the Anti-Money Laundering Law is really intended to prohibit or prevent leaks by officials of the Anti-Money Laundering Council. But it was never intended to prevent subpoenas coming from courts, including the impeachment court. Almost every week, the Sandigan Bayan issues subpoenas for AMLA records. And despite what would appear to be a very categorical prohibition contained in that section, every time subpoenas are issued by the Sandigan Bayan, they are honored by the AMLA and no one is questioning them. Ganon din po itong impeachment court. The subpoena issued by this impeachment court is for the purpose of determining accountability based on the power that is expressly given by the Constitution. Ang aming pong paniwala is that confidentiality cannot trump accountability. Thank you.
Counsel for respondent. May you reply.
Thank you, Your Honor. I cannot verify if indeed the Sandigan Bayan, as mentioned by opposing counsel, issues subpoenas against AMLAC every week. So that I will not comment on because I cannot verify that. What is clear to us, Your Honors, as we have demonstrated last week, is that 8A is an absolute prohibition. And again, this was the latest amendment of the law back in 2021. And for us, Your Honors, that is why when this was presented, the House Committee on Justice, we had our objections to such matter. And in fact, Your Honors, it is the subject of our petition, the Supreme Court, and aside from that, a subject of our motion for exclusion before this Honorable Court. Ngayon po, sa atin, talagang yung tinutumbok natin is it is in fact within the fruit of the poisonous tree. In fact, I'm surprised, Your Honors, because, Your Honors, nabanggit na rin po ng aking distinguished opposing counsel na nakita na nila, may records na sila. In fact, if I'm not mistaken, it was also attached to the articles of impeachment. So kung meron na pala, bakit pa nila pinapasapina ngayon sa impeachment court? Is it because, I don't want to speculate, maybe I just won't go there. But ang sa akin lang po is, we have questioned this all throughout. No? Why? Because to us, unang-una, bawal siya. Pangalawa, hindi siya relevant. Bakit hindi siya relevant? Your Honors, transactions do not equate to wealth. Transactions do not equate to net worth. Especially if tinatali natin siya sa SALN. Because transactions happen over the course of the year, and in this case, years. Well, when you talk about SALN, we talk about net worth on a specific date in time, which is December 31 of every year. So sa atin po, ang aming pananaw dito ay hindi po relevant at hindi po, it will not directly show anything about wealth. Kasi, again, AMLAC transactions do not equate to net worth of a certain person. And that is why, Your Honors, we have opposed this. And we have opposed this since the time it was being presented at the House level. Thank you, Your Honors.
Just for the record and for the information of the Senator Judges, I'm not sure about the Sandigan Bayan issuing a subpoena every week as well against AMLAC. But I'm well aware, the court is well aware of cases decided by the Supreme Court precisely on subpoenas issued by the Sandigan Bayan vis-a-vis the AMLC. Senator Judge Pia, can you wind up? You're done? At this juncture, Chair will now recognize Senator Judge Alan Cayetano for his interjection and questions. You may proceed, sir, when you're ready.
Before I ask question, Mr. Presiding Officer, may I thank you, the Senate President Win Gatchalian, former Senate President Tito Soto, and the whole court, because in our caucus, you did three things. One, you allowed us to have the weekend to review all of the laws so that we can ask more intelligent questions. Two, you allowed to hear the discussions, mostly by Senator Pia, Senator Pangilinan, Senator Lacson, and former Senator Soto. And then number three, we discussed how a complex, or what word did you use a while ago, Mr. Presiding Officer, that it's two motions, but there are
There may be issues underneath. Or
issues and
underneath.
sub-issues. So that after we ask questions and after you make a ruling, we'll, instead of asking for a division of the House just in case we do not agree, I'll make a manifestation, and then if others agree on how we can manifest or submit in writing in what parts of the ruling we agree or disagree for the record. May I proceed, Mr.
Duly
President?
noted, Your Honor. You may proceed, sir.
Good afternoon, Attorney Jokno and Attorney Poa.
Afternoon.
Yeah. So I really want to be enlightened. I have no illusion na magkakasundo yung dalawang side today because you have the eloquent Attorney Jokno on one side and the eloquent no joke on the other side. So sa pangalan pa lang baliktad na. But I think the discussions are very important. And I do appreciate your opening, Congressman Jokno. I appreciate your oral arguments because I've been pondering these questions. What if, hindi ko na sabihin this administration, let's say in future administrations, this exact thing happens, 5 years, 3 years, 10 years, iba ang SALN, iba yung income ng COA chairman or ng ombudsman. Ombudsman files cases, many, mukhang maraming congressman makakasuhan ngayon. So, very, very much relevant yung ating pinag-uusapan ngayon. So, just in the spirit of liberality, same kay Senator Pia, after one answers, if one wants to make a quick rebuttal, I'll ask you the question, but let's try to be concise. So, Counsel, may I ask, let's start with the case of Duterte versus House of Representatives. Thank you for reminding us about certain precedents and how I voted last time. But you would agree, di ba, that when you have legal proceedings, even in legislation, you follow what the latest law is. So, for example, if you're allowed to issue a general warrant before Stonehill versus Jokno, but after Stonehill versus Jokno, so if before Stonehill versus Jokno, walang doctrine of the fruit of the poisonous tree, then some policemen will still submit evidence that was illegally acquired. But after that, we have to follow. So you did make your point about obiter dictum. I'll go to that. But I just want to start out by saying the fact is there is a Duterte versus House of Representatives. So with your permission, let's start discussing that. So this case of Duterte versus House of Representatives came out after the impeachment of CJ Corona, correct?
Yes, Your Honor.
And the two elements was discussed in this case. The act charge must be impeachable under Article 11, Paragraph 2 of the Constitution, and 2, the act committed must be committed during the term of the impeachable officer. You commented on that. Can you elaborate or give your stand regarding, I think you agree with letter A, right? That the charge must be an impeachable offense. I mean, we all agree on that, right?
Well, I would distinguish, Your Honor, please, between what we would call ratio decidendi, or the rule in that particular case, and obiter dicta, which are side comments or incidental remarks made in the opinion of the court. If we are speaking of the ratio decidendi of the Duterte versus House of Representatives case, I would have to disagree that it relates to the statements that you mentioned. My understanding of that case is it really relates to the first mode of impeachment and the procedures that must be followed, the one-year ban provided in the Constitution, how that will be applied when impeachment complaints are filed by at least 1/3 of the members of the House of Representatives. Yung pong nabanggit nila that the basis of any charge must relate to the incumbency of the official, in my view, that is obiter dicta, not necessary
I
for the
appreciate your
decision of
answer.
the
We'll go
case.
to that. But regardless of the Duterte versus House of Representative ruling, we do agree with letter A. The act charge must be an impeachable offense under Article 11(2) of the Constitution.
I would agree, but if
Yes.
I may be allowed to just qualify
No, this is just a
that.
general. This is not a trap question. So,
No, Your
diba, so the officer has to be impeachable, and the acts charge should be an impeachable offense. And since you have betrayal of public trust, that's quite broad. No? So this is not a trap question. This is just laying the basis. But go ahead if you want to comment on that.
Yes, the acts charged must constitute an impeachable offense, and that power to decide what is an impeachable offense is lodged exclusively with this honorable court.
Okay. So, you disagree that part of the ratio decidendi is the act must be committed during the term of the impeachable officer. Thank you for bringing it up now, because I think all throughout the trial, especially in the articles where we will bring up acts before 2022, this discussion will be relevant, no? So, by discussing this, it will pass upon the whether or not including proof like bank records, financial documents, before her term can be inquired into. The prosecution says it cannot, right? Because you believe it's an obiter dictum. I'm just restating. You can say it in your words. You believe that the statement that the act must be committed during the term of the impeachable officer is not the law of the land. It's an obiter dictum.
In the first place, if Your Honor, please, that was not the exact statement of the court.
Okay.
The court said the basis of the charge must relate to the incumbency of the impeachable official,
Yes.
which does not rule out the presentation of evidence of acts or omissions that occurred before the person became an
So
impeachable
let's
officer.
take the judicial notice of the, as you said more eloquently and correctly, that the acts, no, during her term. So can you define, you defined this in your opening statement, but for the sake of this discussion, an obiter dictum is what?
It's a side comment, Your Honor, that is not necessary for the resolution of that case.
Yeah, and I agree with that, and it's a remark made or opinion expressed by a judge in a decision upon a cause, or it's a by the way, that is incidentally or collaterally and not directly upon the question before him, or upon a point not necessarily involved in the determination of the cause, or introduced by way of illustration, analogy, or argument such are not binding precedents. No? Just for the public and for all of us, di ba?
Yes,
so
sir.
ang sinasabi, yes, there can be a Supreme Court decision, but that part could be an obiter dictum, meaning hindi yan yung doktrina that will bind us in making decisions, whether it's issuing the subpoena or admissibility. But are you aware of the Villanueva versus Court of Appeals, GR 142947, March 19, 2002. I won't take it against both of you if you do not. There are thousands of cases. It talks about what is obiter dictum. Have you passed about on this, both counsels?
For me, Your Honor.
Yeah, so the prosecution characterization of the requirement that the basis of the charge must be for impeachable acts or omissions committed in relation to their office during the current term of the impeachable officer as an obiter dictum. But in the Court of Appeals, in Villanueva versus Court of Appeals, in that case, the Supreme Court held an adjudication on any point within the issues presented by the case cannot be considered an obiter dictum, even where the point is only incidentally involved. So we agree if it's incidental, pwedeng obiter, but if it's on point within the issues, sabi ng Villanueva case, it is not. So long as it is presented and decided in the regular course of the consideration of the case and led up to the final conclusion, or is a statement as to the matter of which the decision is predicated. The court added that a point expressly decided does not lose its value as a precedent because the disposition of the case is or might have been made on some other ground, and that where a court decides several points, none of such points can be regarded as having the status of a dictum. And one point should not be denied authority merely because another point was and more dwelt on and more fully argued and considered. So going back to the Duterte versus House of Representatives, the requirement that an impeachable act be committed in relation to their office and during the current term was not a remark made by the way. The Supreme Court en banc laid it down as one of the enumerated principles that due process requires, which is the very ground on which the ruling was predicated. even if the court also struck down the 2025 impeachment complaint based on the one-year bar, so this is the question, does it not render the due process requirement laid out as a mere obiter dicta, or because it's based on due process, regardless of the mode of initiation, regardless of the mode of how the articles of impeachment got here, isn't due process still a requirement?
If I may be recognized,
Yes.
Your Honor.
Counsel for the panel of prosecutors may respond.
Precisely, Your Honor. If a matter is within the issues resolved by the court, then it may not be considered as obiter dicta. But if we look at the decision in the case of Duterte versus House of Representatives, ang mismong nangyari po doon ay may naunang dalawang complaints that were endorsed at may sumunod na complaint filed by at least one-third of the members of the House. At yun yung tinutukan po ng ating Supreme Court. It was in that context that the Supreme Court made pronouncements about the one-year bar and even about due process. At no time in that case was it ever a fact in issue about the mode of impeachment that is involved in our case today. Ang pinag-uusapan po natin dito ay individual complaints that were then referred by the House to the Committee on Justice, heard by the committee, and then brought back to the plenary, and eventually umabot po dito through articles of impeachment. So kahit may sinabi ang Supreme Court about impeachable offenses in relation to the charges, kami po ay naniniwala na hindi po yan pumapasok o sumasakop sa issues that were decided in that case.
I'll not argue with you because that's not my job here. I'll follow the Pia Cayetano style and move to the defense. But just a follow-up question on that. So I respect your belief on that. But my point is, the legal principle of due process applied to that mode, is it not logical that it's the same legal principle on due process even if you use another mode?
First of all, if Your Honors, please, when we speak of due process, of course, there are two types, substantive and procedural due process. And when we speak of substantive, we're talking about protections to life, liberty, and property. Wala naman pong ganun na issue po dito sa atin because office is not a property. We're not talking about the life or liberty of the respondent. Ang pinag-uusapan po natin dito kung due process ang issue ay simply fundamental fairness. And I do believe that this proceeding does require fundamental fairness, but at the same time, it does not require that this court be hamstrung in terms of how to decide whether an offense is impeachable or not. That power is exclusively given to this court at dapat kayo lang po ang magdesisyon at magpasya kung ano nga ba yan. So when we speak of what is an impeachable offense, may kaugnayan po yan doon sa nabanggit ninyong the basis of the charge must relate to the incumbency because in our view, that is really something that each member of this honorable court will have to decide when the time comes.
Yeah, later on, I'll ask you that question, whether or not, what, if ever, can the Supreme Court decide or what of their pronouncements will be applicable to this court and that. But my point is, if we're saying that pag ang mode of initiation is by one-third na pumirma diretso at ang nakalagay doon committed in relation to their office during the current term, wouldn't it be illogical if you use another mode and pwedeng hindi committed in relation to their office and during their current term? I don't think the Supreme Court would be illogical in saying this is the principle for due process in this mode but not in this other mode.
Even if we assume, Your Honor, that that is not obiter, the statement that the basis of the charge must relate to the incumbency of the impeachable officer, we submit that that still applies and we have satisfied that test.
Okay.
As I mentioned in my opening statement, integrity cannot be divided. Hindi po pwedeng biyakin ang integridad.
So on that point, so if a president, an ombudsman, a COA chair who's let's say 60 years old but he started in government at 20 years old, he can be impeached by something he's done when he was 20 to 30, not only on what he's done when he was already an impeachable officer?
if we are speaking about unexplained wealth, Your Honor, I have repeatedly cited the cases of the Supreme Court that provide that we must look from the reckoning of the first day of service of that public official, look at all the income that person has amassed, and determine whether it is manifestly disproportionate to the lawful income that he has reported.
Yes, I agree in terms of holding that person liable and accountable. But what I'm saying is that, let's say he was a counselor, then he was a customs director, then he was BAR, then he's now COA. Isn't the remedy for all his other positions that weren't impeachable is through the regular courts and regular case build-up, etc. But once you're an impeachable officer, you're being held accountable during the term that you are, in fact, an impeachable officer, because usually when you're an impeachable officer, it's too hard to prosecute you the normal way. Isn't that the logic there, or you disagree, counsel?
I would have to respectfully disagree. Ang pinag-uusapan po natin kasi dito ay betrayal of public trust. And I think it's very clear that when we speak of betrayal of public trust, essentially we are looking at whether the public official is fit or unfit to continue in service. Kung siya po ay nakapag-amass ng unexplained wealth, nung siya ay vice mayor o mayor na umaabot sa bilyon-bilyones, I think that would have a very big impact on the court's decision whether that person should continue in office or whether they are fit to have that office.
Okay, as I said,
With the permission of Senator Judge Alan Cayetano, with your indulgence, sir, a request was conveyed to the presiding officer to declare a very brief break. This is not a break for all of us, but a very brief break of 5 minutes so that council may answer to the call of nature. That was the message conveyed to the presiding officer, including Senator Judge Cayetano. So Chair declares a 5-minute break. We shall resume at 4:05. Resumed. We shall resume the interventions of Senator Judge Alan Cayetano pertaining to the issue at hand on the twin requests for subpoena by the prosecution. You may proceed, Senator Judge Alan, when you're ready.
Sir, Presiding Officer, if I may start there, no, whether or not the defense, although they stated already in their opening statement, considers such statement in the Duterte case as obiter dictum, and I'd like to reiterate, it's very important that we all understand and come to our own conclusions, because many, many times during this trial, and even in the decision we'll have to make, this question will play a center, will be front and center. So may I ask Attorney Poa, do you think that statement was a obiter dictum?
As stated, Your Honors, thank you for the question. As stated last week, Your Honors, it is our position of the defense that that is not obiter dictum, precisely because, Your Honors, it is our theory that when the Supreme Court decided the case of Duterte versus HOR, the point that the one-year bar was triggered is precisely because there was a violation of due process. That's why, if you read the decision, Supreme Court, through the words of course, Senior Associate Justice Marvic Leonen, painstakingly discussed what due process is actually in an impeachment proceeding. And in fact, there was a line in that decision that says that they wanted to clarify the guidelines on impeachment proceedings. Further to that, Your Honor, hindi lang po sa decision, pero pati po doon sa binibigay na primer or summary ng Supreme Court bago nila ilabas yung buong decision, they enumerated the guidelines, which were around 7 points, if I'm not mistaken. And the 6th point is actually on what is an impeachable offense. And in fact, we have prepared copies of that primer for the senator judges, which we can distribute, so that makita po nyo na while ang effect ay na-trigger yung one-year bar, it was really due process that the Supreme Court was discussing in that case to guide. Yes.
Commission Counsel for Respondent, kindly submit that to the Clerk of Court.
Yes, Your Honor.
Thank you. You may proceed, sir.
So, while as I was saying, Your Honors, while yung ang end result is na-trigger yung one-year bar, and that's why void yung naging first round of impeachment, ang talagang pinag-uusapan ng Supreme Court dito is the observance of due process in every stage of the proceeding. And that is why it is very important na mapag-usapan natin na yung kasama doon is really kung ano ba talaga ang isang impeachable offense. At nakasulat doon, if I may quote, the basis of any charge must be for impeachable acts or omissions committed in relation to their office, meaning in relation to their impeachable office and during the current term of the impeachable officer. So that is why, Your Honors, it is the view of the defense na hindi po obiter lang itong pronouncement ng Supreme Court na to as to what constitutes as an impeachable offense.
Yes. I'm not texting. I got on my phone the Duterte versus House of Representatives because, of course, my follow-up questions was to get into the mind of the prosecution when to apply the Duterte case and when not to. So, but I'll still ask you the same question. So, what's more logical, that the due process requirement that the acts committed should have been on the term is also applied to the other modes or just to the one-third mode?
All modes of impeachment, Your Honor. That is our position. Kasi po, we would veer into absurdity, no? Na kung dun sa one-third mode tayo, ang impeachable offenses limited lang sa term, pero pagdating doon naman sa other mode, which dinaanan, admittedly, at yun ang dinaanan nitong current proceedings natin, mag-iiba ang definition ng impeachable offense. I do not see any logic on why there's a difference because an impeachable offense is an impeachable offense. So para po sa atin, that should apply. And in fact, the Supreme Court did not make a distinction as to the guidelines that it laid down in that decision, Your Honors, please.
Yeah, so in the first page, Sabi dito, second, considering the nature of the offices and the institution that are subject to impeachment, its effect on the independence of constitutional departments and organs, and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. While the court does not determine when, who, and whether an impeachable officer may be removed and disqualified from political office, it has the duty to construe and process mandated by the Constitution. So is this for you part of the ratio decidendi, or is this a obiter dictum?
Ratio, Your Honors. In fact, that's why the Supreme Court, when it started the decision, said that the end does not justify the means, no? Because it was precisely discussing the means. Ano ba yung dapat nating sinusunod na proseso?
So since we're talking about subpoenas, we'll go to the end and the means, the justified means.
With the permission of Senator Judge Allen, I would just like to get the assent of the counsel from the panel of prosecutors. The document sought to be distributed by the counsel for respondent is a July 25, 2025 discussion on the Duterte v. HOR on the one-year bar rule. Again, it's dated last year. With the permission of the prosecution, we shall distribute it without prejudice to the counsel for the panel of prosecutors to also furnish whenever it shall so desire, because this issue, as pointed out by Senator Judge Cayetano, will linger until the end of the proceedings, without prejudice to the counsel from the panel of prosecutors to so furnish also Senator judges with their rejoinder to this document being furnished to the Senator judges. Is that okay?
Your Honor, I believe that, first of all, may we request for a copy of that document. I believe that document refers to the office of the spokesperson.
That's correct,
of the Supreme Court, in which case, Your Honor, we would have to interpose an objection because any interpretation by the office of the spokesperson is not binding on the Supreme Court. What we must look at are the actual text of the decision.
Well, counsel, you can say that in your rejoinder. Point that out in your rejoinder and point that out in your submission.
We will do that, Your Honor.
So ordered. Clerk of Court is directed to kindly distribute the copies to the Senator judges without prejudice to the panel of prosecutors submitting a rejoinder to this document.
Yeah.
Senator Judge Alan Cayetano, you may proceed, sir.
Yes,
Apologies for the interruption.
Presiding officer, to be fair to I wouldn't have objected if you objected to the distribution, but realistically, we won't have time to read it because magruruling na after.
Yes.
So it'll be more of reference materials. But feel free also to, if you feel that you should submit in writing a rejoinder to be fair to everyone. So if the voting was tomorrow, and it would be unfair to distribute it. So can I ask the same question, Congressman? So I read, it's the first few paragraphs, no? Sabi kasi dito, you heard me naman, no? You want me to read it again, or?
If I may be allowed to respond already to the
yes, go ahead.
question. Well, first of all, Your Honor, I think we must point out one of the plainest reasons why that statement in the Duterte ruling is obiter dictum. And that simply is because there was no trial yet to speak of when the Supreme Court rendered that decision. Paano po magiging issue yung nangyayari ngayon sa trial, samantalang nung dinesisyonan po yan ay wala pa pong trial. Therefore, any statements by the court about how the trial should be conducted are outside the issues of that case, and while they may be guidelines, they are not binding as judicial precedent to us and to the future generations.
Actually, I was referring to a different matter already, but just to that point, it's not how, it's what. Because it's paragraph 6. So the basis of the charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. For the President and Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 3.1 of betrayal of public trust given by the majority of the electorate. For the other impeachable officers, the acts must be sufficiently grave that they undermine and outweigh the respect for their constitutional independence and autonomy. So this doesn't really tell us how to conduct the trial. This basically tells us is that if we don't follow that, we're endangered of having a trial that's void ab initio.
I would have to respectfully disagree,
Okay.
Your Honor.
Anyway, we've gone through that argument, and I won't argue with both of you. Going back to this is what I read, no? Second, considering the nature of the offices and the institutions that are subject to impeachment, its effects on independence of constitutional department and organs, and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. I'll stop there. Kasi nabanggit mo kanina, may I speak English Filipino? Nabanggit nyo po kanina na that's for us to decide, and my interpretation, and I've felt like that many times, di ba, na zealous dapat ang impeachment court sa powers niya kasi not only because it's sui generis, wala tong apologize to Senator Judge Risa, my phone fell there. So, wala nga tong, you cannot appeal the decision of my belief, no? You cannot appeal the decision of to acquit or to convict to the Supreme Court, di ba? But the parameters, so let me use the words of the Supreme Court, no? Ang sabi niya, all legal issues involving impeachment proceeding are subject to judicial review. So you disagree with this or you agree? In context ng sinabi mo kanina na it's within our power to make these decisions.
I believe what is the controlling decisions there, Your Honor, are the cases of Gutierrez and Francisco. Because in those cases, the issue of what is an impeachable offense was squarely brought before the court, and the court said very clearly that that is purely a political question that is not within the judicial power for us to decide. And I believe that that should be the controlling jurisprudence.
So let me be more specific. So for example, we issue some subpoenas and we do not issue some. Can one or both of you, meaning the prosecution and defense, go to the Supreme Court and question it?
Well, there is always the possibility that some side, perhaps the defense, may claim that there is a grave abuse of discretion, I believe, as they have done in their other petitions filed, and therefore make an attempt to stop the proceedings before this court. But as I have said last week, Your Honor, in our opinion, it is this court has the sole and exclusive power to decide what an impeachable offense is, and no one, not even the Supreme Court, can dictate on this court in making that decision.
Yes. Same answer.
No, Your Honor.
No,
I have a different...
So, okay, you can go back to that question. Then my follow-up question was, so let's say certain orders of the court, can the prosecution or defense go up to the Supreme Court and question its constitutionality?
Yes, Your Honor. It is our position that either of the parties can do that. Why? Because sa atin nga, ang sabi natin kanina, that the Constitution cannot be read in isolation. So while the Constitution gives the sole power to the Senate to try an impeachment case, to try and hear an impeachment case, we must read this in conjunction with, again, Article 3, Bill of Rights, and Article 8, specifically Section 1, which is the power of the judicial review. So pag sa tingin po ng isang panig, merong grave abuse of discretion na naganap, we are of the position that, in fact, this is a justiciable issue and can be brought before the Supreme Court, Your Honor.
So at least in that small point, I think we all agree that if we think there's grave abuse of discretion, there's a possibility that the Supreme Court will take it up. I'm not referring to the subpoena, I'm talking in general. So I'll skip a few pages of my questions precisely because I wanted to elicit your opinions or your stand regarding the fact that the impeachment court is supreme, but it's not true that we can do anything or we can just make decisions that are not based on statutes and on legal orders. In fact, when the Supreme Court issued a TRO regarding the foreign accounts or the dollar account in the Corona case, the impeachment court voted to respect the TRO. No? But of course, we did vote. So there could have been a constitutional crisis if we voted not to, and then, of course, we know because of history, nag-waiver na lang si Chief Justice Corona, no? So can I go now to the ultimate facts, no? I don't know if Senator Joel, but Senator Pia asked a little bit about this. Just a quick review, or maybe, so we're also governed by the rules of court when it comes to ultimate facts. This is what Section 1 says. In general, every pleading shall contain in a methodological and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence, on which the party relies on his or her claim of defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her will be clearly and concisely stated. So does the two councils agree that sa ultimate facts, you have to include the evidence?
I would make a distinction, Your Honor, between what we call ultimate facts and evidentiary facts, which are the pieces of evidence that could be used to come to the conclusion or to decide whether those ultimate facts are present in the case or not.
Yeah, I think all of us lawyers agree with that. There's a difference between ultimate facts and evidentiary facts. But the rules of court says, including evidence. Kasi kung walang including evidence, ang kailangan mo lang i-file ultimate facts. Pero pag sinabing kasama ang evidence, for me, it doesn't mean that every single testimony in every single document should be attached. But so let me go to my second question. So pwede bang sa articles of impeachment, ultimate facts lang, walang naka-attach na evidence?
Ang requirement po sa pleading ay doon na dapat nakasaad ang ultimate facts. But if you look at the articles of impeachment that are before this court, it also contains evidentiary factual allegations to support the ultimate facts that are contained therein.
Thank you for that answer. Actually, that was my next question. Did it contain? And you answered it. So, with respect to the Saballa and Cabrera impeachment complaints, is it correct that there was no authentic records that were attached when they were filed? Factual lang tong tanong ko.
If Your Honor, please, first of all, I would have to raise an issue with respect to whether this honorable court is acting as an appellate or review court of what happened during the House proceedings. The power of to initiate an impeachment complaint is exclusively lodged with the House, while the power to try and decide that impeachment case is exclusively lodged with this honorable court. And I don't believe that it is part of the function to go back to what may have happened during the proceedings before the House, since the articles have already been transmitted to this honorable.
Well, Counsel, even your students, colleagues, recognize that you are a brilliant man. You're very well learned sa law, but minsan mabilis. Kasi actually, that's not where I was going. Binaliktad ko lang. So two of my colleagues started with, or in your discussions, ano yung fishing expedition going down to ultimate facts and evidentiary. Ako, I wanted to distinguish when is it a fishing expedition and when it's not. So I just wanted to know as a fact. Or can we take judicial notice that there was no authentic records in the Saballa and Cabrera?
What's the point again, Senator Judge? There were no authentic...
It was just preliminary because I wanted to compare it with other impeachment complaints. And I wanted to ask the question, when is it a fishing expedition or hindi? So these are legitimate questions. So factually, yung Saballa and Cabrera ba, may authentic records attached. Ang information ko, wala. But I don't want to...
I believe, Senator Judge Allen, that the Zaballa and Cabrera complaints were attached as an annex,
yes,
if I'm not mistaken, to the respondent's answer. Would that be correct, Attorney Poe?
And to be fair, it was...
as well as the annexes.
Yes, Your Honor.
In fact, the presiding officer noticed that it lacked a page in one of the annexes to the, I think, Zaballa complaint,
So,
which
anyway,
I think pointed out. So that's a fact.
Yeah,
So it's in the
lang-
records, Senator Judge
factual
Allen.
lang po. So, in the absence of authentic supporting record, what factual basis did the prosecution rely on to say that the allegations were sufficient in form and substance?
If I recall correctly, Your Honor, please, there were some attachments to both complaints. And I'm not aware of any rule in the House of Representatives as far as impeachment cases are concerned that limit what may be discussed or investigated by the committee to only what is contained and attached to the impeachment complaint.
I'm not questioning if there's an attachment. I'm questioning whether there was, I'm asking question. I'm not even questioning it. I'm asking questions on if there were authentic records. So I'll move on. No? In the complaint against President Bongbong Marcos, the finding was the complaint failed to establish any factual nexus between the president and an impeachable offense. What are presented were policy and disagreements and generalized accusations, not ultimate facts. Yun ang finding ng Committee on Justice. Correct?
Yes, Your Honor, to the best of my recollection.
So that's my question. After answering that question, does the prosecution agree that the requirement of alleging ultimate facts applies equally to all impeachment complaints, regardless of it's the president or the vice president, regardless if it's the ombudsman or the COA chairman?
Yes, Your Honor, and as I recall, when the members of the committee examined the complaint filed against the president, the conclusion of the committee was in fact that there were only conclusions of law contained in that complaint, not allegations of ultimate facts.
Yes, yet in that complaint, there were documents attached, authentic records, and the House did not ask na masupina yung AMLA, BIR, and bank records of the president.
The requirement, if Your Honor, please, of ultimate facts is really based on what is alleged in the petition or complaint itself.
But what was the exact words of counsel? Ang katotohanan ay hindi
confidential.
Hindi confidential. So why in the case of President Marcos is the katotohanan confidential, but in the case of Vice President Sara, it's not confidential?
Wala naman po akong maalalang ruling ng committee in the case of the president na meron silang sinabing confidential.
No,
what I recall is that the conclusion was that the complaint did not allege ultimate facts.
So there was a conclusion even before asking for all of this. But in this case, there was a conclusion that there's no nexus between the president and an impeachable offense. In this case, walang authentic documents pero humihingi ng supina kasi yung katotohanan hindi confidential. So, which goes to my, well, first, let me honor who I should honor because it seems that the Lisa Masa complaint, which was endorsed by ACT party list, was here kanina, and I think Antonio Tino, I think Sara Elago was here the last week, and I think Representative Ko was here. So in their case kasi, I can say walang selective justice because they wanted the same standards of president and vice president. So that's my next question. We want fairness for everyone and for the Filipino people, but would it be unfair to require 20 years of documents from AMLA, BIR, and bank accounts from Vice President Sara without requiring the same from President Bongbong, considering that all of these scandals is happening during his administration?
If the allegations of the complaint against the president did in fact contain ultimate facts, I would see no reason why the Committee on Justice should not have proceeded with it.
So I'll take that answer. May I ask the same question? Rule 8, ultimate facts including evidence. So the answer of the prosecution was that basta't may evidentiary facts. But ang nakalagay kasi sa Section 1 ng Rule 8, including evidence, what is the position of the defense on this?
The defense follows strictly the rules, Your Honors. While I agree with the distinguished opposing counsel na iba yung ultimate facts and evidentiary facts, no? I don't want to blur that line. Tama naman po yung sinabi ng ating opposing. But yun nga po yung punto namin, no? In the Zavala and Cabrera complaints, Wala pong ultimate facts at wala din pong evidence or evidentiary na nakakalakip doon po sa mga complaints, and which is the very issue that we brought up to the Supreme Court, Your Honor.
So if you were representing now the President and the opposing counsel was also asking for 20 years of records of AMLA bank accounts and BIR, would you still have the same position?
Your Honors,
That unless it is relevant and definite, I read in your pleadings, diba, and in your position paper na yun yung... So kasi I'll ask na rin my next question. Why is it definite in your view?
Opo. So on the first question, yes, Your Honor. Even if I were to be representing the President now, I would have the same view, no? Na hindi po pwedeng ganun ka 20 years ang span ng mga documents na hiningi, precisely because the jurisprudence provides that for a valid subpoena to issue, it must be particularly described, plus yung sinasabi po natin na relevance. Now, to the second question as to why it is not particularly described, Your Honors, unang-una, let's start with the bank accounts. No? Yung bank accounts na naka-enumerate sa kanilang request, it is our position na yun po yung natawag kanina na fruit of the poisonous tree. Because as you can see, lahat po ng pinanggalingan na accounts na yan ay yung AMLAC. But which we are contesting. No? Sa amin po, unlawful po yung naging disclosure sa Committee on Justice. But more importantly, pangalawa, aside from just the mere bank accounts, the documents they're asking, Your Honors, while they are specified, kung titingnan mo talaga ng mabuti kung anong hinihingi nila, they're asking for all bank records, without any assertion as to why all of these are relevant to prove whatever allegation they have stated in the articles of impeachment.
I'll skip many questions here and go to that question, but to be fair, Congressman Dioknos, you said that's an exclusive authority, right, power of the House. So if I want to question the difference, I'll do that in either the Senate or as a private citizen. So I won't go into that. But I ask that now in context of whether or not the certain parameters in the subpoena you're asking for is valid or not. So let me just go to this series of questions. This is really a discussion into what is substantial facts, what's ultimate facts, what's essential facts, what are, and as you said, Attorney Powa, we don't want to bore everyone with that, but it's important in terms of due process. So basically, diba, the ultimate facts are that establish the charge, in this case, unexplained wealth. So let me put it this way in my question to Attorney and Congressman Prosecutor Joke. No. So like if I say that may kilala akong politiko, commissioner ng ganito or congressman, senator, whatever, ang SALN niya was 1 peso or what's a reasonable amount. SALN niya was 1 million, 20 years later it's 20 million versus the commissioner of BIR in 5 years, it gained 50 million compared to this congressman nito. Then I said, eto lang income niya, unexplained wealth yan. In your view, is that sufficient na for the impeachment court then to issue the subpoenas? Or do you have to specify na, for example, you say that that commissioner, sa SALN niya, he only had 2 cars, but he actually has more than 4. Therefore, penging subpoena para sa LTO. O that commissioner, ang sabi niya, isa lang ang bahay niya. Pero subpoena sa LRA kasi 4 ang nakita namin. Diba? Kasi on the later examples, medyo mas malinaw yung ultimate facts. Pero yung pag sinabi mo lang, eto SALN, eto tumaas, which was my point actually in my last few vlogs, that just because tumaas yung SALN, that doesn't mean that there's ill-gotten wealth. But my question there was, does that give us now the authority to get the bank accounts, the AMLA and the BIR? Because whatever we do in the impeachment court is for impeachable officers. But nanonood din yung Sandigan Bayan, nanonood din RTC, MTC, nanonood din yung Supreme Court. So whatever rule we have here, that will influence then how we deal with barangay captains all the way to anyone who's not impeachable, no?
For unexplained wealth, Your Honor, I believe the ultimate facts must include the following. First, that the person involved amassed wealth. Second, that that wealth is manifestly disproportionate to that person's lawful income. So kailangan po natin makita kung ano yung kanyang kayamanan at kailangan natin ikumpara doon sa lehitimo niyang kinita. And that can be only determined by looking at the records that we are requesting from this honorable court.
No, but if you're just looking at the SALN at yung kinita niya, so I'll give you a example. No? I won't name the person para walang mag-react. But he was senator, I think in 1987, an outstanding human being. And he was telling us, etong lupa na to, nabili ko ng 1980 o 1970 na 50,000. Oh. Nabenta ko ng 1990. Kaya lang sa SALN, ang nakalagay kasi doon yung acquired cost. So nilagay ko 50,000. So kung titignan mo kami, then he named some other great senators, etc. Nakasabayan niya, congressman at dito. Titignan mo, si senator ganito, kami lahat. O ang SALN namin, baka 5 million. Pero yung 100,000 na lupa na binili namin noon, baka 5 million, 20 million, 30 million. So if one of those officials suddenly sold the property and then placed the money that came in, so let's say the 100,000 property was sold for 5 million, but then for example, pinang-blow out niya sa pamilya yung 500,000 before December 31 of that year, mag-i-increase yung kanyang SALN by 4.5 million. So if you just compare his income na sweldo niya with that will not show you that he has ill-gotten wealth. So compared na pagka inallege ko na ang sweldo niya 200,000, eto, pero bakit may bahay siya sa ganito, nawala sa SALN niya. Diba? So I agree na sundan natin yung ebidensya. If the SALN is much more than what you're making, that could spark your curiosity, your suspicion, and continue to investigate. But do you make the conclusion now and file the impeachment case that since malayo yung SALN sa income, therefore ill-gotten yon, without giving that person a way to explain before you subpoena every single document about their lives?
That's precisely why, Your Honor, they call it unexplained wealth. Doon po natin malalaman yan sa mga dokumento.
No, I agree.
Ngayon, kung
they call it Go ahead, sorry.
I'm sorry, Your Honor.
I'm sorry. I'm the one. Please continue.
Kung halimbawa sa binigay niyong example ay nag-appreciate yung value of the land, then I would not call that unexplained. I would call that explained wealth.
Yes, but you're introducing a new concept now, unexplained wealth versus ill-gotten wealth. I agree with you. Unexplained wealth is that if you look at the SALN at hindi tumutugma, may may unexplained wealth. That's why you ask them to explain it. And then pag hindi maganda yung explanation and may ebidensya ka, then you can go against that person for ill-gotten wealth. Diba? But like in certain parts here, I saw some that I would consider even without asking you evidence. But for example, yung mga kumpanya. Sabi dito, lugi yung kumpanya. So kung lugi yung kumpanya, hindi makaka-contribute yun sa kanyang ill-gotten wealth kung meron man. So why are we getting all the documents about those companies? Doon pumapasok yung criticism ng iba, is this a fishing expedition? Kasi if I had 5 companies and they were all making money and supposedly I only own 1% of that company but I'm getting half of that income, I would agree with you, isupina lahat yan. Tignan natin yung flow niyan, baka yan yung pumasok sa akin. Pero lugi nga yung mga kumpanya. As an example, as an example. So that's my point. Is it enough in the view of the prosecution panel just to allege, malaki yung SALN mo, bigger than your monthly sweldo? Both of us agree, it's unexplained. But is it ill-gotten? Or do you need more allegations to show that it was ill-gotten?
Well, Your Honor, please, the decision whether wealth is unexplained or, as you said, ill-gotten is really a decision that this honorable court will make based on the evidence. Ang gusto lang po namin ay mailatag ang ebidensya sa inyong harap para kayo na mismo ang magsabi. At para malaman po yan, we have to look at the statements of assets, liabilities, and net worth. We have to look at the lawful income reported in the ITRs. We have to look at the bank records in terms of kung ano yung pumasok at lumabas sa kanilang mga accounts. I'm sorry, Your Honor.
You go ahead, Gert. It's mine.
As
Sorry.
far as the businesses are concerned, that has to do with the third subcharge under unexplained wealth. Yung pong continuing to participate in business interests despite the clear and express prohibition provided in the Constitution. We want to know whether those businesses, yung ba ay mga operational ba ito? Ito ba ay talagang sasabihin natin na nandun yung sinasabi nga na inaamin ni Vice President sa kanyang salin na business interest nga niya yon.
Yeah, I'm skipping because this is mostly questions on fishing expedition. I'll go to the defense after this, but can you tell us the difference between evidence and proof? In your layman's term or legal terms, or if you want to look it up, but in how do we explain to people the difference between evidence and proof?
Napakabigat po ng inyong tanong.
In our words lang.
I will
para
try
lang
my
maintindihan.
best, Your Honor, to answer it. In a court proceeding, whether we're speaking of an impeachment court or a regular court, the judges look at the evidence. They may never be able to know the entire truth kasi ang pangyayari ay nangyari dati pa po. Essentially, a trial is really a reconstruction of something that happened before. So it may happen in some cases that there is enough evidence to make conclusions as far as a judgment is concerned, even if the members of the court did not get to see the entire truth.
Yes.
Ang gusto po namin maiwasan dito sa impeachment court ay meron po tayong hindi mailatag na ebidensya sa mga maestrado po na nandito para talagang maging buo yung larawan nila bago po kayo magpapasya.
Yeah. I don't think there's any question that all of us here want na mailatag yung ebidensya. The question is, do you have the evidence or are you fishing for the evidence? And that's a question not only for you, but for every single impeachment process, not only the umabot dito, because myself, Senator Subiri, Senator Chis Escudero, then later on Senator Villanueva, has been in the House many times during impeachments of presidents and chief justices. No? But the reason I ask between evidence and proof is because if you have the evidence, you want the opportunity, diba, to bring it here, show the relevancy, connect it to the crime, we admit it so that if it's true, then we can convict. The opposite sides na will either question, hindi admissible yan, or admissible pero walang relationship yan, etc. No? So what I'm saying is that if you're going to prove your case with no evidence, except that if you get all of that, then magiging arbitrary yung House of Representatives, sinong gusto nilang i-impeach. Because almost any public official who's been there for a long time, you will see discrepancies in their SALN because unang-una iba yung acquisition cost at iba yung current value at iba din yung deadline ng December 31, no? Which after this I'll ask the defense to answer, then I'll go into the AMLA, which is different from bank accounts, no? So if you're coming to the court with evidence already, but kinukuha mo yung supina na yan, di ba, to further prove your point, I don't think there'll be a question there. As Attorney Powa said kanina na kung yung BIR box na yan, alam natin yung laman, and dapat gamitin dito, they inallege nyo na. Pero kung hindi alam yung laman, are we fishing there if there's a tax evasion or wala? I don't know the answer. I'm asking you the question. You can answer it in any way you're comfortable in answering.
If I may briefly narrate the procedure that the House might had to undergo for the articles to reach this honorable court. When the complaints were filed before the House of Representatives, the Committee on Justice was tasked not with conducting a trial, not with ferreting out all the evidence, but simply determining whether there was probable cause to proceed with the case. So hindi po namin hinanap yung kabuuan ng ebidensya dahil hindi po namin tungkulin yon.
Yes.
When we made the determination that there was sufficient probable cause to proceed with that case, then that is what we submitted in terms of the articles of impeachment that reached this honorable court. Ngayon, syempre po, just like a preliminary investigation conducted by a prosecutor, ang hawak lang po niyang ebidensya, ang titingnan lang po niya ay kung merong probable cause. Not all the evidence yet is before that prosecutor because wala pa pong trial. The presentation of evidence, even the subpoena or compulsion to present evidence will only happen when the trial takes place. And yung tinutukoy po ninyong fishing expedition, yun ay maaring sabihin natin nangyari kung only if the party requesting the evidence or documents ay nagbabakasakali lang. Baka may makuha tayo dito. In our case, I have to disagree that there was any sort of fishing expedition because based on what the Committee on Justice and later the plenary of the House found was sufficient, there was enough cause to proceed with the case.
I'll go to probable cause, but yung sinabi mo, baka sakaling may makukuha dito. You said hindi ganon. So anong makukuha natin if we grant all the subpoenas you're requesting?
The evidentiary facts, Your Honor, that were not yet hindi pa nakita ng House nung ang ginagawa lang po namin ay determinahin ang probable cause.
So nagbabaka sakali din?
Hindi po.
No, kasi you said...
Because there is basis for requesting for the bank records.
So what will you see? You still don't know what you'll see?
We are basing the request for the bank records on the evidence and information provided by the Anti-Money Laundering Council, which appears to show that there were billions of pesos that went through the accounts of the Vice President during that
Let's go
period
to
of
that
time.
with the permission of the defense then. I think you're listing down naman. So the Anti-Money Laundering Council, no, does not deal with income. They deal with flow, right? So pag sinabing billion, that doesn't mean that a certain official has billions in their account. So meaning if I have 1 million pesos deposit on January 1, and then on January 5, I take it out and put it in time deposit for 1 month. And 1 month later, it comes out with 2% time deposit. Hindi na 1 million yon. 1 million in, 1 million out, 2 million, 1 million in the time deposit, 3 million. Paglabas na may 2%, 1 million 2 pesos, 1 million 2,000 pesos, 4 million na yon. So hindi evidentiary yun, speculation sa ikot ng pera. Meaning, all I have to do is find someone with a bank account and give them a long enough period and I will say that they have hundreds of millions or billions.
Precisely, Your Honor, that is why we want the bank records to be produced. Because, as you mentioned, the only reports submitted by the Anti-Money Laundering Council pertain to covered and suspicious transaction reports. They do not show us the exact balances that were contained in those bank accounts. And it is only the bank records that will provide that information.
Agree. And it's suspicion. When you say suspicion, that does not mean necessarily suspicion that it's attached to a AMLA crime, but it could be suspicious meaning 6 months walang gumagalaw, biglang everyday ngayon gumalaw. Diba? Yun yung definition ng part ng definition ng AMLA. But if you cannot connect AMLA and the bank accounts, that's precisely what the defense and other people are saying. Aren't you nga fishing between the three? Fishing means hindi mo pa hawak, so you're trying to get a fish, in this case, a very big fish. Diba? So, pag sinabing hindi fishing expedition, meron ka ng ebidensya, but you want to prove that in court, and you need that to prove it, but you know what to prove already.
If we bring Your Honor's logic to its conclusion, that would mean that the Committee on Justice would have to conduct a full-blown trial, get all the evidence at that level, so that we do not have to fish anymore when we get to this court. When that is not the contemplation of the procedure for impeachment under the Constitution.
I won't argue what the
with
what
the permission,
House...
with the permission of the gentleman of the floor, Senator Cayetano.
Last 2 questions.
Thank you very much.
So, Senator Escudero, myself, we were in the Estrada and Arroyo impeachment. And it's harder to impeach a president than a vice president. Di ba? But whether it was accounts, anong laman, property, kotse, we did our homework. So it's not my place to tell you did or not. Kaya nga tinatanong ko, may ebidensya ba o wala? Or is it a fishing expedition or not? But as I said a while ago, I won't argue. So I have one last question after that, but I'll go first to the defense. In the context of what I asked, no? Between those two examples, eto salin mo, eto income mo, malaki salin mo, we can agree it's unexplained. Kasi nga, you need to explain it further. But is it automatically ill-gotten wealth?
No, Your Honor.
So if it's not automatically ill-gotten wealth, in your view, I mean, I read this from your, maybe you can just restate, why is it a fishing expedition?
Opo. Your Honor, because precisely, yun pong sinasabi nila na unexplained wealth, they were basing it for 20 years, for one, no? Pangalawa, they couldn't pinpoint exactly bakit mo nasabing may unexplained. Alin dito sa properties yun unexplained, no? Third, and if I may elaborate from our memo, if you look at the articles of impeachment, it presupposes that the Vice President earned 30 million over a span of 20 years. Yes, they did not think about the Vice President not being in public office from 2013 to 2016. They didn't think about the income that could have been generated by being married to a lawyer who had his own law office. So to us, it was basically a conjecture, speculation, conclusion of law and fact to say, biglang, uy, may unexplained wealth po dito. No? That's basically our point. And then secondly, the decision earlier, it was mentioned by distinguished opposing counsel, decision rests upon this court to determine kung meron ng unexplained wealth. I disagree with that. The ultimate decision rests upon this court, that is true. But the initial decision rests with the person accusing, di ba? Pero nung nag-accuse yung tao sa Sabalian Cabrera complaints, wala man lang nakasulat po doon. Kanina na-mention po yung should the Committee on Justice now conduct a full-blown trial? No, it shouldn't. It should just evaluate the complaint. Parang nga pong piskal, parang preliminary investigation. Pag tayo po pumunta sa piskal at ang dala lang natin doon ay puro paratang, wala man lang supporting document, what will the fiscal do? Dismiss the case outright. Yan naman po ang totoo. No? So that was our point to begin with, and that is why we're saying fishing expedition ito. Kasi hindi mo man lang ma-pinpoint kung anong transaction yung sinasabi mong nag-amass ang Vice President natin. Anong taon na nag-amass yung Vice President natin ng ill-gotten wealth or unexplained wealth. At dahil doon ngayon, we're asking for records spanning 20 years, both, BIR records, bank records, AMLAC records, which they already have, actually, from the Committee on Justice. Pero, hindi natin ma-pinpoint, alin ba talaga dito? We cannot specify kung ano yung act, ano yung omission na ginawa niya na nakapag-amass siya ng unexplained wealth.
Talking about both parties, talking about the fiscal or prosecutor, actually binago na rin ngayon. Probable cause, with reasonable certainty, mako-convict. So meaning, you go to the fiscal's office, that you point out ano yung crime, sino yung gumawa ng crime, and yung preliminary evidence mo might not be enough to convict at that time, but enough to say na hindi lang to marites. So if I go to the fiscal's office or ombudsman saying this senator has 150 million in SALN, 10 years ago it was 50 million, therefore it's ill-gotten wealth, and then wala pa akong ibang dala except yung magkano sweldo dito, I doubt the fiscal will file that case. But if I tell the fiscal that he has 2 cars in his SALN, but eto, I see him using 4, then give him the opportunity. But I can subpoena the LTO. Na kanino ba yung plate number na yan? Baka namang nasa kapatid talaga niya, no? But the last set of questions, I'll just ask it once, no? So I think everyone understands naman the subpoena regarding the Vice President. The issue was really the dates and how specific or hindi. Actually 2 questions. The corporations, do you not have to pierce the corporate veil considering there's no allegations in the articles that these companies were used to amass ill-gotten wealth. In fact, I haven't read everything, but so far sa binasa ko, is hindi kumikita tong mga kumpanya na to. Because there's a Supreme Court decision that if it's a joint account, may rights din yung isa. And I don't even know if we informed all of those companies that we might subpoena their records. So did we give them that opportunity? Isama ko na yung last question, Mr. Presiding Officer, and I won't follow it up, no? But yeah, the question was, because a law student asked me, Sir, bakit dinala yung box dito sa Senate? Ba't na lang hindi nila binuksan sa House? So sinagot ko sa kanila, ano ba turo ng professor nyo? Sir, hindi naman nakalagay impeachment trial in cases of impeachment. So the House was actually empowered to open the box there. So I just wanna know the position of both parties kasi nahihiwagaan ako sa box na yon. Si Neil dinala dito, ibabalik sa inyo, then magsusupina tayo. But dun sa graduate na yung nagtanong sa akin doon, they discussed it daw in class, and their professor and their class, ang consensus is that the House could have opened it because the wording in the is it the BIR case or the bank accounts? No, bank accounts ata, yung in cases of impeachment yung nakalagay dun sa sa
Bank
batas.
accounts. Secrecy of bank deposits.
Yes. So ang question niya, let me rephrase, is that, did you do that there? Kasi if you did that there, hawak nyo na ngayon. Hindi na namin problema sana. No? So those two questions lang regarding do you think nag-comply yung requirements dun sa companies, and should we give notice to the companies? And secondly, about bank account, could you have opened it already in the House? Yung BIR din ba?
Counsel for the panel of prosecutors may respond. Thereafter, counsel for respondents.
Thank you, Your Honor.
And we would like to thank
Counsel, thank you very
Senator
much.
Judge
Thank you,
Allen for his
Senator
interjections.
If Your Honor, please, the doctrine of piercing the corporate veil applies when we are determining liability of the company or corporation involved. In this particular case, that doctrine has no application at all. We are asking for those records to be produced so that we can determine the extent of participation of the Vice President, as she herself had admitted those business interests in her salens. Kaya po namin hinihingi po yun. Kasi sa tingin po namin ay wala pong aplikasyon ang piercing the corporate veil. Second, as far as opening the box is concerned, while it is true that under Republic Act 1405, there's no qualification that impeachment trial lang po ang pwede. As I understand it, it was the better judgment of the committee out of sheer discretion and prudence not to, because at that time we were already being bombarded with petitions left and right seeking to restrain our proceedings. And we felt that it would be more prudent to bring the matter to this honorable court. Thank you.
Your Honor.
Counsel for the respondent.
On the first point, Your Honors, on piercing of the corporate veil, para sa amin, pwede lang naman under jurisprudence mag-pierce ng corporate veil. Ibig sabihin, kasi separate and distinct personality ng mga korporasyon, you can pierce that veil if there's an allegation of fraud. And in this case, wala naman pong allegation ng fraud. Pangalawa, kung totoo po na talagang hinahanap lang po ng kinakagalang-galang na prosecution ay tungkol dun sa divestment issue, then they will not need the tax records, the bank records, or even the AMLAC records of these companies because all they need would be the GIS. The General Information Sheet would show you exactly the extent of the interest of the stockholders, hindi po ba? Pangalawa, pagdating naman po dun sa what's our position, pagdating sa bank secrecy and the exception on cases of impeachment. Sa aming pananaw, at the committee level, meaning Committee on Justice, ay hindi pa po applicable yung exception na ito. And we are holding on to the ruling of Marquez versus Ombudsman or Desierto, I believe, no? Wherein it was said na pagdating sa preliminary investigation, hindi pa po applicable yung mga exceptions under the Bank Secrecy Act, and there has to be a pending case before such bank documents are in fact subpoenaed. That is our position, Your Honors.
Thank you, counsels for the parties. Chair will now make a ruling, but prior to that ruling, Chair would like to inquire very, very briefly from the counsels. First, for the counsel for respondent, may the court know when the respondent was married to her spouse and what is the property regime governing their marriage?
Your Honor, I believe they were married, but let me just check the facts just to be sure, but I think it was 2007. 2007, Your Honor. Can I get back to you on the specific date for that?
The date would not be necessary because 2007 would mean they would be covered under the family code. So may the
Yes, Your Honor.
chair ask, what is the property regime governing their marriage?
As far as I know, there are no property regime arrangements or prenup. That's why, Your Honor, I would assume it would be the default property regime, which would be
The absolute community of property. Thank you, counsel. Chair will now make its ruling. The impeachment court will now resolve the prosecution's renewed request for the issuance of subpoena ducis tecum dated July 6, 2026. You may seat, counsels. Directed to the concerned banking institutions and Anti-Money Laundering Council. The court begins with the standards governing the issuance of subpoena ducis tecum. These are set forth in Section 3, Rule 21 of the Rules of Court, which provides, among others, that in the case of a subpoena ducis tecum, it shall contain a reasonable description of the books, documents, or things demanded, which must appear to the court as prima facie relevant. Settled jurisprudence has affirmed and clarified these requirements in the 2021 case of Republic versus Sandigan Bayan, dated 2/15/21, where the Supreme Court stated, quote, a subpoena ducis tecum may be issued if the tests of relevancy and definiteness are satisfied. The court must ensure that, number one, the books, documents, or other things requested must appear prima facie relevant to the issue, subject of the controversy, the test of relevancy. And number two, such books must be reasonably described by the parties to be readily identified, the test of definiteness. In the case of BSB Group, Inc. versus Go, GR number 168644, the court stated that evidence is relevant when it bears such a direct relation to the fact in issue as to induce a belief in its existence or non-existence, and when it relates to a collateral fact from which the existence or non-existence of the principal fact may logically be inferred. These requirements are intended to ensure that the subpoena is not used, as mentioned earlier and discussed earlier, as a tool for a fishing expedition as held in Apostol versus Lubingan Rafael, GR number 260640, dated October 1, 2025. We are also aware of the ruling of the Supreme Court in HC Libenau versus Philippine National Oil Company, GR number L13463, quote, a general inquisitorial examination of all the books, papers, and documents of an adversary conducted with a view to ascertain whether something of value may or may not show up will not be enforced. However, after a careful examination of the records requested, the court finds that the requested documents meet the requirements set forth above. They are reasonably described, readily identifiable, prima facie relevant, and material to the allegations under Article 2. This is not the first time that bank records have been examined by an impeachment trial. During the impeachment trial of former Chief Justice Corona, the Senate, sitting as an impeachment court, granted the prosecution's request for the production of bank records. In granting that request, the court cited Section 2 of Republic Act No. 1405, which expressly recognizes cases of impeachment as an exception to the confidentiality of bank deposits and the rights to privacy of depositors. As to the requested period from 2007 to 2021, the defense's objection is overruled. The respondents' invocation of what they referred to as offenses in term, quote unquote, in their memorandum, doctrine in Duterte versus HOR, does not avail. First, the documents requested under the subpoena ducis tecum will not be used to allege additional independent impeachable offenses. The court will not allow this in adherence to the doctrine laid down in Duterte v. HOR, as this will violate the respondent's right to be informed of the nature and cause of the accusations against her and her rights to due process at every stage of the proceedings. Rather, the court will only allow these records to be used to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. Establishing such a factual baseline is recognized in settled jurisprudence involving allegations that a public officer's wealth is manifestly disproportionate to the lawful income and financial capacity of the officer and the officer's spouse. As held by the Supreme Court in Concerned Taxpayer versus Doblada Jr., dated 8 June 2005, quote, in determining whether the properties acquired were manifestly out of proportion to the lawful income of the spouses, necessarily requires comparing their value with the spouse's salaries, benefits, other lawful income, and revenues from legitimately acquired properties or businesses. Further, in the case of Ombudsman V. Bernardo, GR number 18-1598, quote, respondents' beginning net worth must be considered for purposes of determining whether his disposable income was more than sufficient to justify his property acquisitions and foreign travels for the covered period, and whether he possesses the financial capability to acquire or purchase properties as reported in his SAL-N. Quote, such net worth of the respondent as declared in the statement filed by him or her from the first day of his employment with the government shall be considered as his true net worth as of such date for purposes of determining his capacity for future property acquisitions during his tenure as a public officer. Any unexplained increase in his net worth thereafter may fall within the ambit of the presumption provided for in Republic Act number 1379. The production, therefore, of the records from 2007 to 2021 is authorized strictly for that limited purpose only. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term in relation only to Article 2 of the Articles of Impeachment. Now, with regard to the bank records held separately by Attorney Manasseh Carpio and jointly by him and the respondent, the defense's objection is likewise overruled. The respondent's reliance on Republic v. Eugenio is unavailing. That case involved only an ordinary civil inquiry into spousal assets that were not statutorily aggregated. On the other hand, Section 8 of Republic Act number 6713 requires public officials to disclose their assets, including that of their spouses. Their financial interests are therefore statutorily intertwined for purposes of disclosure. Respondent likewise insists on the separate legal personality and distinct right to privacy of Attorney Carpio, but this is likewise untenable. Article 75 of the Family Code explicitly provides, which is why the presiding officer earlier asked the property regime governing them. In the absence of a marriage settlement or when the regime agreed upon is void, the system of absolute community of properties established in this code shall govern. Under this regime, Article 91 dictates that community property shall consist of all the property owned by the spouses at the time of the celebration of marriage or acquired thereafter. Furthermore, the Family Code imposes a strict statutory presumption under Article 93, which mandates that property acquired during the marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. The law is clear on the matter. The legal necessity of examining the financial records of Attorney Carpio is firmly cemented by the default property regime of absolute community of property governing his marriage to the respondent. Absent any proof of a different property regime governing their marriage, any funds deposited in the bank accounts of Attorney Carpio are legally presumed to form a single, indivisible mass of community property jointly owned with the respondent vice president. Because Philippine civil law legally merges their assets, properties, and income into a single absolute community, it is a legal and mathematical impossibility to determine the respondent's true net worth or lawful income without examining the bank accounts of her husband. Investigating Mr. Carpio's financial records is therefore not an unwarranted intrusion into a third party's privacy, but an absolute legal prerequisite in determining the actual aggregated wealth of the respondent. The defense likewise invokes the Data Privacy Act, classifying the records as sensitive personal information, requiring strict scrutiny, quote unquote, citing Zoleta versus Ombudsman. The court, however, in Zoleta did not really use the phrase strict scrutiny, but said strict adherence to the Data Privacy Act. Accordingly, Section 16B of the Data Privacy Act expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of the DPA, Data Privacy Act implementing rules, expressly permits the processing of sensitive information, personal information, when provided to government or public authority pursuant to a constitutional or statutory mandate, and when necessary for the protection of lawful rights, interests in court proceedings. Now, as to the 21 listed corporate entities and partnership, the requests are granted with respect only to 19 corporate entities and partnership. The respondent's connection to these entities is prima facie shown by the general information sheets in the articles of partnership, which have been pre-marked in evidence, and by her admitted sal-ens from 2022 to 2025. The request, therefore, is not considered as a fishing expedition, and subpoenas may issue for their peso-denominated accounts strictly only in relation to Article 2. However, the requests directed to banking institutions concerning JTC Group of Companies and Pikimong Philippines Corporation are denied. Their general information sheets do not identify the respondent or her spouse as shareholders, and the prosecution at this time failed to show either a direct business interest or a clear and convincing basis to disregard their separate juridical personalities. As held in Pantranco Employees Association VNLRC, GR 170689, and Lanuza versus BF Corporation, GR number 174938, the corporate veil may not be pierced on mere suspicion or speculation. Misuse of the corporation as an alter ego, conduit, or instrument of fraud must be clearly established. Absent such proof, these entities cannot be subjected to the compulsory process intended for another. As to the request for subpoena against the partnership of Carpio Lawyers, the same is granted with the following reservation: in adherence to Subido versus Pagante Certeza Mendoza and Binay Law Offices versus Court of Appeals, GR number 216914. The chair notes the practical reality that an examination of a law firm's bank accounts may incidentally disclose sensitive information relating to its clients and legal engagements. The court acknowledges that the partnership and/or the clients of Carpio Lawyers may seek appropriate remedies and to challenge compliance with applicable legal requirements, particularly in light of the potential legal implications, including concerns relating to attorney-client privilege, which may also be raised during the trial proper. Furthermore, the court must draw a legal firm line regarding foreign currency deposits. Foreign currency deposits are governed by Republic Act number 6426, particularly Section 8, which recognizes only one exception to confidentiality: the written permission of the depositor. This is also guided by the precedent arising from the 2012 Corona impeachment trial. On February 19, 2012, the Supreme Court issued a temporary restraining order in PS Bank versus Senate Impeachment Court, GR number 200-238, enjoining the Senate from opening the Chief Justice's Corona dollar accounts in the absence of a written waiver of the depositor. Accordingly, insofar as the request covers foreign currency deposits of the respondent, her spouse, separately or jointly, as well as the corporation and partnership, it is denied. Such accounts shall be excluded unless and until a written consent of the respective depositors is produced. The court now turns to the records held by the AMLC, or Anti-Money Laundering Council. As to the request directed to the Anti-Money Laundering Council, the same are granted with respect to the respondent, her spouse, and the 19 entities and one partnership, for which a prima facie connection has been shown through the pre-marked general information sheets, articles of partnership, and the respondent's admitted sal-ens. However, the requests as to JTC Group of Companies and Pikimong Philippines Corporation are denied for failure at this stage to establish a prima facie link, the respondent or her spouse and said entities, or any sufficient basis to disregard their separate juridical personalities as previously stated. The defense vigorously argues that AMLC is absolutely shielded from this court's compulsory process by the confidentiality provisions of Section 80 of the Anti-Money Laundering Act, as amended, and warrants that compliance would expose AMLC officers to criminal sanctions for breach of confidentiality. The court, however, finds this argument unavailing. Section 8A regulates unauthorized and arbitrary disclosures by AMLAC personnel. It does not and constitutionally cannot nullify the lawful subpoena powers of the Senate sitting as an impeachment court, where compliance with the lawful constitutional subpoena is a justifying circumstances that, if at all, would extinguish any penal liability under Article 11, Paragraph 6 of the Revised Penal Code for any person acting in obedience to an order issued by a superior or some lawful purpose. In the landmark case of Republic versus Sandigan Bayan, GR 2322724, the Supreme Court explicitly rejected the AMLC's attempt to quash a subpoena ducis tecum, ruling verbatim, quote, "The Anti-Money Laundering Council is not merely a repository of reports and information on covered and suspicious transactions. It was created precisely to investigate and institute charges against those suspected to commit money laundering activities. The criminal prosecution of such activities would be unduly hampered if we were to prohibit it from disclosing such information. For the Anti-Money Laundering Council to refuse disclosing the information required of it would be to go against its very function under the law." Further, as held by the Supreme Court in Sabio versus Gordon, GR number 174340, by parity explained that statutory provisions on confidentiality and exemptions from inquiry cannot be invoked to deny access to information by Congress in aid of legislation. It is therefore the position of this court that if the Sandigan Bayan, pursuant to its subpoena powers, cannot be denied AMLC records as well as the legislature in aid of legislation, it most certainly cannot be denied to the Senate, sitting as an impeachment court. The defense also vehemently objects to the production of AMLC documents by pointing out to the agency's own printed footnotes, which restrict the reports for intelligence purposes only, quote unquote, and explicitly state they are not to be used as evidence in any formal proceedings. The court, however, overrules this objection. The admissibility and evidentiary weight of documents in an impeachment trial are determined by the Constitution, the rules of court, and the judgment of the impeachment court, not by unilateral disclaimers printed by an executive agency on its letterhead. An administrative footnote or internal intelligence sharing protocol cannot rise to the level of a constitutional or statutory exclusionary rule. While the AMLC's internal protocols are validly designed to prevent premature leaks during ongoing investigations, they cannot legally operate to tie the hands of the impeachment court once the documents are lawfully subpoenaed. Because the requested suspicious transaction reports and covered transaction reports satisfy the threshold of prima facie relevance in tracing the alleged accumulation of unexplained wealth under Article 2, they shall be produced. The defense further invokes the 5-year record retention period under the AMLA regulations. The 5-year period is a minimum mandatory retention requirement imposed on covered institutions. It is not an absolute prohibition against keeping or producing all the records. Accordingly, let AMLC invoke this limitation in its return, which this court shall take into account and inform the parties thereon accordingly, should they be unable to comply with the subpoena. As for the partnership of Carpio lawyers, Section 1 of Republic Act No. 10365, amending Section 3A7 of Republic Act No. 9160, treats as covered persons those including lawyers who manage client money or assets, manage bank savings and securities accounts, organize contributions for companies, or create, operate, or manage judicial persons or arrangements. Section 2C of AMLC Regulatory Issuance B No. 1, Series of 2018, adopted on May 10, 2018, and filed on June 13, 2018, expressly reiterates this activity-based rule. The court recognizes the statutory exception for lawyers acting as independent legal professionals, where the information concerns their clients or disclosure would compromise client confidences or the attorney-client relationship. Absent any showing, however, that the particular record sought contained such information or would compromise a protected confidence, the exception cannot be invoked merely because the entity concerned is a law partnership. It protects client confidences. It does not confer a blanket immunity upon every financial record bearing the law firm's name. The request for the issuance of subpoenas for the identified financial records, therefore, pertaining to Carpi lawyers is granted, subject to the remedies in law and/or their legal right to assert a specific claim of privilege over a particular document at the proper time. No generalized blanket invocation of attorney-client privilege shall exclude compliance at this time. Therefore, to summarize, the court rules as follows. The request for subpoenas directed to the concerned banking institutions covering the accounts of respondent, Attorney Manasseh Carpio, separately or jointly, the partnership of Carpio lawyers, and the 19 listed corporate entities is granted. The banks are ordered to submit to the clerk of court the documents on July 30, 2026 at 9 a.m. with the attendance of parties and counsels. The request insofar as it seeks the records pertaining to JTC Group of Companies and Pikimong Philippines Corporation is denied for failing to establish prima facie relevance. The subpoenas granted shall apply only to peso-denominated accounts relevant to Article 2. Foreign currency deposits are excluded absent the written consent of the respective depositors. The subpoena directed to the Anti-Money Laundering Council covering respondent Attorney Manasseh Carpio separately and jointly with the respondent, the partnership of Carpio and lawyers, and the 19 listed corporations and entities is granted. The request insofar as it seeks records pertaining to JTC Group of Companies and Pikimong Philippines Corporation is denied for failing to establish prima facie relevance. Finally, the court is cognizant of the Supreme Court ruling in Almonte v. Vasquez, GR 95367, where it stated that a government privilege against disclosure is recognized with respect to state secrets, and it is not amiss to state that even matters of national security have been inquired into in appropriate in-camera proceedings by the court. Therefore, the court ex abundante ad cautela, or out of an abundance of caution, hereby directs, in order to prevent the unwarranted exposure of sensitive AMLC methodologies and information, to submit the records strictly in camera to the presiding officer through the clerk of court first on July 30, 2026 at 9 a.m., who shall review these documents privately before turning them over to the parties as may be warranted. The parties are directed to be represented by counsel on the aforementioned time and date for the proper inspection, comparison, photocopying, and/or marking of these documents as the case may be. So ordered. Moving now on. BR. The impeachment court will now resolve the prosecution's request for the issuance of subpoena dated July 6, 2026, directed to the Commission or Internal Revenue. At the outset, the presiding officer reiterates and adopts by reference the court's citation of applicable rules regarding the issuance of subpoena ducis tecum, which forms an integral part of this order. The foregoing standards are deemed reproduced and shall govern the court's disposition of the present subpoena requests. After examining the records sought, the court finds that the requested documents meet the requirements set forth. They are reasonably described, readily identifiable, and prima facie relevant and material to the allegations under Article 2. However, the court, similarly, requests insofar as it seeks the records of JTC Group of Companies, Philippines Inc., and Pikimong Philippines Corporation. The prosecution failed to establish a prima facie nexus between these entities to either the respondent or to her spouse. The records sought, therefore, do not at this time satisfy the requirement of prima facie relevance under Rule 21 of the Rules of Civil Procedure. The court also resolves the respondent's objection to the requested period from 2007 to 2021. They anchored their opposition on the Supreme Court's pronouncement in Duterte v. HOR that the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. The argument, as stated earlier, fails because first, the documents requested under the subpoena ducis tecum will not be used to allege additional impeachable offenses. This court will not allow it. For the same reasons discussed in the court's earlier order, consistent with the same jurisprudence which are hereby adopted by reference, the court likewise holds that the requested records are sought to establish respondents' financial baseline and capacity only, not to inquire into or prosecute alleged impeachable acts occurring outside the present articles of impeachment. Accordingly, These records are required to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. We are also not without precedent. During the Corona impeachment trial, the Salens, prior to his appointment as Chief Justice in 2010, were presented on the January 18, 2012 hearing of the court. Likewise, evidence and testimony concerning properties and transactions before his appointment as Associate Justice were presented before the court on March 13, 2012. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing a comparative baseline only. They shall not be used as proof of another independent impeachable offense. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. The defense's invocation of the Race to the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of its implementing rules expressly permits the processing of sensitive personal information provided to government public authority pursuant to a constitutional or statutory mandate and when necessary for the protection of lawful rights and interests and court proceedings. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5 of the NIRC. This court is not determining the tax deficiencies or civil liabilities which remain within the province of the BIR. It is exercising its constitutional mandate to determine public accountability under the Articles of Impeachment. Neither does the pendency of a BIR audit suspend or limit the Senate's exclusive jurisdiction to try impeachment cases. The respondent invokes Section 270 of the National Internal Revenue Code to prevent the production of the requested records. The objection is overruled in part. The Supreme Court expressly ruled in Dipad v. Spouses Olivan, GR 168771, that Section 270, quote, of the NIRC obviously does not address the confidentiality of ITRs. It merely penalizes the unauthorized disclosure of taxpayer information, except as otherwise provided for by law. It does not bar the production of the documents. However, the respondent correctly invokes Section 71 and other provisions of the NIRC which recognizes only 3 instances in which a taxpayer's records may be opened for inspection. Number 1, upon order of the President or authorization of the President. Number 2, upon the request of a foreign tax authority with the approval of the President. Or number 3, upon the taxpayer's waiver. Nevertheless, the existence of these statutory limitations does not at this stage preclude the issuance of the requested subpoena. The issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, inspection, or admission of the requested tax records into evidence.
For the arrival of the Senate
In
President,
fact,
the presiding
this
officer of the
issuance
impeachment court,
is the order
and the
that shall
senator
set,
judges.
if at all, things in motion.
The Sergeant at Arms is directed to make a proclamation.
All persons are commanded to keep silent under pain of penalty while the impeachment court is in session for the trial of Vice President Sara Duterte.
The impeachment trial of Vice President Sara Duterte is hereby called to order. We shall be led in prayer by Senator Judge Panfilo Lacson.
Let us all pause for 1 minute of silent prayer for humility, wisdom, neutrality, and fairness. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
Amen. The Clerk of Court will now call the roll.
Roll call of members. The Honorable Senator Judge Aquino, Senator Judge Cayetano Alan, Senator Judge Cayetano Pia, Senator Judge De La Rosa, Senator Judge Ejercito, Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the presiding officer, Senator Judge Escudero, Senate President Gatchalian.
With 20 senators present, the chair declares the presence of a quorum. In accordance with the rules of procedure on impeachment trials, the chair now recognizes the duly elected presiding officer to preside over the proceedings of the impeachment court.
Thank you, Mr. Senate President. The chair would like to defer action or approval on the journal as we await the manifestations of some of our senator judges. However, having said that, before we end today's trial, regardless of the submission of the senator judges who manifested their intention to so submit their manifestations, we will have to approve the journal already so that we can furnish the parties with a copy, because as requested by counsel for the respondents, they would want an official copy of yesterday's ruling in order to afford them sufficient time to avail of whatever remedies they may want to seek in regard to the ruling in whole or in part. So for the information of the counsel for the parties, we shall be approving the journal within the day. You shall have a copy of the same before today's trial ends. This is also to inform the senator judges to make their submissions at the soonest possible time. Otherwise, it shall only be made part of the transcript and the records and will no longer be made part of the journal. So ordered, and for the information of the body, the clerk of court will please call the case before the impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances of the parties, please.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready for the presentation of our next witness, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honors. Same appearance for the defense.
May we know who on the part of the counsel, who among the panel of prosecutors or counsel from the panel of prosecutors will be presenting the witness?
This representation, Your Honor, will be presenting the next witness.
May I know likewise on the part of the counsel for respondents who will be standing on the other side? Will it be you, Attorney Villanueva?
That's correct, Your Honor.
You may proceed, lead prosecutor, call your first witness.
Your Honors, we are calling to the witness stand our next witness, the last witness for Article 4 threat, Attorney Melvin Matibag, the NBI Director.
kindly remain standing. Director Matibag, the clerk will kindly administer the oath to the witness. Kindly turn on the mic of the clerk of court.
You, Melvin A. Matibag, do swear that the evidence you shall give in the case now pending between the Philippines and Vice President Sara Duterte shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Kindly sit down, Director Matibag.
May we
Before the lead prosecutor proceeds with their direct examination, the chair would like to address the witness regarding certain matters. Director Matibag, the chair would like to remind and admonish you on behalf of the impeachment court to kindly avoid statements pertaining to individual members of this impeachment court. Without prejudice to any investigation you're undertaking, you may do so, but without need of issuing statements that may impinge upon the independence and or integrity of the court or the individual senator judges. And for this reason, for your information as well, Attorney Director Matibag, these statements made by Senator Judge Alan Peter Cayetano and Senator Judge Pia Cayetano last July 15, pertaining to statements made by you and the video presented in the impeachment court shall be referred to the Senate as a legislative body and referred to the appropriate committee, specifically the Rules Committee, for its proper disposition and for the matter to be taken up thereat, and not in this impeachment court. I hope you will hear and understand, Director Matibag, the reminder and the admonition of the chair.
Yes, Your Honor.
Thank you, Director Matibag. Lead prosecutor, the Honorable LIVESTREAM, you may proceed with your direct examination.
Your Honor, we are offering the testimony of witness NBI Director, Attorney Melvin Matibag, to prove the following. 1. Siya ang kasalukuyang direktor ng National Bureau of Investigation. 2. Matapos siyang italaga bilang direktor, may binuo siyang special task force para magsagawa ng investigasyon sa patuloy na mga pagbabanta sa buhay ng Pangulo. 3. May karagdagang investigasyon na isinagawa ang Special Task Force hinggil sa mga pagbabantang ginawa sa buhay ng Pangulo kasama ang pagbabanta ng Vice Presidente. 4. Ang pagbanta sa buhay ng Pangulo ay hindi lamang pagbanta sa kanyang buhay, kundi pagbanta sa pambansang seguridad. 5. Ang mga natuklasan at naging resulta ng Special Task Force mula sa karagdagang investigasyon. 6. Kilalanin at patunayan ang mga dokumento kaugnay ng nasabing investigasyon ng NBI. 7. Ang iba pang mga bagay na may kaugnayan at mahalaga sa nagaganap na impeachment trial ng Vice Presidente.
Comments, Your Honor.
Then,
Your Honor, as to the first purpose, we are willing to stipulate, Your Honor, that Attorney Matibag is the current NBI Director. In the interest of expediting the proceedings, no need to propound questions on that. Number 2, as to the task force, Your Honor, we would have to object thereto on the basis of them being irrelevant. Your Honor, would just like to manifest for the record that such task force, Your Honor, was not part of the articles of impeachment as well as the impeachment complaint. There was no mention thereof, and this is tantamount to a new information. So, Your Honor, we just like to manifest for the record that the articles of impeachment is akin to a information that is filed in court, and the trials already started, and the prosecution cannot modify such information or articles of impeachment, for such will be a violation of our client's right to due process, particularly her right to be promptly and fully apprised of the exact charge against her. So any new information is irrelevant. Number 3, same objection, Your Honor, because the good counsel mentioned karagdagang investigation. So it pertains also to a new information which is irrelevant. Number 4, we would have to object because the good counsel used the word banta, which is a conclusion of fact. She mentioned it twice. So we are objecting on the basis of it being conclusions of fact. Number 5, as to the special task force, same objection, Your Honor, considering that, again, there was no mention of such information, new information in the articles of impeachment. Number 6 and 7 are okay, Your Honor.
Would the lead prosecutor care to respond?
We would like to respond, Your Honor.
The lady may proceed.
Your Honor, maliwanag po sa naging banta ng Vice Presidente kaugnay ng November 23, 2024 na video. May kinausap siyang tao kaugnay ng kanyang banta sa buhay ng Presidente, ng First Lady at ng dating Speaker. Later, Your Honor, we will present that this special task force was specifically created for the purpose of furthering the investigation because of the possibility of seeing na hindi po mag-isa ang Vice Presidente sa bantang ito. In other words, Your Honor, the mention of special task force, including its creation at ang karagdagang investigasyon nito, passes the test of relevance. As a matter of fact, this is the very reason why we are presenting Attorney Melvin Matibag, the NBI Director, before the Honorable Impeachment Court. Your Honor, the defense likewise mentioned that special task force was not mentioned in the articles of impeachment. Nais ko pong ibalik ang naging desisyon ng kagalang-galang na impeachment court kahapon, kaugnay ng mga dokumento which pertains to acts and omissions prior to 2022 and acts or omissions which were not specifically mentioned in the articles of impeachment. Ang mahalaga po dito, Your Honor, ay itong mga aligasyon or testimony to be presented ay may kaugnayan o relevant sa article of impeachment. It is not necessary that they be specifically mentioned in the articles of impeachment. Finally, Your Honor, they likewise raised the issue of due process of the respondent. It is very much apparent, Your Honor, since day one of our impeachment trial, the respondent is very well represented by her very much able defense panel. In other words, Your Honor, atin pong ibinibigay ang nararapat na due process sa respondent Vice President in as far as this impeachment trial is concerned, kasama na po ang pagtestigo ni NBI Director, kaugnay ng Special Task Force at ang mga naging investigasyon nito.
Just a short rejoinder, Your Honor.
Counsel for respondent may do so before the chair makes a ruling on the offer and the comments to the offer. You may proceed, Attorney Binlon.
Your Honor, considering that the prosecution mentioned dates prior to the appointment of Director Matibag, then we would also add as basis for our objection his lack of personal knowledge.
Noted. Chair will now make a ruling. Chair reminds the lead prosecutor to skip the introduction and preliminary questions with respect to the witness being the current NBI Director, having been admitted by the counsel for respondent. Insofar as the phrase banta is concerned, Chair would like to remind the Senator Judges that that is indeed a conclusion which the prosecutors will seek to prove. For our purposes, tawagin na lamang natin o ituring na lamang natin ang mga pahayag ang binitiwan ng ikalawang Pangulo But lead prosecutor, kindly let the witness testify and characterize it as such if he will, but it should come from the witness and not from any of the counsel for the parties. As to the task force, the task force was formed on April 16, 2026, after the impeachment complaints have been filed. Although the impeachment complaint was filed before the Senate in May, the impeachment complaints were already filed prior to the formation of the task force. And as a last point, this, if at all, would show persistence, absence or lack of it, which is an element of the crime of grave threats, which the prosecution is seeking to prove. Again, not through their statements, but through the witnesses they will be presenting in the person today of Director Matibag. The chair will therefore allow the testimony, and the counsel for the respondent may object at any time with respect to the points he raised, and the chair will rule each time an objection is raised regarding that matter without prejudice. I'm already seeing what Attorney Binloan will do because he's reaching for the mic. Without prejudice to the counsel, of course, making a continuing objection with respect to his observations to the offer, so that we would abbreviate the proceedings and he won't need to object each time if at all it is brought up. Would that be correct, Attorney?
Yes, Your Honor, we register our continuing objection and everything subject to cross, Your Honor.
Noted. The lead prosecutor may proceed. Your witness.
Mr. Witness, pakisabi po ang inyong pangalan, edad, at iba pang pagkakakilanlan.
Ako po ay si Attorney Melvin Matibag na kasalukuyang Director ng National Bureau of Investigation. Ang aming pong tanggapan ay may address na 9th floor Philinvest Cyber Zone Building, Tostado, Macapagal, Pasay City.
Nabanggit mo na ikaw ay isang abogado. Gaano ka na katagal sa nasabing propesyon?
29 years po.
Saan ka nagtapos ng iyong abogasya?
Sa Ateneo Law School po.
Bago ang iyong abogasya, ano ang una mong inaral sa kolehiyo?
Ako po ay nagtapos ng Bachelor of Arts, major in Philosophy sa University of Santo Tomas.
Pagkatapos naman ng abogasya, Mr. Witness, ano ang iyong inaral kung mayroon man?
Nag-aral po ako ng Masters of Law, major in Corporate and Finance Law sa Wayne State University, Detroit, Michigan, USA po.
You are here as NBI Director. Bago ka itinalaga bilang NBI Director, ano ang iyong mga naging trabaho kung mayroon man?
Bago po ako itinalaga na NBI Director, kasalukuyan po ako naglilingkod bilang Dean o Dekano ng Lyceum Alabang College of Law.
Nabanggit mo na ikaw ay dating Dean ng Lyceum College of Law, Alabang. Bukod sa pagiging Dean, ano pa, kung mayroon man, ang iyong naging trabaho bagong iyong pagkatalaga bilang NBI Director?
Ako po ay nanungkulan na rin sa iba't ibang kapasidad sa ilalim po ng iba't ibang administrasyon. Una-una po rito bilang Director ng Laguna Lake Development Authority sa administrasyon po ni dating Pangulong Gloria Macapagal Arroyo.
Nabanggit mo na ikaw ay naglingkod bilang Director ng Laguna Lake Development Authority panahon ng dating Pangulo, Gloria Macapagal Arroyo. Ano pa, Mr. Witness, kung mayroon man, ang iyong naging trabaho bago ka itinalaga bilang NBI Director?
Sa administrasyon po din ng dating Pangulong Gloria Macapagal Arroyo, ako rin po ay nanungkulan bilang General Manager ng Manila International Airport Authority at sa administrasyon din po ng dating Pangulong Rodrigo Roa Duterte, ako rin po ay nanungkulan sa iba't ibang kapasidad po.
Nabanggit mo na sa ilalim ng administrasyon ni Pangulong Duterte, nanungkulan ka rin sa gobyerno. Ano itong mga posisyon mo sa gobyerno na iyong nabanggit?
Objection, Your Honor. Relevance.
Your Honor, may I
Counsel
respond?
may answer. Counsel may respond,
The
rather.
prosecution, Your Honor, is establishing the competence of the witness the qualification as an official of the government. We are establishing, Your Honor, that he is loyal to his duty regardless of the principal he is serving.
Wind up with your preliminaries, counsel. Witness may answer. Objection overruled.
Thank you, Your Honor. Ako po'y nanungkulan bilang Presidente at CEO ng National Transmission Corporation mula po noong January 2017 hanggang Marso 2022 at pagkatapos doon ako po'y tinalaga bilang Cabinet Secretary po ng dating Pangulong Rodrigo Roa Duterte.
Kaugnay pa rin ng iyong pagiging NBI Director. Kailan ka itinalaga sa nasabing posisyon?
Ako po ay nai-appoint noong pong February 20 ng kasalukuyang taon po.
Mr. Witness, bilang NBI Director, ano ang iyong mga responsibilidad at kapangyarihan kung iyong nalalaman?
Objection, Your Honor. We already stipulated on this matters. No need for the Director.
Your Honor?
Did you stipulate, counsel, as well as with the powers, responsibilities of
We're willing to stipulate, Your Honor, as what
The
the law
Director?
provides.
Your Honor, regardless of the position of the defense to stipulate on the fact pertaining to the powers and responsibilities of the NBI Director, it is the position of the prosecution that since this is a constitutional process, mahalaga po na marinig ng ating mga iginagalang na senator judges, ganun din ng mga kababayang nanonood kung ano talaga ang responsibilidad at kapangyarihan ng isang NBI Director.
Understood, counsel, but it has been stipulated already by counsel for the respondent. So kindly go straight to the matter at the soonest possible time. You're on a short leash with respect to the preliminaries on the qualifications of the witness. Kindly proceed, ma'am.
Mr. Witness, ano ang iyong mga kapangyarihan at responsibilidad kung iyong nalalaman?
Ang kasama po dito sa aking mga responsibilidad, ang una-una na po, we are the primary investigating authority ng ating pong bansa. Kung kaya po, ito po ay aming mandato na mag-imbestiga sa anumang usapin o mga maaring krimen na pumapasok sa amin. At kasama rin po dito ang pagbabalangkas ng mga polisiya at pagbubuo po ng mga units or division kung kinakailangan at ang pagmamanage din po administratively po ng aming opisina.
Sa mga kapangyarihan at responsibilidad na iyong binanggit, ano ang araw-araw mong ginagampanan kung mayroon man at kung iyong nalalaman?
Ang araw-araw pong pagbabantay at pakikipag-ugnayan sa aming mga ahente dahil po sa araw-araw namin pag-iimbestiga ng iba't iba pong usapin na pumapasok po sa aming ahensya.
Kaugnay pa rin ng mga binanggit mong kapangyarihan at responsibilidad, ano ang pinakamabigat mo na responsibilidad bilang NBI Director kung iyong nalalaman?
Objection, Your Honor. Calls for an opinion.
Witness may answer. I think witness is competent enough to answer that question.
Thank you, Mr. Presiding Officer. Ang akin pong hindi lamang po bilang primary investigating agency, kundi ang amin pong primerong ginagawa ay ang pagbabantay para po sa ating mga taong bayan at bantayan din po ng ating konstitusyon ay may patupad at siguraduhin na hindi po nagkakaroon ng kaguluhan at ligalig para ito po ay puksain, habulin at amin pong kung kinakailangan ay kasuhan ang mga taong lumalabag po sa aming pong mandatong binabantayan.
Chair would like to remind the lead prosecutor to go into the meat of her direct examination already. I think we've heard enough of the preliminaries insofar as Director Matibag is concerned. Kindly proceed, ma'am.
Your Honor. Mr. Witness, naririto ka upang tumistigo sa impeachment trial na ito. Ano ang pagkakakilanlan ng respondent sa impeachment trial na ito kung iyong nalalaman?
Malinaw naman po na ang nasasakdal po sa impeachment trial na ito ay ang ating pong Vice Presidente na si Vice President Sara Duterte.
Bukod sa ang respondent ay ang Vice Presidente, ano pa kung mayroon man ang pagkakakilanlan ng respondent sa impeachment trial na ito?
Base po sa aking mandato bilang direktor nang ako po ay pumasok sa aming opisina, lahat po ng mga kasong nakabinbin at mga amin na naipasok sa Department of Justice ay akin pong niribisa at tiningnan upang akin po itong masubaybayan. At isa po sa mga kasong aking nakita rito, ang respondent po rito ay ang ating pong Vice Presidente, kung saan po siya ay kinasuhan ng aming Cybercrime Division ng grave threat at inciting to sedition na kasalukuyan po ngayong nakabinbin sa Department of Justice.
Nabanggit mo na ang respondent ay may kasong grave threat at inciting to sedition sa DOJ. Mr. Witness, ano pa kung mayroon man ang pagkakakilanlan ng respondent sa impeachment trial na ito?
Ang ating pong Vice Presidente kasalukuyang ating pong subject sa ating continuing investigation dun po sa pagbabanta at plano na pagpatay po sa ating Pangulo, sa First Lady at sa dati pong Speaker of the House.
Mr. Witness, may binanggit ka na continuing investigation ng NBI. Ano ang iyong ginawa kung mayroon man kaugnay ng ongoing investigation ng NBI na iyong binanggit?
Tayo po ay nagtatag ng tinatawag ko ni Special Task Force po sa pamamagitan ng pag-create po ng isang administrative order kung saan bumalangkas po tayo ng mga miyembro ng aming pong opisina para sila po ang magtuloy ng investigasyon na ito at mag-monitor po ng mga kailangang gawin.
Kaugnay pa rin ng binanggit mong Special Task Force. Ano ang kahalagahan nito sa investigasyon na ginagawa ng National Bureau of Investigation?
Napakahalaga po para sa amin sapagkat from our law enforcement perspective, ang ginawa pong banta ng Vice Presidente ay tinatrato na namin hindi banta kundi isang plano para po sa pagpatay sa ating Pangulo. And that is a threat to the President which we consider also na threat po sa ating national security.
Mr. Witness, anong katunayan mayroon ka? Kaugnay ng iyong binanggit na binuong Special Task Force upang mag-imbestiga sa lahat ng banta sa buhay ng Presidente kasama na ang pagbabanta ng Vice Presidente.
Meron po akong inisyu na Administrative Order number 11 noong April 16 ng kasalukuyang taon po.
At kung ipapakita sa iyo ang kopya ng Administrative Order number 11, ito ba ay makikilala mo?
Opo.
Your Honor, may we request that AO number 11, previously marked as Exhibit P429, be flashed. We likewise request, Your Honor, that Attorney Kyle Kapunan, Assisting Counsel, be allowed to approach the witness for confirmation of the document.
Assisting counsel for the prosecution may approach, and likewise, assisting counsel for the respondent may approach to confirm and validate the document being shown to the witness. Likewise, the tech through the clerk of court is instructed to kindly flash in the screens the document being referred to by the lead prosecutor, the Honorable LIVESTREAM. Kindly zoom it in, please.
Mr.
Thank you.
Witness,
Your Honor, can we be
Attorney
given time
Binloan
to
is
comment?
recognized.
Your Honor, we manifest for the record, Your Honor, that the document is a photocopy.
So noted. Thus, the lead prosecutor confirmed the observation of the counsel for respondents while we are awaiting, the respondent rather,
Your Honor,
while we are awaiting for their review of the document.
Your Honor, after the confirmation of the document, the prosecution will be requesting for the transfer of marking to a certified true copy, Your Honor.
At a later time.
Yes, Your Honor.
Noted. Counsel may proceed when she's ready.
Mr. Witness, ipinapakita sa iyo ngayon May we request the assisting counsel to please show the document to the witness?
Attorney Kapunan, kindly.
Mr. Witness, ipinapakita sa iyo ngayon ang isang dokumento na may pamagat na Administrative Order Number 11. Ano ang kaugnayan nito sa binanggit mo kanina na Administrative Order Number 11 na kung saan nabuo ang Special Task Force?
Ito po yung aking dokumentong binabanggit.
Sa pangalawang pahina ng Administrative Order Number 11, makikita ang isang lagda sa taas ng pangalang Attorney Melvin Matibag. Kaninong lagda ito, Mr. Witness?
Sa akin po.
Your Honor, may we manifest that AO number 11 has been previously marked as Exhibit P 429, and we just want to place on record the request for the transfer of marking at a later time to the certified true copy, Your Honor.
Noted.
Kaugnay pa rin ng Administrative Order Number 11, Mr. Witness. Ano ang komposisyon ng Special Task Force kung iyong nalalaman?
Ito po ay binubuo ng iba't ibang division na pinamumunuan po ng aming pong team leader na Deputy Director for Operations at dalawa po na assistant team leader sa pangunguna po ng Assistant Director namin for Investigation at Assistant Director for Intelligence po.
Nabanggit mo ang team leader at assistant team leader ng Special Task Force. Sino naman ang mga miyembro ng Special Task Force kung iyong nalalaman?
Your Honor, hindi po sino, kundi ito po ay mga grupo, specific units po. Isa na po rito ang National Capital Region Division namin, ang Cybercrime Division po namin, ang aming pong OCTD, Organized Crime, Transnational Crime Division, ang TID po at ang CFD.
Mr. Witness, nabanggit mo ang National Capital Region Division. Ano ang dahilan at isinama ang National Capital Region Division sa miyembro ng Special Task Force kung iyong nalalaman?
Sapagkat ang pag-iimbestiga po at ang continuing na surveillance ay tungkol sa banta sa kaligtasan po ng ating Pangulo at ang primerong opisina at tirahan po ng ating Pangulo ay nasa National Capital Region, kung kaya naman po ating pong isinama rito ang National Capital Region bilang miyembro po ng Special Task Force na ito.
Mr. Witness, binanggit mo din kanina ang Cybercrime Division. Ano naman ang dahilan kung iyong nalalaman? Bakit ginawang miyembro ng Special Task Force ang Cybercrime Division?
Ang Cybercrime Division po ay kasama dito sa task force na ito sapagkat marami po ngayon na nabanta na pumapasok po sa ating Pangulo sa pamamagitan po paggamit ng social media platform at ang CCD po, sila po yung may karanasan at kaalaman po na sapat para bantayan po ang mga bantang papasok dito sa pang-araw-araw po.
Mr. Witness, binanggit mo din ang Organized Transnational Crime Division. Ano naman ang dahilan at isinama ito sa Special Task Force kung mayroon man?
Hindi naman po lingid sa atin na ang ating Pangulo ay may mga pagkakataon na lumalabas ng ating bansa at nagbabiyahe na kung saan ay ating pa rin pong tungkulin na bantayan ang kanyang seguridad kahit siya ay nasa labas sa ating bansa. At ang ating pong Organized Transnational Crime Division, sila po yung merong ugnayan sa ating pong mga counterparts sa iba't ibang bansa upang ating pong maisiguro ang kaligtasan po ng ating pong Pangulo habang siya ay nasa labas ng ating bansa.
Mr. Witness, kasama sa iyong binanggit ang Technical Intelligence Division. Ano naman ang dahilan at kasama ito sa miyembro ng STF kung mayroon man?
Napaka-importante po ng role ng TID, ng Technical Intelligence Division, sapagkat ang mga banta po na katulad ng pumapasok po sa ating Pangulo ay nangangailangan po ng masusi at malawak na intelligence network. At ang TID po natin, sila po ang may karapatan dito at nagpuproseso ng mga ganito pong gawain.
Bilang huli, Mr. Witness, binanggit mo din ang Digital Forensic Laboratory Division. Ano naman ang dahilan at isinama ito sa miyembro ng Special Task Force?
Importante po ang kanilang role dito sa task force na ito sapagkat lahat po ng mga ebidensya na ating makakalap, lalong-lalo na nakailangan pong idaan sa forensics o pagsusuri na technical, sila po ang dibisyon na maaari pong gumawa ng pagsusuri na ito.
Maraming salamat sa iyong paglilinaw kaugnay ng komposisyon ng Special Task Force. Mr. Witness, anong mga pagkakataon kailangan ng NBI bumuo ng task force kung iyong nalalaman?
Ang pagbuo ng task force ay yung mga immediate po na pangangailangan nating tugunan. Isa po yan. Pangalawa po rito ay kung isa ng malawakan ang isang bagay na kailangan nating tugunan at imbestigahan. At ang task force din po, kaya po ganyan kalawak kung makikita ninyo, ay kung ang nasasakupan po nito ay hindi lamang iisang lugar. At yung pong mga seryosong banta, na katulad ng banta sa ating Pangulo, ganitong task force po ang pakiramdam namin na kinakailangan.
Mr. Witness, balikan ko ang Special Task Force na iyong binuo. Kanina, ibinahagi mo ang komposisyon nito. Ano ang iyong partisipasyon bilang NBI Director kung meron man sa investigasyon ng Special Task Force?
Nakasad po dyan sa administrative order na yan na ang patuloy na pakikipag-ugnayan po sa Office ng Director, patuloy na pag-uulat kung ano man po ang kanilang nakikita o namomonitor, at lalong-lalo na po kung may specific po na kailangang kaagad matugunan, dapat pong ipaalam sa opisina po ng Office ng Director.
Balikan natin ang Special Task Force na binuo sa ilalim ng AO number 11, Mr. Witness. Ano ang nagtulak sa'yo kung mayroon man upang buuin ang Special Task Force na ito?
Ang akin na po nabanggit, ang malinaw na banta at planong pagpatay po sa ating Pangulo na para sa amin po sa law enforcement, ito ay nag-transcend na sa banta po sa ating national security. Sapagkat anuman pong banta sa ating Pangulo ay banta sa seguridad ng ating bansa. Sapagkat ito'y magdudulot ng kaguluhan, ng ligalig at destabilisasyon po sa ating pong gobyerno at sa ating pong bansa.
Nabanggit mo na ang banta sa buhay ng Pangulo ay banta na rin sa national security. Ano pa, Mr. Witness, kung mayroon man ang nagtulak sa'yo upang buuin ang Special Task Force na ito?
May mga pangyayari po na atin pong nasaksihan na nagpatunay na ang banta ay seryoso. Katunayan po, ang aming investigasyon ngayon ay tumawid na sa hindi banta, kundi isang plano talaga na patayin po ang ating Pangulo ng Pilipinas. Sapagkat doon po sa ating mga inobserbahan na tinatawag dating open source intel, manilaw po roon ng ating Vice Presidente, sinabi mismo na siya ay kumausap na ng papatay at pumayag yung papatay na yan sa ating Pangulo ng Pilipinas.
Mr. Witness, bukod sa iyong nabanggit kung saan may kinausap ang Vice Presidente na papatay sa Pangulo, ano pa kung mayroon man ang dahilan o nagtulak sa'yo upang buuin ang Special Task Force?
Kung makikita po ninyo doon sa whereas clauses ng Administrative Order 11, ang nag-isa pong nagpatibay rito ay yung aming napanood na live broadcast po ng isang rally na tinatawag na Rage Coalition. If I remember it correctly, it's April 12 na nagsasalita ang mayor ng Davao City na si Mayor Sebastian Duterte na sinabi niya na isang ulo lang naman ang kailangan namin at yan ay ang ulo ni Bongbong Marcos. Yan po ay aming isinama sa aming factor upang buuin po itong ating Administrative Order number 11.
May nabanggit ka na Rage Coalition Rally noong April 12, 2026. Ano itong insidenteng ito, Mr.
Objection,
Witness?
Your Honor, relevance. We ask for the relevance, Your Honor.
Part of the witness's narration, counsel, you're on a short leash again, kindly connected to this case.
Your Honor, this
Witness may answer.
Dito po sa rally na ito ay nakita natin doon pa lang pa sa pangalan na sinasabing rage ito po ay may interpretasyon base sa aming law enforcement experience na pag sinabing rage, galit, poot, at ang mga personalidad po na dumalo rito, ay makikita nating mga personalidad na kilalang tumutuligsa at naglalabas ng destabilisasyon po sa atin pong gobyerno ngayon. Makita po natin ang presence ng iba't ibang personalities dyan na consistent na nagdudulot ng ligalig po sa atin pong bansa.
Mr. Witness, kung ipapakita sa iyo itong videong ito ba'y makikilala mo?
Opo.
Anong partikular na bahagi ng videong ito ang tumutukoy sa iyong sinabi kung saan may binanggit si Mayor Sebastian Duterte?
Mr. President, we be allowed
Objection,
to
Your
check
Honor.
on the timestamp.
Let's listen to the council's objection first. Attorney Vinluan, what is your objection?
Again, irrelevant, Your Honor.
Same ruling. Council, go to it directly, and I hope you will connect and make the connection between this video and the matter at hand. Yes, Director Matibag, you may proceed to open the US. Are you referring to your notes, rather?
Opo, yung po aking investigation.
You may refer to your notes,
Kung saan
Director Matibag.
po nakasulat ang timestamp nung video na akin po binabanggit.
Your Honor, may we be allowed also to peruse
Counsel
that-
for assisting counsel for the respondent may look at the document being reviewed by the witness. Likewise, should the prosecutor wish to do so, assisting counsel for the prosecutor may also stand up and accompany assisting counsel for the defense. You may proceed, Director Matibag, to answer.
Yan po ay nasa timestamp 2:34:35 to 2:34:43.
Your Honor, we are requesting that the video of Mayor Sebastian Duterte during the Rage Coalition on April 12, 2026, which has been previously marked as P430, particularly timestamp 2:34:35 to 2:34:43, be flashed, Your Honor.
The tech is directed to kindly play the timestamps mentioned. May I request assisting counsel from the defense to kindly witness the breaking. Is the USB sealed, counsel? Has
I
the
believe,
seal
Your
been
Honor.
broken? Witness is instructed to break the seal while being witnessed by assisting counsel for both parties before it is presented to the tech for it to be played.
Ayaw.
While the witness is breaking the seal and giving it rather to the counsel for the prosecutor and assisting counsel for the respondent, Chair would like to make a manifestation with respect to the proceedings. Earlier, the Chair intimated to some senator judges, as far as practicable, to make their interjections and interventions after the party shall have examined the witness, both direct, cross, redirect, and recross, if any, unless the matter is of urgent, administrative, or procedural concern, in which case it may be brought up even before the examination of the witness by the parties. But as far as practicable, let us allow the parties to finish the examination of the witnesses by themselves, because this is more of a trial really than merely seeking clarificatory questions when the counsels can elicit that from the witness anyway. Yes, are we ready to play the video?
Tama na yan. That's okay. Isang ulo lang naman ang kailangan namin. Ang ulo ni Bongbong Marcos!
Mr. Witness, napanood mo ang video. Ano ang kaugnayan ng video na ito sa insidente ng Rage Coalition na tinukoy mo kanina?
Yan po yung aking tinutukoy na video.
Ano ang partikular na sinabi ni Mayor Sebastian Duterte sa nasabing insidente kung iyong naaalala?
Sinabi po niya na isang ulo lang naman ang kailangan namin, ang ulo ni Bongbong Marcos.
Mr. Witness, ano ang kahalagahan ng insidenteng ito sa Rage Coalition sa investigasyon na ginagawa ng Special Task Force kaugnay ng banta ng Vice Presidente sa buhay ng Presidente?
Objection, Your Honor. Up to now, the prosecution has not established the relevance of these incidents to the matter at hand, Your Honor.
Your Honor, I'm
We're
in the
objecting on the basis
process.
of irrelevance, Your Honor.
I'm in the process of establishing the relevance already, Your Honor.
Counsel, kindly do so as best you can with the shortest possible time. I will allow it.
Yung pong video na yan ay amin pong naikumpara sa mga naging pahayag ng ating Vice Presidente na kung saan meron din po kaming bidyong binalikan na ang ating Vice Presidente ay nagre-repair din po sa pagtanggal ng ulo ng ating pong Presidente. Kung kaya't nakita namin po ang pagkakahambing ng statement po ng ating pong Mayor at ng Vice President Sara Duterte.
Mr. Witness, binanggit mo ang isang insidente kung saan sinabi ng Vice Presidente gusto tanggalin ang ulo ng Presidente. Ano itong insidenteng ito kung iyong nalalaman?
Sa aking pong recollection sa iyong pag-iimbestiga, ito po yung kanyang press conference noong October 18 ng 2024 kung saan sinabi niya, gusto kong tanggalin ang ulo niya ba? At sinabi rin po niya nga, imagine cutting his head. So yan po ang binabanggit ko na video.
Kaugnay ng sinabi niya na gusto ko tanggalin yung ulo niya ba? Anong partikular na bahagi ng binanggit mo na video ang tumutukoy sa sinabing ito ng Vice Presidente?
Mr. Presiding Officer, respectfully, with your permission, for the timestamp, I want to refer to my
Witness
notes.
is allowed to refer to his notes
Salamat
with the
po.
assistance and within the view of the counsel, assisting counsel for the respondent and the prosecution if they so desire.
Your Honor, can we ask permission to scan the whole notebook, Your Honor? Or at least the salient portions of the notebook, Your Honor.
It's a memorandum. To look at it, to scan it, to see that if baka may mga nakasulat na iba dyan na wala nang kinalaman. Just to confirm that it is indeed his notes with respect. What is the book you are referring to or notebook you are referring to, Attorney Matibag?
Mr. Presiding Officer, actually, diary ko po ito at saka notes Combination. So kung makikita naman po, mula pa noon, iba't iba pong nakasulat dito. May mga personal po, may mga usapin. Ito lamang pong notes ko na to, nakatuon dun sa date kung saan po nagkaroon na ng investigation po yung Administrative Order number 11.
Then just the salient portions, Your Honor.
Your Honor, just for the record, we would like to invoke the right of the witness to refer to his notes because that note pertains to investigation notes which were prepared, done, written at the time of the investigation, Your Honor. That is to refresh his memory, Your
No,
Honor.
the presiding officer already allowed it. Counsel for the respondent, your assisting counsel is there. Without necessarily scanning the whole notebook, which might contain other confidential or perhaps personal information, he may observe what the witness is referring to, and you may make your observations known to the record should he observe something out of the ordinary. Witness may answer.
Ang timestamp po dun sa sinabi kong gusto kong tanggalin yung ulo niya ba is from 1:35:57 to 1:36:10 po.
Your Honor, may we request that the video of the Vice President on October 18, 2024, during her press conference, previously marked as P411, particularly timestamp 1:35:57 to 1:36:10, be played, Your Honor.
Has the USB seal been broken by the witness? If not, witness is instructed to kindly break the seal of the marked evidence in full view of the assisting counsels for the parties. Thereafter, for the USB to be brought to the tech booth, and the clerk of court is instructed to have it played with respect to the identified timestamps of Director Matibag.
gusto ko tanggalin yung ulo niya ba?
Mr. Witness, napanood mo ang video.
The video is still playing, I believe, lead prosecutor. Unless you want it cut already.
Yung times.
It may be cut, Your Honor.
I'm sorry? Do you
It may
want...
be cut, Your Honor.
Okay.
The timestamp is only 1:35:57 to 1:36:10. Mr. Witness, napanood mo ang video? Ano ang kaugnayan nito sa insidenteng tinukoy mo kanina kung saan sinabi ng Vice Presidente, gusto kong tanggalin ang ulo niya ba?
That is the same video that I was referring to.
Kanina, Mr. Witness, binanggit mo din na may sinabi ang Vice Presidente, I imagine myself cutting his head. Anong partikular na bahagi naman ng video na iyong tinukoy ang tumutukoy sa sinabing ito ng Vice Presidente kung iyong nalalaman?
Again, Mr. Presiding Officer may be allowed to look for the
Witness may do so.
Thank you po. Timestamp 136:52 po to timestamp 136:58.
Your Honor, may we request that the same video be played, particularly timestamp 136:52 to 136:58.
Pertaining to the same exhibit, counsel.
Yes, Your Honor. Same exhibit P411.
Tech is instructed through the clerk of court to kindly play the video.
Myself cutting his head.
Mr. Witness, napanood mo ang video. Ano ang kaugnayan nito sa insidenteng tinukoy mo kanina kung saan sinabi ng Vice Presidente, I imagine myself cutting his head?
Yan din po yung video ang aking tinutukoy.
Mr. Witness, kanina ay binanggit mo ang insidente ng Mayor Sebastian Duterte. Kaninong ulo ang kailangan nila kung iyong nalalaman?
Objection asked and answered, Your Honor.
Asked and answered. Move on, counsel.
Binanggit mo din ang video ni Vice President Sara Duterte. Mr. Witness, kaninong ulo ang gustong tanggalin?
Objection asked and answered, Your Honor.
Move on, counsel. Asked and answered. The court understands and knows who said the Vice President was referring to in that video.
Thank you, Your Honor. We will proceed. Ano ang obserbasyon mo dito sa video ni Mayor Sebastian Duterte at sa video ni Vice President Sara Duterte kaugnay ng investigasyon ng Special Task Force kung mayroon man?
Objection vague, Your Honor. Ano ang obserbasyon mo?
Kindly be more specific, counsel. Although the witness is competent, kindly be more specific so that the witness can more intelligently answer the question.
Mr. Witness, anong koneksyon, kung mayroon man, ang video ni Mayor Sebastian Duterte at ang video ni Vice President Sara Duterte sa kasalukuyang investigasyon ng Special Task Force?
Objection,
kung
Your
mayroon
Honor.
man
Objection,
at
Your
kung
Honor.
iyong nalalaman.
Objection, Your Honor. Still vague and asked and answered.
Witness may answer if he knows so that we can move on. Director Matibag, kindly respond.
Salamat po. Kapansin-pansin po na makikita natin na nanggagaling sa isang pamilya ang pagbabanta sa ating Pangulo at parehas na nag-refer sa ulo ng Pangulo. Kung kaya naman, iniisip po ba namin kung meron bang kasabwat o may sabwatan sa pangyayaring ito, sapagkat gaya po ng aking binanggit na noong November 23, binanggit po ng ating Vice Presidente na meron na siyang kinausap para pumatay sa ating Pangulo at pumayag siya. Kaya ito po ang amin pong tinututukan sa task force na amin pong itinatag.
Objection, Your Honor. We would have to object as to the answer being non-responsive, and we would like to move, Your Honor, that it be expunged from the record.
Your Honor, the witness has answered already, and that should form part of the transcript of our trial today.
Then we move to strike it off, Your Honor.
The objection is overruled and the motion to strike is denied. Let it remain in the records for the appreciation of the senator judges as to the weight they will give that particular part of the witness's testimony.
We will submit, Your Honor.
Mr. Witness, binanggit
Counsel may
mo
proceed.
kanina na may kinausap ng tao ang Vice Presidente. Ano ang kahalagahan nito sa inyong investigasyon sa Special Task Force? Kung mayroon man.
Sapagkat ito po yung amin mismong tinitingnan, sapagkat ang tingin nga po namin dito that the threat is serious, active, and continuing doon po sa banta sa ating presidente. At dahil ito ay seryoso, aktibo, at patuloy na umiiral, ay nagiging banta na rin po sa ating pambansang seguridad. Sapagkat anuman pong banta sa seguridad ng ating Pangulo ay banta po sa ating national security.
Mr. Witness, ano ang inyong obserbasyon kung mayroon man doon sa sinabi ng Vice Presidente na mayroon na siyang kinausap na tao?
Objection vague, Your Honor.
Your Honor, the witness is very much competent. Please allow him to answer the question.
Objection overruled. Witness may answer. Kindly move on, counsel. I think I know where you're getting at, but kindly move on toward your point. Witness may answer.
Ang obserbasyon po namin dito ay hindi na ito isang banta, kundi isang plano. Sapagkat ang tingin po namin dito ay inianunsyo ng ating Vice Presidente ang kanyang planong pagpatay sa Pangulo ng Pilipinas at mga nabanggit pa ang kanyang gustong ipapatay doon po sa kanyang pagbabanggit sa kanyang press conference.
Kanina, Mr. Witness, binanggit mo ang investigasyon ng NBI noong November 2024. Ano ang pagkakaiba kung mayroon man ng investigasyon ng NBI noong November 2024 sa kasalukuyang investigasyon ng Special Task Force na nagumpisa noong Abril 2026?
Malaki po ang pagkakaiba. Yung investigasyon po na natapos na ginawa noong November 24 na nag-iimbestiga doon po sa grave threat at sa inciting to sedition, ito po ay ordinaryong krimen na iniimbestigahan na sa ngayon po ay nakabinbinma sa Department of Justice para sa kanilang resolusyon. Pero ang amin pong iniimbestigahan ay sinuulit ko nga po, the serious, active, and continuing threat to the life of the President which already transcend to a national security issue. Sapagkat malinaw po na hindi na ito banta, kundi isang plano na patayin ang Pangulo ng Pilipinas.
With the permission of the Council of the Parties, Chair would like to clarify for the record and for the Senator Judges that the investigation conducted by the NBI in November of 2025, the witness was not yet the director at that time, but he can testify as to the fact that the agency he now heads conducted the investigation, but not as to the truth of the investigations conducted at that time, but as to the fact that investigations were conducted only. You may proceed, Counsel.
Mr. Witness, ano ang dahilan? Bakit kasama ang video ni Mayor Sebastian Duterte sa inyong sinasabi ngayon na ang bantang ito ay banta na sa national security kung mayroon man?
Objection asked and answered, Your Honor.
Asked and answered, Counsel. Move on.
Your Honor, as a matter of fact, we haven't asked that question and the witness is supposed to explain the reasons why the video was actually considered in their observation that this is a threat to national security.
I believe the witness already answered that any threat to the President is a threat to national security, to the national security of the country. And earlier, the Council already asked the relationship of the video to that statement of the witness, which the Chair allowed. We're already there, Counsel. Please move on.
Bilang karagdagan, Mr. Witness, sa iyong binanggit na issue ng national security, kaugnay ng video ni Mayor Sebastian Duterte, ano pa ang dahilan, kung mayroon man, kung bakit isinama siya sa pagsusuri ng Special Task Force?
Sapagkat dito lang nga po na makikita na ang naging pagbabanta ng ating Vice President ay nagkaroon po ng tinatawag natin na epekto. It is a kinetic force na kung saan yung mga nakarinig ng kanyang pagbabanta ay gumagaya na rin at nagbabanta. Lalong-lalo na sila ay nabibilang sa isang pamilya. That is the very purpose of the task force, to monitor all those threats na lumalabas po ngayon, at sa araw-araw nga, meron po tayong nakikitang threat sa social media, sa mga pahayag po during the mga rallies, ay tuloy-tuloy po na banta sa ating pong Pangulo na umaabot na po na banta sa ating national security.
Binanggit mo ang kinetic force. Anong ibig sabihin nito, Mr. Witness?
Na yung kanila pong aksyon ay nagkakaroon po ng epekto para kumilos sa mga nakakarinig, ang kanilang mga supporter, upang maghasik po ng ligalig at kaguluhan po sa ating pong bansa, at hindi na nirirespeto ang ating pong konstitusyon, at wala na rin pong pagtingin sa ating democratic process.
Ano pa ang dahilan, kung meron man, bakit isinama sa pagsusuri ang video ni Mayor Sebastian Duterte kaugnay ng Rage Coalition Rally?
Yung presensya...
Objection as unanswered, Your Honor.
Witness may answer.
Yung proseso po namin na yan, doon po namin nakita na sinasabi ko nga, yung mga participants dito, yung po mga kilala na mga tao na nagdudulot ng ligalig at pagtutol sa demokrasya po natin. At nandiyon din po yung broadcast na yan, napakarami pong naabot na tao, nasa 600,000 plus po yung live broadcast niyan. Doon na po papasok yung tinatawag ko nga kanina na sinabi kong kinetic force, na maaaring magkaroon po ng reaksyon ng mga taong nanonood na ito na hindi po maganda at makagugulo po sa pag-promote po natin ng law and order na primero po nagawain po dapat ng National Bureau of Investigation.
Binanggit mo na may mga kilalang personalidad na nakibahagi sa Rage Coalition Rally. Sino-sino itong mga ito?
Objection, Your Honor, irrelevant.
Witness may answer.
Makita po natin doon, may mga senador din po na nandoon. Nandoon din po si Mike Defensor, at nandoon po ang mga haligi po ng PDP Laban na akin po mga kakilala. Nandoon din po ang mga iba't ibang leader sa iba't ibang rehiyon na akin na pong nakasama noon nung ako'y miyembro pa ng PDP Laban.
Mr. Witness, ano ang ibig sabihin ng rage kung iyong nalalaman?
Objection, Your Honor, irrelevant.
I think Council has already made the connection between the rage, the statements of Mayor Baste, and the statements of the respondent. Witness may answer.
Sa Tagalog po niyan ay galit o puot. Yun po.
Wala pong acronym yon, Director Matibag?
Hindi po kasi tumutugma doon sa acronym nila, dahil yung acronym nila Reform Alliance for Good Governance. So hindi po rage eh. So medyo malayo po.
May proceed, Your
Council
Honor.
may proceed.
Nabanggit mo din, Mr. Witness, na maraming nanood ng videong ito. Ilan ang nanood ng videong ito kung iyong nalalaman?
Sa live broadcast po, lumabas po na nasa 600,000.
At ano ang kahalagahan na 691,000 ang nanood sa live broadcast ng videong ito kung mayroon man?
Again, ganoon na po kalawak yung nakikita natin na resulta ng pag-asik po ng ligalig po at pagbabanta po sa kayusan, pati na rin po sa seguridad ng ating Pangulo.
Mr. Witness, kanina binanggit mo ang pagkakaiba ng naunang investigasyon ng NBI sa kasalukuyang investigasyon ng Special Task Force ng NBI. Ngayon, ano naman ang ginawa ng NBI sa pagitan ng unang investigasyon kung saan na-file ang kasong grave threat at inciting to sedition sa DOJ, February 2025, sa kasalukuyang investigasyon ng Special Task Force na inumpisahan nung buuin ang STF April 2026. Kung mayroon man.
Ang sa pagkaalam
Council,
ko po,
you mean April 16, 2026. That's the, you're referring to AO11.
Yes, Your Honor.
Witness may answer.
doon po base po sa tanong ng mula February 25, 2025, ako po ay hindi pa NBI noon, subalit nung ako po ay nag-assume nung February 20, kasama po sa ating pinag-aralan yan, at alam naman po natin na ang mandato ng NBI ay ang patuloy na bantayan ng seguridad ng ating mga opisyales at siguraduhin na may law and order. So ako po na-appraise naman na tuloy-tuloy ang mga monitoring at consultation po at surveillance na ginagawa ng iba't ibang unit noon. Ngayon, nung ako naman po ay pumasok bilang NBI Director at atin pong pinag-aralan yung mga kaso. Noong April 16 nga po, itinatag na po natin ang task force na ito upang po matutukan ang mga issue na akin na nga pong nabanggit.
Mr. Witness, maraming salamat sa iyong paglilinaw, kaugnay ng nauna at ng kasalukuyang investigasyon ng NBI. Kaugnay pa rin ng Special Task Force, ano ang iyong naging direktiba kung mayroon man? Kaugnay ng video ni Mayor Sebastian Duterte noong April 12, 2026.
Akin pong ipinag-utos through the task force na may authenticate at may preserve itong video ito sapagkat amin pong iniisip na ito'y magiging material sa amin pong pag-iimbestiga at sa darating po na panahon na amin po itong gagamitin.
Mr. Witness, sino ang iyong inutusan upang ma-preserve at ma-authenticate ang video ni Mayor Sebastian Duterte na tinukoy mo?
Ito po ay aming naitoka kay Agent Edgar Apolonio po ng Cybercrime Division po.
Ano naman ang iyong patunay na ang videong ito ay na-preserve at na-authenticate ni Agent Edgar Apolonio kung mayroon man?
Ako po ay nakakuha ng kopya ng affidavit of authentication na ipinasa po sa aking tanggapan at akin po itong nahawakan po.
Your Honor, we are requesting that affidavit of authentication of Edgar Apolonio, previously marked as Exhibit P431, be flashed. Likewise, Your Honor, we're requesting that we allow assisting counsel to present the document to the witness for confirmation. Mr. Witness, we are presenting to you a document entitled Affidavit of Authentication. Ano ang kaugnayan nito sa Affidavit of Authentication ni Agent Edgar Apolonio na tinukoy mo kanina?
Ito po ang affidavit of authentication na akin pong binabanggit.
We manifest, Your Honor, that the same has been previously marked as Exhibit P431. Sa pahina 2, makikita isang lagda sa ibabaw ng pangalang Agent Edgar Apolonio. Mr. Witness, kaninong lagda iyan kung iyong nalalaman?
Kay Agent Edgar Apolonio po.
Mr. Witness, paano mo nalaman na ang lagdang iyan ay lagda ni Agent Edgar Apolonio?
Noong po ito'y sinumite sa aking opisina, siya po ay aking ipinatawag at tinanong ko kung siya ang gumawa at kung lagda niya po ito. Bukod po doon ay marami na po akong naiutos na ipa-authenticate sa kanya at iba pang dokumento na siya po ang lumalagda, kung saan nagkaroon na po ako ng familiarity doon sa kanya pong mga lagda.
Maraming salamat sa iyong paglilinaw. Ngayon ay puntahan natin ang investigasyon ng Special Task Force sa banta ng Vice Presidente sa buhay ng Presidente. Ano ang mga ginamit niyong batayan? Kung mayroon man sa inyong pag-iimbestiga sa Special Task Force sa banta ng Vice Presidente sa buhay ng Presidente?
Consistent po sa ginagamit po ng Protective Intelligence Methodology ng Secret Service ng Amerika. Diyan po sa tinatawag natin na if there is a threat to unknown personality, meron po silang mga pamantayan at doon din po namin ibinasa itong pamantayan na ito. 5 po ito na pamantayan namin pong ginamit.
Mr. Witness, binanggit mo na meron kayong ginamit na 5 pamantayan. Ano-ano itong mga 5 pamantayan na binanggit mo?
Una na po rito yung pattern of violence po.
Bukod sa pattern of violence, ano pa kung mayroon pa?
Yung pong gravity at seriousness po ng isa pong pangyayari.
Anong sunod dito kung meron pa?
Yung pong identity and identifying characteristic po ng involved po doon sa pangyayari.
Bukod sa identity, ano pa Mr. Witness kung mayroon man?
Ang isa po rito ay yung kakayanan po at kapasidad po ng nabanggit po na subject po.
At bukod sa 4 na iyong nabanggit, ano pa ang inyong ginamit na batayan kaugnay ng investigasyon na ito?
Yung pong tinatawag na motive o motibo at intent po ng personality po.
Mr. Witness, balikan natin ang pattern of violence na una mong binanggit kanina. Ano ang inyong sinuri, kung mayroon man, kaugnay ng pattern of violence ng Vice Presidente?
Sa tulong po ng amin pong Special Task Force ay amin pong binalikan ang mga pangyayari na yan naman po ay lumabas na tinatawag namin sa media na mga open source intel namin. At doon po nakita namin yung isang event nung mayor pa po ang ating Vice President Sara Duterte na meron pong isang sheriff na gustong gawin ang kanyang tungkulin na atas po ng legal na atas ng korte na magpatupad po ng demolition order. Subalit hindi po ito nagustuhan ng noon ay mayor at kay Vice Presidente, kung saan ay tinawag po niya yung sheriff at pinagsusuntok po sa mukha itong sheriff na ito.
Mr. Witness, binanggit mo ang isang insidente ng sheriff na pinagsusuntok sa mukha. May ipapakita ako sa iyong video.
Noong July 2011, habang nakaupong mayor ng Davao City, sinapak ni Vice President Sara Duterte ang isang court sheriff.
Ito ba ang insidenteng tinutukoy mo?
Tama po, yan po.
Bukod sa insidente ng sheriff na sinuntok ng Vice Presidente, ano pa kung mayroon man ang inyong sinuri kaugnay ng pattern of violence ng Vice Presidente?
As part of our investigation, kami po ay nakakakuha ng mga dokumento related po dito sa aming inimbestigan kung saan we got hold of affidavit of ito pong dating police ni si Arturo Las Canas na self-confessed member ng DDS na kung saan doon po sa kanyang affidavit na yan ay atin pong nakita at inilalarawan po at sinasabi nitong ni Arturo Las Canas na ang Vice Presidente mismo ay kasama doon sa Oplan Tokhang, isa sa mga arkitekto ng Oplan Tokhang. At dito rin po niya sinabi na instead na barilin at patayin para hindi nalalaman ng media, ay kidnapin na lamang yung mga subject po, mga shabu users o kaya yung pong ibang gumagawa ng krimen o nagtitinda ng droga at ibaw na lang po sa isang quarry. Na kung saan natagpuan po later nitong Laod Quarry na meron pong mga biktima ng extrajudicial killings.
Mr. Witness, nabanggit mo ang affidavit ni Arturo Las Canas. Nasaan ang affidavit na tinutukoy mo?
Objection, Your Honor. May we know the relevance of all these questions?
Your Honor, we are establishing the pattern of violence. And this is very much relevant.
Witness may answer.
Sa pagkakalam ko po, ang affidavit na ito ay nakasumito po sa International Criminal Court na sasulukuyan po dumidinig ng kaso ng extrajudicial killings po.
Kaugnay pa rin ng affidavit of Arturo Las Canas. Nasaan ang kopya nito kung mayroon ka man?
Meron po.
Objection, Your Honor. The witness is not competent to provide an answer on an affidavit that he did not execute.
Your Honor, may I respond?
Lead counsel may respond.
Your Honor, this affidavit of Arturo Las Canas can be considered as a declaration against interest. He's saying in the affidavit na siya ay hitman, na siya ay bahagi ng Davao Death Squad. And under the rules, Your Honor, this may be considered also even with respect to third party. And in this particular case, Your Honor, the Vice President, the respondent, is the third party.
Just a rejoinder, Your Honor.
Counsel for the respondent.
Then we would have to object to that, Your Honor, because it will be Mr. Las Cañas, if at all, who has the personal knowledge. We're already going into the contents of such affidavit, and the witness is incompetent to testify on that.
Chair will make a ruling. It is of no moment that it is a declaration against interest. Again, it is not an exception to the hearsay rule. It's certainly not a declaration against the interest of the witness. However, the court will allow it as part of the testimony and narration only of the witness, not as to the truth of the allegations of fact contained in the affidavit of Las Cañas, just as to the fact that the affidavit went through the office of the NBI director, that he knows of the affidavit, but certainly for the information likewise of the senator judges, not as to the truth of the allegations stated in the Las Cañas affidavit. Witness may answer.
Your Honor, we will submit, but we register continuing objection.
The continuing objection of the counsel for respondent is duly noted and entered into the records.
Mr. Witness, kaugnay pa rin ng affidavit ni Arturo Las Cañas. Nasaan ang kopya ng affidavit na ito?
Meron po akong CP.
Counsel, witness already answered. He said it is in the ICC, I believe.
Your Honor, I am pertaining to his actual copy.
You may proceed, counsel. Witness may answer.
Nandito po sa akin, dala-dala ko po yung kopya ng affidavit.
Your Honor, may we allow the witness to present his own copy?
Witness is allowed to produce a copy she is mentioning, is referring to rather in his testimony. For the record, assisting counsel for the respondent as well as assisting counsel for the prosecutors are viewing the document produced by the witness.
Your Honor, just a comment.
Counsel for the respondents recognized.
Your Honor, it appears that this document has not been marked during the pre-trial conference.
Your Honor, may I respond to that?
Not yet done with my manifestation.
Let the counsel for respondent finish, counsel.
So in other words, may we request, Your Honor, that we be given a copy of such document as well for our perusal.
The prosecutor is so instructed to kindly furnish a copy if indeed this document has not yet been marked.
Your Honor, may I respond to that?
Counsel may respond.
The affidavit of Arturo Las Cañas has been previously marked as P-2-10-1-W, Your Honor, for the prosecution.
Then I stand corrected, Your Honor, but can we still request for a copy?
Nevertheless, kindly give the counsel for respondents a copy.
We submit, Your Honor.
Counsels rather for respondent a copy. Thank you, counsel.
But we make the manifestation, Your Honor, that such
Counsel may proceed to make a manifestation.
that such exhibit was indeed marked, but it was marked under Article 2, Your Honor, not Article 4.
We confirm, Your Honor. Nevertheless, we maintain that this document has been marked during the pre-trial conference, Your Honor.
Duly noted.
Mr. Witness?
Ito yung copy. It's the same. May USB. May USB. Is this part of the mark? Oh, this is part of the mark. Just an additional comment, Your Honor.
Counsel may proceed.
It appears that the two documents are not the same in that the marked documents contains a page and attached thereto is an USB. However, the copy of Director Matibag does not contain that page, Your Honor.
I'm sorry, Counsel.
It appears, Your Honor, that the two documents are not the same.
What two documents are you referring to?
The marked exhibit and the set of documents from Director Matibag. With all due respect, Your Honor, the copy that was marked contains a page with annexes, including a USB, and such page does not appear in the copy provided by Director Matibag.
So the copy of Director Matibag does not contain a page with an attached USB.
That's correct, Your Honor. It's incomplete.
Does counsel for the prosecutors, assisting counsel for the prosecutors, or lead counsel confirm that? For the record?
We confirm, Your Honor. Nevertheless, the representation of the witness is that the copy is his own copy and does not pertain to the copy of the prosecution. And we will be willing, Your Honor, to use the pre-marked copy for the purpose of confirmation of the witness, Your Honor.
If you have it with you, counsel, why not just use that copy?
Yes, Your Honor.
So that we can go directly to it, unless there are any reservations from the
We are
counsel.
okay, Your Honor. Your Honor, if I may be recognized. We are okay with confronting the witness with his own copy, Your Honor. But again, we manifest that it was not the document that was marked and it does not contain the USB. Moreover, just an additional manifestation. The marked copy or marked set contains a stamp certified true copy, but it was not signed by anyone and there was no date provided.
Duly noted. Again, this without prejudice to the counsel for the prosecutor, furnishing counsel for respondent with a copy of the exact document produced by Director Matibag for further comparison and or observation either during cross or future proceedings later on.
We submit, Your Honor.
Your Honor, just a correction. There was a stamp, Your Honor, and a signature, but there was no name. Just for the record, Your Honor.
Duly noted for the record.
With the permission of the court, we'll be using the pre-marked document, Your Honor, for the purpose of confirmation.
Likewise, for the information of the counsel for respondent, would that be okay?
Then we take exception to that, Your Honor, because it was not the one that was identified by the witness in open court. What he identified was his own copy, and that copy does not contain any USB. So he does not have. He will be incompetent to testify on a pre-marked exhibit that he did not submit or participate in.
The exhibits can be later on compared to with a certified true copy at a later date, as has been previously done by the parties. In the meantime, the Chair will allow the witness to use his copy without prejudice to any differences that may be shown either through cross or through the comparison after a copy shall have been furnished to the counsel for respondents.
Continuing objection, Your Honor.
So ordered.
May
Continuing
we
objection is
confirm,
noted.
Your Honor, which copy we will be using for
The counsel
confirmation?
produced by Director Matibag will be the one that will be used.
Mr.
For the
Witness, kanina, binanggit mo ang Tokhang, Laod Quarry, at ang Vice Presidente. Saang partikular na bahagi ng affidavit ni Arturo Las Cañas na ipinapakita mo ngayon tumutukoy dito sa mga binanggit mo?
Objection, Your Honor. Then that already goes into the contents of such affidavit. And since the witness is not the one who executed the affidavit, then he has no personal knowledge and incompetent to answer that question.
Your Honor, may I respond?
Moreover, the court already ruled, Your Honor.
Counsel for the prosecutor may respond before the court rules on the objection.
Your Honor, the witness is merely pointing to that pertinent portion of the affidavit. And later, Your Honor, for the record, we will just be asking him to read into the records.
Just short rejoinder, Your Honor.
Counsel for the respondent may give his rejoinder.
Objection, the document will speak for itself.
Chair sustains the objection, counsel for the prosecutors. The document will speak for itself, and the document will be furnished to the senator judges anyway, given that it's part of the annexes. Let the witness merely testify to the fact that he included the affidavit of Mr. Las Cañas as part of his investigation and part of his narration of his investigation to prove, quote, pattern of violence. But again, not as to the truth and the contents of the affidavit itself. Move on, counsel.
With that, Your Honor, we will be requesting for the submarking of the pertinent portion of the affidavit of Arturo Las Cañas, the witness already referred to.
Again, only as to tenor, but not as to the truth, counsel. For the record and for the information of the senator judges, you may do so.
For purposes, Your Honor, of reference, which particular portion to be submarked, Your Honor? May we ask the witness to make reference or point which part of that affidavit he is referring to?
In his investigation, counsel.
Same objection, Your Honor.
As part of his investigation, witness may answer.
As part of our investigation, ang importante po para sa amin dito, in establishing the pattern of violence is yung paragraph 270 and paragraph 270B and paragraph 270D. 270.
For purposes of submarking, Your Honor, may we ask which particular part of paragraph 270 the witness first referred to?
Your Honor, manifestation.
Counsel for respondent may proceed.
All right. Your Honor, this pertains to an affidavit of Arturo Las Cañas. And on page 186, Your Honor, of such affidavit, it appears that even the signature is not a wet signature. It's a printed copy. And there's a subscription and sworn to portion thereof, but it's not notarized at all. So this is a mere scrap of paper, Your Honor.
Counsel.
Your Honor, the document is being presented only to seek confirmation from the witness that he is referring to this particular document as part of the investigation of Special Task Force. We are not presenting it to prove the truthfulness of the contents of the affidavit. The question only, Your Honor, is whether or not this is the document that was part of the consideration of the Special Task Force in investigating on the threat by the President to the life of the
Just
President.
a short
Your Honor.
rejoinder, Your Honor.
Counsel may give a rejoinder
Then
or
we-
additional manifestation.
Then we will not allow this witness to build on the basis of a mere scrap of paper, Your Honor.
Counsel, it was the counsel for respondent who chose this to use this copy instead of the one previously marked. That I presume is either certified true or contains a more complete signature.
Then I would have to clarify, Your Honor, that it is our position. Well, it's first of all, we are not in the position to choose for this witness. But in the event that they use this document, we manifest, Your Honor, upon perusal that such document is unsigned and unnotarized, Your Honor. This is an affidavit. So in other words, without the proper notarization and without the proper signature, then it is a mere scrap of paper. We cannot allow this witness to build his testimony based on this document.
Your
Your
Honor,
Honor, in fact, Your Honor, we request, Your Honor, that this court peruse also page 186 of such document.
Before the court makes the presiding officer makes a ruling,
Your Honor.
the pre-marked document, is it notarized?
Your Honor, may I raise a question to the witness so that he will answer and enlighten us on why the document is not notarized?
You may, counsel. So you're admitting that it's not even
Yes,
your
Your
pre-marked copy is not notarized, whether we use that copy or this one.
We admit to that, Your Honor.
The witness will please explain why he is using in his investigation a document and or affidavit that is not subscribed to or under oath. So it is not even an affidavit, but merely a statement.
Alam niyo po, Your Honor, sa law enforcement po, meron po tayo mga tinatawag na open source intel. At ito po ay pinadala sa atin at atin pong susundan. At kaya nga po, ang aming pong investigasyon ay isang continuing investigation, open, continuing and active investigation, sapagkat ito bang ganitong dokumento ay amin ding ikukumpara pa. Subalit malaki po ang value ng mga itong bagay sa amin sapagkat ito po ang nagbibigay rin sa amin ng direksyon at mga leads upang amin pong magampanan ang aming pong tungkulin na mag-imbestiga.
So for the second time and for the sake of clarity, and then for the information and guidance of the senator judges, the document being identified by the witness is unsigned, is not notarized, not under oath, and it is only as to the fact that they used this document in their investigation or as part of their investigation, but not as to the truth of the allegations contained in that unsubscribed document that was not made under oath.
Also unsigned, Your Honor. Sorry.
Unsigned.
Also
May I make a
unsigned because there's a
manifestation, Your Honor?
signature, but it appears to be a photocopy, so it doesn't qualify as a signature.
With the additional manifestation of the respondent, so noted, what is the manifestation of the counsel for the prosecutors?
Your Honor, based on the ICC, as relayed to us by our witness in the next article or in the last article that we will present, the ICC does not require notarization of document.
Noted, but we are not the ICC counsel. Again, we're just placing on the record and for the record the factual situation concerning the document that the witness is testifying to for the information and guidance of the senator judges. Counsel for the panel of prosecutors may proceed.
Mr. Witness, for purposes of submarking, can you read just a portion of paragraph 270, just for the guidance of the impeachment court?
Again, Your Honor, same objection. The document will speak for itself. Best evidence of this statement is a document.
Your Honor, we wanted
As
to be
previously
guided.
ruled, the court will allow it. Again, given the limited consideration that the court will give this testimony of the witness and not as the truth of what he will read. Witness may answer.
Paragraph 270, the years of 2012 to 2013 were the birth of Tokhang operations and the evil side of enforcement in Davao City by its author, the newly installed Davao City Police Office Director Colonel Ronald Bato de la Rosa. The operations were all cleared and approved by Mayors Inday Sara Zimmerman Duterte Carpio and Rodrigo Roa Duterte.
Your Honor, we are requesting that the portion read by the witness be bracketed and marked as Exhibit P4-35.
So ordered.
Mr. Witness, what else is the pertinent portion of this affidavit that you are referring to?
As mentioned earlier po, paragraph 270B.
For the guidance of the impeachment court, kindly read for purposes of submarking only.
While eating, Colonel Bato de la Rosa told me in Visayan dialect why you summoned me, and I quote, tour, short of Arturo, my first name. Nakaistorya mi ni Mayor Inday, referring to Davao City Mayor Inday Sara C. Duterte Carpio, party sa atwang Tokhang operation. As part of our Tokhang operation, ang order ni Mayor Inday sa akon, nag-ilaylo sa nato ang pusil, killing through shooting. Sa atwang mga target persons, shabu users and pushers and other criminal elements in Davao City. Kaysa mukan siya media, magsige o pagunta na, pud, kidnapa, abdak, na lang ninyo ang inyong target, unya, ilubong sa quarry, laod quarry. Para missing lang kay okay si Mayor Inday sa ana paagi. I talked to Mayor Inday as part of our Tokhang operation. She ordered us to lay low our killings through gun shooting because the media is asking too much. Just kidnap targets, then bury them in the quarry so they would go missing. She is okay with that way. To which I answer, yes sir, sultian na ko ako ang grupo. I'll inform my group. Colonel Bato de la Rosa instructed me. I-inform tour kung naamoy maabdak na target nyo. Inform me tour whenever you are kidnap a target.
Your Honor, we are requesting that that pertinent portion read by the witness be bracketed and marked as Exhibit P435A.
So marked,
Your
so
Honor,
ordered.
just
Counsel for respondent.
What?
we just want to register again our continuing objection, Your Honor. Again, we already allowed, Your Honor, that the witness at least identify this document. But as to the fact, Your Honor, that he is allowed to read even portions thereof, he's not the author of this affidavit. And as to the truth or falsity thereof, he is incompetent to testify on that. And it already violates, Your Honor, it already violates the rights of our clients because she's being prejudiced by the reading of this affidavit that cannot even be verified because the person is not here to testify. That's our objection, Your Honor.
Chair notes the objection and continuing objection of counsel for the respondents, and as an additional, for the third time perhaps, reminder of the presiding officer to my fellow senator judges. The mention of statements allegedly made by then General De La Rosa, now Senator De La Rosa, are clearly hearsay even on the part of Las Cañas himself. But as to the fact that probably he told him that, it may be established if the affidavit of Las Cañas and if Las Cañas is presented here. Again, this is only as to the fact that this is what the NBI used in their investigation and coming up with their findings, not as to the truth of the statements being read by Director Matibag, much less the statements of other parties who did not execute this document. The continuing objection is noted. Witness may answer. Counsel will proceed.
We are requesting, Your Honor, that that portion just read by the witness be bracketed and marked as P435A. Mr. Witness,
Let it be so marked.
ano pa, kung mayroon man, ang mahalagang bahagi ng affidavit ni Arturo Las Cañas na tinukoy mo kanina?
Same objection, Your Honors.
Noted. Witness may answer.
Sa paragraph D po, yung portion po nito ay ito po ay isa sa aming pinagtuunan ng pansin sa aming investigasyon.
Please read for the purpose of submarking only.
I later called up retired senior police Sonny Benaventura and relayed to him Colonel Ronald Bato de la Rosa's abduction operation ordered to me as allegedly ordered to him by Mayor Inday Sara Duterte Carpio. Sonny Benaventura answered me that would personally confirm and verify the matter with Mayor Inday Duterte. 2 days later, to my recollection, Sonny Benaventura called me and instructed me to meet him in Caltex gasoline station parking area in front of SM Mall Ecoland, Matina, Davao City, because Mayor Inday Sara Duterte will meet him in the said place. Sonny Benaventura wanted me to narrate personally to Mayor Inday Sara about the abduction order of Colonel Ronald Bato de la Rosa regarding his Tokhang operation. I agreed. I immediately proceeded to Sonny Benaventura's location. Upon my arrival on the board of my Strada pickup vehicle in Caltex gasoline station parking area, Sonny Benaventura motored me to the board pickup vehicle. However, before I could do so, Mayor Inday Sara Duterte Carpio arrived on board her SUV vehicle, a Fortuner-like vehicle, colored dark blue. Sonny Benaventura then disembarked immediately from his vehicle and rushed to the vehicle of Mayor Inday Sara Duterte that's a stop a few meters away from Sonny Benaventura's pickup vehicle. I stood in front of Sonny Benaventura's pickup vehicle looking and then talking. Mayor Inday Sara Duterte Carpio did not get up from the vehicle while talking to Sonny Benaventura, and Sonny was standing on the left side of Mayor Inday Sara Duterte vehicle. Then Sonny Benaventura hand signaled to me to come near him. I saw Mayor Inday Sara Z. Duterte Carpio inside her vehicle alone. I personally heard Mayor Inday Sara Zimmerman Duterte Carpio ordered Sonny Benaventura and I in Visayan dialect, and I quote, "Bulgar naman kayo man, pusilon, shoot." And target ninyo na referring to Sonny and myself nung short of manong older person. Kidnapa na lang ninyo. Target shabu users and pushers and other suspected criminal elements in Davao City. Para missing lang para sila, para dili samok ang media. Shooting your target is too brazen. Just kidnap them so they will just go missing and so that the media won't bother us. Sonny Benaventura replied, "Sige day, okay." Then she drove away it was a 3 to 5 minute kill order through abduction operation from a lady mayor of our city, the daughter of Mayor President Rodrigo Roa Duterte, that shed much blood of innocent poor Filipino suspected of being shabu users and pushers in Davao City. Now nationwide through the Tokhang campaign of the Philippine National Police for 4-star General and newly elected Senator Ronald Bato de la Rosa.
Your Honor.
Counsel for Respondent.
Then, considering, Your Honor, the reading of this portion of this piece of paper, Your Honor, we ask for a fourth clarification on the part of the chair that the reading of this document, Your Honor, already creates an impression, not just to the minds of the senator judges, but also the public. They may be misled, Your Honor, to believing the truth or falsity of these statements. So in other words, Your Honor, this is highly improper for, with all due respect, Your Honor, for this honorable court to allow the reading of a portion of an affidavit that was not authored by this witness. He doesn't know, he doesn't have personal knowledge, again, and he's not competent to testify as to the truth or falsity of these statements. It is purely hearsay and excluded by the evidence and the rules of court, Your Honor.
The chair is inclined at this point to already agree with counsel for respondent. Chair will cut short any further identifications of the witness in regard to this affidavit. I think you have sufficiently established, counsel,
May I
the
comment, Your
so-called
Honor?
pattern of violence that you sought to establish in the investigation of the NBI regarding the so-called grave threats that they are investigating. But the chair will nevertheless remind again the senator judges, as requested by counsel for the respondents, that this is only as to the fact that Las Cañas executed a document that they used in their open source investigation, not as to the truth of what was read. It was only identified for easy identification by the senator judges, subject to that limited understanding. And I think, counsel, that should be enough for now insofar as establishing your desire, rather, to establish so-called pattern of violence. Kindly move on already to the other grounds for investigation.
Just one last manifestation.
Counsel for respondent is recognized.
Well, in that case, Your Honor, with all due respect again, then it is like we believe certain portions of the statements as read by this witness because we are already mentioning about a pattern. So in other words, Your Honor, we give credence, Your Honor, or value to the statements that were read, which is highly improper, and we would like to object to that, Your Honor.
We did not give credence to it, counsel. We merely allowed the witness to testify as to the evidence he used and or considered in his investigation, which actually has not yet borne fruit unless he will testify to the contrary later on. As I believe the investigation as of this moment is still ongoing. But let it end at that. Counsel, please move on to
We will
another
submit,
point.
Your Honor, but register a continuing
The
objection.
continuing objection of counsel for respondent is duly noted and entered into the records. Counsel, lead counsel for the prosecutors, kindly move on to
Yes, Your Honor.
I presume you will go through the 5
Yes, Your
pillars
Honor.
of investigation of the NBI.
Yes, Your Honor.
Kindly proceed to the next point, the gravity or seriousness aspect.
May I just request, Your Honor, that the last portion read by the witness be submarked as P435B. Thank you, Your Honor.
Continuing objection, Your Honor.
Continuing
Maraming
objection of
salamat
the
sa iyong
counsel is noted.
paglilinaw kaugnay ng pattern of violence. Ngayon, puntahan natin ang gravity at seriousness ng banta. Mr. Witness, ano ang inyong sinuri kung mayroon man kaugnay ng gravity at seriousness ng banta?
Unang-una na po rito kung sino yung pinagbantaan, sino yung sinabing papatayin. At dito po natin makikita na 2 pinuno ng 2 sangay ng ating gobyerno, ang dating speaker at ang Pangulo ng Pilipinas ang pinagbantaan, kasama na rin po ang unang ginan. Kaya para sa amin po ay mabigat at seryoso po ang pagbabantang ito.
Bukod sa nabanggit mo na pinuno ng 2 malalaking sangay ng gobyerno ang pinagbantaan, ano pa ang inyong sinuri kung mayroon man?
Mismong ang Vice Presidente na po ang nagsabi na paulit-ulit na no joke, At pati pag tiningnan po natin yung kanya pong press conference noong November 23, 2024, makikita natin sa kanya na seryoso ang kanyang pagsasabi nito.
Bukod dito sa binanggit mo na sinabi ng Vice Presidente, no joke, no joke. Ano pa kung mayroon man ang sinuri mo kaugnay ng gravity at seriousness ng banta?
Tiningnan po natin yung mga kanina katulad ng video noong October 18 at yung pong kanyang video noong November 23 at nasundan pa po ito noong November 26 na sinasabi niya at kinukumpirma na seryoso ang kanyang pagbabanta at siya ay meron ng kinausap at pumayag para patayin ang Pangulo ng Pilipinas.
Bukod sa nabanggit mong 3 video, ano pa kung mayroon man ang iyong sinuri kaugnay pa rin ng gravity at seriousness ng banta?
Para sa akin po, hindi na ito talaga banta kundi isa na pong confession ng kanyang plano na pagpatay po sa ating Pangulo. Sapagkat makikita naman natin na sinabi niya na meron akong kinausap at pumayag ang kinausap para patayin ang presidente.
Objection, Your Honor. The witness already is providing conclusions of law, Your Honor. May we ask that it be stricken off the record?
Your Honor, may I respond to that?
Counsel for the prosecutor may respond. Rather, the lead prosecutor may respond.
Your Honor, the witness is testifying as to what transpired during the investigation of Special Task Force. He is testifying on the observation, appreciation, and findings of the Special Task Force. And this is the very purpose of presenting the testimony of NBI Director Melvin Matibag.
Short rejoinder, Your Honor.
Counsel may give a rejoinder.
Part of the witness's response is the use of the term confession, which is a legal term. The witness is a lawyer. He knows exactly what he's doing, Your Honor.
Nevertheless, Your Honor, that is the testimony of the witness, and that should be considered by the impeachment court.
The presiding officer shall rule, let it stay in the record as part of the narration of the witness, but not as to for the senator judges not to consider it as a conclusion of law, notwithstanding that the witness is the director of the NBI and there is a lawyer and a former dean, that is still not to be used by any of the senator judges as a conclusion of law as to the fact in issue in this impeachment court. Witness may answer.
Bukod sa
counsel may
binanggit
proceed.
mong confession, ano pa kung mayroon man ang iyong sinuri, kaugnay pa rin ng gravity at seriousness ng banta?
May tuturing po natin ito na mabigat at seryoso sapagkat alam niyo po ang NBI meron po kaming mga foreign counterparts na sa investigation din na patuloy namin pong nakakausap at nakakaugnayan. At kasama po ron aming pinag-uusapan ng mga pangyayari sa kanilang lugar, sa ating lugar. At napapag-aralan po kung paano kami magkakaroon po ng collaboration at pagtutulungan. At kung saan po sa amin pong pakikipag-usap rito ay atin pong napag-usapan ang tungkol po sa ginawang pagbabanta ng Pangulo, ng pangalawang Pangulo sa ating Pangulo. At lumalabas po sa aming mga usapan na sinasabi na ito ay seryoso na pagbabanta at sinabi pa nga na kung sa kanilang jurisdiction ito nangyari, maaaring hanggang ngayon nakakulong ang nagbanta na Vice Presidente o maaaring natanggal na sa pwesto ang Vice Presidente na nagbanta sa Pangulo.
Maraming salamat sa iyong paglilinaw kaugnay ng gravity at seriousness. Puntahan natin yung pangatlong batayan, identity. Mr. Witness, ano ang inyong sinuri kung mayroon man kaugnay ng identity ng pinagmumula ng banta?
Ito naman po ay malinaw na na-establish na ng identity at hindi naman po ito itinanggi. Paulit-ulit naman na inamin na ang nagbanta, ang napabausap ng papatay ay ang ating pong Vice Presidente na si Vice President Sara Duterte.
Bukod sa Vice Presidente Sara Duterte na tinukoy mong pagkakakilanlan ng nagbanta, ano pa o sino pa kung mayroon man, Mr. Witness, ang inyong sinuri dito sa pag-aaral ng identity o pagkakakilanlan?
Sinama na rin po namin dito ang tuloy-tuloy na mga banta kahit na po ng mga ordinaryong individual at kasama na rin po rito ang patuloy na banta po na nabanggit po ng ating pong Mayor Baste Duterte po.
Puntahan naman natin ang pang-apat ninyong batayan, capacity. Ano ang inyong mga sinuri kaugnay ng capacity to execute threat?
Unang-una po namin tiningnan sa capacity o kapasidad ng nagturan ng pagbabanta o pakikipag-usap nga sa pagpatay. Alam naman po natin ang Vice Presidente may malawak na network. At alam po natin na matagal ding nangungulang Pangulo ang kanyang ama po. At sila po regionally ay sila rin kinikilala dyan po sa Davao. Ibig sabihin po marami po silang network na maaari ding ibilang natin dito yung mga men in uniform sa Philippine military po natin, sa kapulisan. Ito po ay ating ipinactor in na kasama po doon sa kapasidad na kayang gawin po ang kanyang sinabing pagpapapatay.
Binanggit mo ang network ng dating Pangulo, ganun din na ang ama ay dating Pangulo. Binanggit mo ang network ng Vice Presidente. Ano pa ang inyong sinuri kung mayroon man kaugnay pa rin ang capacity ng pinagmumula ng banta?
Alam po natin at kanina nabanggit ko na yung pagiging kasama sa pagtatatag ng Davao Death Squad at alam naman natin kung ano ang kakayahan ng Death Squad na pumatay ng mga tao through AJK. Ibig sabihin po, pag ating itong ibinilang, kasama po ito sa kapasidad ng ating Vice Presidente na maisagawa po ang kanyang plano.
At bukod sa inyong pagsusuri dito sa Davao Death Squad, ano pa, kung mayroon man ang inyong sinuri, kaugnay pa rin ng capacity ng nagbanta?
It is also public record. Nakikita naman natin po sa mga balita ng mga Duterte, maraming pag-aari ng mga baril. At alam din naman po natin na they are well connected financially para matustusan o may sagawa ang kanya pong plano na pagpatay po sa Pangulong Duterte.
Bukod sa binanggit mong pag-aaring baril at financial connections, Mr. Witness, ano pa, kung mayroon pa, ang iyong sinuri, kaugnay pa rin ng capacity ng nagbanta?
Karugtong po rito yung Vice Presidential Security Group, yung BPSG na tinatawag natin, na alam natin na sa ngayon ay napakarami pong membro na isang tawag lang ng ating Vice Presidente ay nandiyan dyan para tubugon po sa kanya pong mga instructions.
Mr. Witness, puntahan natin ang panglima ninyong batayan. Motive or intention. Ano ang inyong mga sinuri kung mayroon man, kaugnay ng motive at intention ng nagbanta?
Unang-una po, at nasasad naman ito sa ating pong batas, sa ating konstitusyon, na kung ang Pangulo ng Pilipinas ay mawawala, mamamatay, ang susunod po na uupo by succession ay ang Vice Presidente. So pumapasok po ito sa motibo at sa intensyon.
Bukod sa ang Vice Presidente, ang papalit kung mawawala ang Presidente, ano pa ang inyong sinuri kung mayroon man, kaugnay pa rin ang motive at intention ng nagbanta?
Dito na po namin sinundan yung tinatawag namin na sunod-sunod at magkakaugday na pattern na nangyayari. At kaya po namin paulit-ulit na sinasabi na ang banta sa Pangulo ay banta sa ating national security sapagat nakikita po natin na it's creating chaos, yung kakaroon po ng kaguluhan, sunod-sunod po na pagtuligsa sa gobyerno. At yung mga ordinaryong mamamayan na nga po, makikita natin patuloy pong nagbabanta sa Pangulo. Katunayan, marami po kaming monitoring sa social media ng mga banta namin pong sinusundan sa seguridad po ng ating Pangulo.
Maraming salamat sa iyong paglilinaw sa 5 batayan na inyong ginamit kaugnay ng investigasyon ng Special Task Force. Kanina'y binanggit mo na maging ang ordinaryong mga tao ay nagbabanta na rin sa buhay ng Presidente.
Objection, Your Honor. May we know the question?
Allow
Your Honor,
the
I'm just
counsel to finish. She is not
I'm
yet
laying
finished.
the basis. Binanggit mo na maging ang ordinaryong tao ay nagbabanta na rin sa buhay ng Pangulo. Ano pa ang naging obserbasyon mo na may kinalaman sa naging banta ng Pangulo, ng Vice Presidente sa buhay ng Pangulo?
Objection on the use of the word banta, Your Honor.
Witness already used that word. Counsel is simply referring to the words used by the witness himself already at this time. Witness may answer.
Napansin ko nga po na tumaas ang antas ng kaguluhan sa pamamagitan po. Doon lamang po sa social media, kita-kita natin. Meron po mga panahon na nating pong Pangulo ay nasa isang event na live. Meron pong mga magko-comment na barilin na yan. Meron pong mga sa video na nakuha ng ating CCD na mayroong nagkakasa ng baril at ang reference din po ay isang bala lang to sa ulo ng presidente. So yan po yung kapansin-pansin na nagdudulot sa atin ng panganib sa ating Pangulo at sa ating pong pambansang seguridad.
Pagkatapos ng mga nabanggit mong obserbasyon sa inyong investigasyon, ano ang inyong ginawa sa Special Task Force kaugnay pa rin ang inyong investigasyon sa banta ng Vice Presidente sa buhay ng Pangulo?
Malinaw po ang mandato ng Special Task Force at ang mandato po nito ay patuloy na bantayan ang seguridad po ng ating Pangulo. At hindi lamang po para bantayan ang seguridad ng Pangulo, kundi hanapin at ma-identify kung sino ang kinausap ng Vice Presidente para po patayin ang ating Pangulo.
Binanggit mo na bahagi ng inyong ginawa ay hanapin ang taong kinausap ng Pangulo. Ano ang inyong napag-alaman, kung mayroon man, kaugnay ng tao na kinausap ng Vice Presidente upang patayin ang Pangulo, ang First Lady at ang former Speaker?
Sa ngayon po, ang aming pong investigasyon at ang task force is a continuing and active investigation of the threat to the President. Meron po tayong mga leads natin pong sinusundan at katunayan, we already have established persons of interest na maaaring makapagturo o tumukoy dun sa taong kinausap ng ating Vice Presidente o maaaring isa rito sa tinatawag nating persons of interest ang siyang talagang nakausap ng Vice Presidente.
Mr. Witness, binanggit mo yung persons of interest upang mas maunawaan tayo ng mga kababayang nanonood. Ano ang ibig sabihin mo ng persons of interest?
Ang ibig sabihin po nito, itong mga taong ito ay maaaring magbigay linaw o makapagturo sa identity ng taong kinausap o sa pangyayari ng pag-uusap o yun nga po, maaaring sila mismo ang nandoon o sila mismo ang kinausap. Kaya po ito tinatawag na persons of interest. Hindi po nangangahulugan na sila na mismo ang kinausap gaya ng aking pong sinabi.
Kaugnay pa rin ang binanggit mo na mayroon ng persons of interest. Mr. Witness, ano ang pagkakakilanlan ng mga persons of interest na tinukoy mo?
Respectfully, Mr. Presiding Officer, kinalulungkot ko po pero sa aking pong katatayuan bilang NBI Director, hindi ko po maaaring isiwalat ang pagkakakilanlan o pagkatao ng ating mga persons of interest na ito sapagkat gaya ng aking sinabi, this is a continuing and an open investigation po sa nangyari po na pagkontrata sa pagpatay sa ating Pangulo.
Mr. Witness, matagal nang iniintay ng sambayanan kung sino ang taong kinausap ng Vice Presidente. As a matter of fact, maging ang ating iginagalang na mga senator judges ay nagtatanong din kaugnay ng pagkakakilanlan ng taong kinausap ng Presidente. Ano ang dahilan, kung mayroon man? Bakit mo sinasabi, Vice President? Bakit mo sinasabi na hindi ito pwedeng i-disclose o isa publiko itong mga persons of interest na tinukoy mo?
Alam po ninyo, maraming kadahilanan. Tayo po ay nasa law enforcement. Kapag ang ganito pong bagay na it's an open and continuing investigation ay ating isisiwalat, unang-una pong mangyayari rito ay makukompromiso po ang ating investigasyon. At may lalagay po sa alanganin yung pong ating mga tinatawag na informants o assets na nasa ground na nagbibigay po sa atin ng human intel na tinatawag. At kasama na rin po rito na yung pong aming capability to have successful operation ay makompromiso sapagkat maaaring hindi na po kami pagtiwalaan ng aming pong mga pinanggagalingan na source. Pangatlo po, it will violate the right of privacy po ng mga individual na ating natukoy na persons of interest. At meron din po itong kaparusahan under the administrative code na kung ang isa pong information ay confidential, secret, or top secret, hindi po ito pwedeng ibahagi basta-basta sa publiko. Ito po ay exception din sa Freedom of Information under po sa Memorandum Order number 15 po ng ating pong Pangulo.
Mr. Witness, binanggit mo ang maraming dahilan kung bakit hindi mo pwedeng i-disclose itong pagkakakilanlan ng mga persons of interest. Baguhin ko yung tanong, anong pagkakataon kung meron man na maaari mong ibahagi sa impeachment court na ito ang mga persons of interest na tinutukoy mo?
Alam po ninyo, kahit dumating yung punto na matukoy na natin kung sino ang kinausap, we have the right to protect yung pong aming mga informants. Sapagkat ang pinoproteksyonan din po namin dito ay ang institusyon ng NBI. Subalit ito po ay patuloy na pagsusuri at report na tuloy na ginagawa po ng National Bureau of Investigation. Katunayan po, nandirito po sa akin yung mga report ng task force tag as confidential. Kaya pagpamanin po ninyo na talagang hindi ko po ito pwedeng ibahagi na pagpapubliko.
Ano
Your Honor,
yung
please.
mga...
Council correspondent is recognized.
Your Honor, considering already the length of time, can we just ask for a 5-minute recess, Your Honor?
Actually, I'm about to do so as soon as the counsel for the lead counsel winds
Your Honor,
up.
I'm about to conclude.
As soon as the direct examination is concluded, the chair will declare a recess before we proceed with your cross. Would that be okay, counsel?
Okay, Your Honor.
Counsel may proceed. Witness may answer.
Mr. Witness, ano yung mga papel na ipinapakita mo kanina?
Ito po yung patuloy na pag-uulat, mga minutes ng meeting at mga intel report po na nasagap. Kaugnay po sa ating isyong pinag-uusapan.
Kaugnay ng mga persons of interest na hindi mo pwedeng isiwalat, iyan ba ay bahagi ng mga papel na iyong ipinapakita?
Kasama na po ito.
Mr. Witness, I'm about to conclude. Ano ang nalabag ng Vice Presidente kung mayroon man?
Objection, Your Honor.
Kaugnay ng banta niya sa buhay ng Presidente. Your Honor, this is still part of the investigation.
I will have to sustain the objection. It would call for a conclusion of law, and as admitted by the witness himself, the investigation is ongoing unless he has concluded it already. Kindly rephrase, counsel.
I have no further question, Your Honor.
If there are no further questions, given that it is 4:03 and given that it's been 2 hours already, as agreed, Chair will declare a 15-minute recess. We shall resume at 4:18 for the cross-examination of the counsel for respondent. We are in recess. Witness is excused for the meantime and may exit the witness box. Before recognizing counsel for respondent for his cross, Chair would like to remind the witness that he shall continue with his testimony under the same oath. Do you confirm, Director Matibag, sir?
Yes, Your Honor.
Thank you, sir. Apologies. Prior to the chair's attention was called that we haven't approved the journal. At this juncture, Chair would like to dispense with the reading of the journal of July 20, 2026 and consider the same as approved. Apologies for the delay, given that we had to await the manifestations to be submitted to be made part of the journal. The other manifestations that were not submitted within today will be made part of the transcript and the records. The approval of the journal is made important, especially given the manifestation of the counsel for respondent that they need a copy of the ruling of the chair yesterday in order to afford them enough time to avail of whatever remedies they may have in relation to the court's ruling yesterday. So ordered. Counsel for the respondent may proceed with his cross when he's ready. You may proceed, sir.
Good afternoon, Director Matibag.
Good afternoon.
As NBI Director, you are the Chief Executive of the Bureau.
I'm the Chief of the Bureau. Yes.
And part of your duties is to oversee the conduct of investigation, correct?
Tama po.
You're also authorized to issue subpoenas for the production of witnesses and documents, correct?
Correct. Tama po.
Very well. Now, the NBI conducted an investigation following the November 23, 2024 press con, am I right?
I'm aware under the report that there was a subpoenaed issue,
Okay.
but I have no personal knowledge on the issuance.
Okay, we'll go there in a while. But this investigation was documented in the 2 affidavits of investigation, correct?
That's correct.
And did you read and understand these 2 affidavits of investigation?
I read the affidavit of investigation which was forwarded to the Department of Justice, which is dated February 11.
Okay. So, as part of that investigation, will you agree that individuals were subpoenaed?
There were individuals subpoenaed.
More or less 10
Your Honor?
subpoenas?
Your Honor, please.
Counsel for the panel of prosecutors, rather, the lead prosecutor is recognized.
Your Honor, the witness was appointed as NBI Director only in February 2026. His testimony with respect to the first investigation will only be based on records.
Your
So
Honor-
if it will go into the detail of the investigation, I'm afraid, Your Honor, he is not competent as he has no personal knowledge about the first investigation, Your Honor.
To begin with, asked and answered, and the witness was about to answer if he knows, given that he is the current superior of this agency, and I presume that he has kept himself abreast of what happened in his agency prior to his assumption in February of 2026. Witness may answer if he knows.
Please repeat the question.
So, more or less around 10 subpoenas were issued, correct? If you know.
Well, I cannot count,
All right.
but I know that their personality is subpoena.
Okay, very well. Now, these people were asked to appear before the NBI, correct?
Yes, that is the very purpose of the subpoena.
Okay. Now, these appearances were on various dates in November and December of 2024, correct? If you know.
I cannot recall
Okay.
exactly.
Now, if you know also, some appeared while some did not.
Yes, I was informed during the briefing.
All right. Now, for those who appeared, the NBI conducted interviews with them.
Yes.
All right. And minutes of these interviews were recorded, correct?
That is the standard procedure. So I suppose during that time it was recorded.
SOP. All right. So after the interviews, the interviewers who were also NBI agents executed affidavits. Is that also a part of the SOP?
Yes, that is correct.
Okay. And the affidavits attested that interviews were conducted, correct?
Yes, it will be signed by the investigating officers and eventually signed by a superior officer.
Okay. Very clear so far. Now, my question to you is this. Did you actually participate in these stages of the investigation?
That is
Honor?
very impossible because I'm not yet a director at that time.
Okay, that's okay. Are you aware that a subpoena was issued to VP Sara?
Yes, I was informed.
Did you sign that subpoena?
I was not
No.
there. I
All
cannot
right.
sign
Okay.
it.
Are you aware that the subpoena was issued to Dempsey Reyes of the Philippine Daily Inquirer?
I know that there are personalities of PINA who were present during the press conference on the November 23, but I cannot recall who are the personalities because I just went through to the affidavit of investigation.
Did you sign that subpoena for Dempsey Reyes?
That's impossible because
Okay.
I'm not that there.
That's okay. Now, are you aware also that a subpoena was issued to Red Mendoza of Manila Times? We can confront you with a hard copy if you just want to refer to it, but you can answer also. At any rate, we are showing the soft copies, Your Honor.
Your Honor, may I just...
For the benefit of this honorable court.
Assisting counsel may approach the witness. What is the pleasure of the lead prosecutor?
Your Honor, may just enter into the record that the witness already testified that he has no personal knowledge about the first investigation, and all his testimonies will be based only on the records existing in the NBI.
At any rate, Your Honor.
If he knows, witness will answer.
Your Honor, may we request also that those flashed in the big screen be explained by the defense counsel?
I already explained, Your Honor. We're confronting the witness with hard copies, and the subpoenas, the soft copies thereof, are displayed.
May we
as-
know, Your Honor, if these documents are pre-marked?
Well, it is part, Your Honor, of Articles of Impeachment, Annex G9, pages 159 onwards. So it is part of the records of this case. These
May
are
we
not
know
our
if they are
documents.
pre-marked?
Yes, we can mark it. And it was also pre-marked.
It is
But at any
pre-marked?
rate, Your Honor, these are not our documents. These are NBI documents, Your Honor.
No, the query is just if it's pre-marked so that the senator judges can refer to it if at all when they
The
read
marking,
the TSN.
sorry, Your Honor, the marking is D-1-145, Your Honor.
Which,
Your Honor-
which document, counsel? Because I see 8 documents.
In succession, Your Honor.
In
Those
succession.
those are all parts.
Counsel may proceed.
All right. Now,
Your
are you...
Honor, may I be clarified only about the XX, which are superimposed on those documents on the screen?
Counsel for respondent will please reply.
Your Honor, it was based on the witness's own answer that he did not personally sign.
Nonetheless, it does not reflect the exact document referred to by the defense, Your Honor. And that should not be allowed, Your Honor, with all due respect.
It is just to illustrate, Your Honor, for the benefit of the senator judges and as well as the public watching so that they can also follow the...
Lead prosecutor, we will allow it. So for the information of senator judges, the counsel for the respondent confronted the witness with respect to these affidavits that were part of the investigation conducted prior to his assumption as NBI director. And the witness simply stated that he has no personal knowledge with respect to the execution or due execution rather of these 2 affidavits thus far out of, I presume, 10.
May I comment, Your Honor?
The lead prosecutor may register her comment.
May I know what is wrong with just presenting the exact document instead of those which are marked with XX? Your Honor, I'm afraid it will give a wrong impression to the viewing public that those XX has something to do with inability, perhaps, or whatever impression it may give to the witness with respect to the to attending to the subpoena, Your Honor.
Short
May we
rejoin-
just remove those XX? We don't mind if they flash the documents, but it should be an exact reflection of what the document is.
Short rejoinder, Your Honor.
No need for a rejoinder. Court is ruled, and the court notes the observation, manifestation, and objection of the lead prosecutor. Again, I think it's quite plain that these are documents that the witness cannot or does not have personal knowledge about because he was not yet the NBI director. Counsel may proceed. Witness may answer.
All right, I'll move on. Are you aware that the subpoena was issued to Red Mendoza of Manila Times?
I'm aware that there is a subpoena, but on the actual issuance of the subpoena at that time, that will be impossible to be aware of because I'm no longer I'm not yet the NBI director.
So in short, you did not sign it?
I did not
All right,
sign.
okay.
I think it was
All right,
signed by Glenn Ricarte.
All right, that's enough. Okay. Now, are you aware also that the subpoena was issued to Bons Magsambol of Rappler?
Based on the affidavit of investigation, I think it was mentioned.
And did you sign that subpoena?
It is again signed by a certain Glenn Ricarte.
Are you aware that the subpoena was issued to Ana Rosario Malindog Uy, also of Manila Times?
Again, based on the investigation report.
And did you sign that subpoena?
No.
All right. Are you aware that the subpoena was issued to Jason Rubrico of SMNI?
Again, based on the investigation report.
Did you sign that subpoena?
Your Honor, may I respectfully interrupt?
Lead prosecutor is recognized.
The prosecution is willing to stipulate as to the issuance of this subpoena by the National Bureau of Investigation during the time that the witness is not yet appointed as the NBI director, Your Honor.
But that's not my question, Your Honor.
I
Anyway,
think
Your Honor.
unless you're willing to stipulate, counsel, to abbreviate the proceedings, that insofar as the questions of the counsel for respondent is concerned, that for the remaining 4 subpoenas, that the same answer of the witness for the previous 6 ones will be the same.
We are willing to stipulate on that, Your Honor.
We are not willing to stipulate, Your Honor. We'll just ask for a ruling from the court.
In that case, witness may proceed. A witness may answer. Counsel will please proceed.
All right. Are you aware that a subpoena was issued again to Jason Rubrico of SNMNI?
Same answer, Your Honor.
Okay, same answer. And you did not sign that subpoena for Jason?
I said
Rubrico.
same answer,
All right.
Your Honor.
Are you aware that the subpoena was issued to Mikhail Flores of Reuters?
Same answer, Your Honor.
Your Honor, may we ask, Your Honor, that the lawyer of the prosecution do not supply anything or make any comment near the witness because it may affect us.
Is he the assisting counsel may not supply any information to the witness other than merely observing the document being shown to him by assisting counsel for respondent. Counsel may proceed.
Mr. Presiding Officer, may I speak?
Yes, Director.
The counsel is not telling anything, but may I request not to cover me so that the people can see me.
Yes, that may be granted by the presiding
Thank
officer.
you, Your Honor.
Assisting counsel, kindly sit beside the assisting counsel stand beside the assisting counsel for the respondent. You may proceed, counsel,
All right.
for the respondent.
Are you aware that the subpoena was issued to Mikhail Flores of Reuters?
Same answer, Your
Same
Honor.
answer. You did not sign it. Okay. Are you aware that the subpoena was issued to Trixie Cruz Angeles?
Same answer.
And you did not sign it. Okay. Are you aware that the subpoena was issued to 2 OVP personnel? And did you sign the subpoenas?
Same answer.
All right. So not a single one. Now, my next question to you is this. Did you oversee any interview that was conducted in the fact-finding investigation?
Your Honor, the question is vague.
If the witness is a lawyer and is competent to
Your
answer,
Honor,
if he knows, Your Honor.
Your Honor, during the direct, it was established that there were 2 investigations. The first investigation and the current investigation of the STF.
Then,
the defense need to specify which investigation is he referring to.
The affidavit.
Counsel will please clarify.
Okay. Did you oversee any interview that was conducted in the investigation that was covered by the affidavit of investigation?
As mentioned in my testimony, I was appointed only on February 20, 2026, and it's very unlikely to be part of the investigation prior to that.
Okay. So, are you aware that there were at least 4 interviews that were conducted?
Your Honor, asked and answered.
That is a different question, Your Honor.
Nonetheless.
Witness may answer.
I'm not aware because I'm not yet there.
Okay, so are you aware? Let me be more specific. Are you aware that an interview of Dempsey Reyes of PDI was conducted?
I'm not aware of that, but as reflected in the investigation report, it was there.
So in other words, you did not oversee that interview?
Yes, definitely.
All right. Are you aware that there was an interview of Fred Mendoza of Manila Times?
Same answer, Your Honor.
Same answer. Are you aware that there was an interview of Bons Magsambol of Rappler?
Same answer.
Same answer. So you did not oversee that interview. And are you aware that there was an interview of Jason Rubrico? Did you oversee this interview?
Again, same answer.
Same answer. Okay. Did you see them sign any minutes of the meeting?
No.
No. Did you meet any one of these interviewees?
At
Before
that
or
time?
after? Before or after?
Who among the
Among the interviewees that I
No.
mentioned? No. Did you meet any one of their lawyers?
No.
No. All right. Now, were you even present at the NBI Cybercrime Division office at the time of these interviews?
That is impossible.
All right. After the interviews, affidavits attesting to the interviews were executed, as you mentioned. Did you oversee the drafting of these affidavits by the NBI agents?
Again, very unlikely. I was not present.
All right.
Your Honor, if I may interrupt, may I just enter a
Lead
continuing...
prosecutor may make a manifestation and or a continuing objection, as I presume she will.
Yes, Your Honor. I'm entering a continuing objection to the line of questions of the defense on the ground as stated by the witness. He has no personal knowledge about the investigation conducted prior to his appointment in February 2026, Your Honor.
Just a
That is for
short
the
rejoinder.
record.
The continuing
Your Honor.
objection is noted. Counsel for the respondent may proceed.
No need for that rejoinder. But were you present when the NBI agents subscribed and sworn to their affidavits?
I was not there.
You were not there. Still nothing. So, and since you did not actually participate, it means that you do not have personal knowledge of these stages of the investigation, correct?
During that time, yes. But as I mentioned earlier, I read the investigation report.
So your knowledge of the investigation was based on only of your reading.
That is absolutely correct.
All right.
And upon the discussion of the investigating officers.
Okay, very well. Now, were you present at the November 23, 2024 press con?
I was not present.
You were not
I was
present.
not participating on that.
And if you know, was any NBI agent present at the November 23, 2024 press con?
Not that I know of.
None. All right. So in layman's terms, for the benefit of this honorable court and the Filipino people watching, and I'll phrase my question in Tagalog. So sa kabila po ng pagtestigo po ninyo ngayong araw, inaamin nyo ba na wala kayong personal na kaalaman sa nangyaring investigation starting November 23, 2024?
Malinaw naman po yun. At ang korte po, I can take judicial notice of the fact na hindi pa po ako NBI director ng panahon na yun.
So you're confirming that you do not have personal knowledge because you were only appointed as NBA director a year later or on February 20,
Your Honor, ask and
2026,
answer
correct?
question.
No, I haven't even asked that question, Your Honor.
Kindly let counsel finish.
So again, I will repeat. So the reason for this is that because you became NBI director only a year later or on February 20, 2026, correct?
Tama po.
All right. Okay. So prior to February 20, 2026, you do not have any personal knowledge of any investigation, correct?
Nababasa ko lang po sa balita mga pangyayari.
Which is not personal knowledge, correct?
Well, yun lang po yung knowledge natin.
You're a lawyer, correct?
Tama po, 29 years.
29 years. Can you recall Rule 130, Section 22 of the Rules of Evidence?
Can you refresh me, sir?
Okay, I will
Because you have a
gladly
copy.
refresh you, of course. I have here a copy of Rule 130, Section 22 of the Rules of Evidence, and I'll read it. Please read with me, Director Matibag. Testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Can you recall that rule now?
Ayan po, nababasa ko po ngayon.
Okay, you
Tama
can
po.
read it. All right. So, based on this rule, will you agree with me that a witness can only testify based on his personal knowledge?
Your Honor, may I comment to that?
These are basic questions, Your Honor. The witness is a lawyer. He is competent enough to answer.
Counsel, are you making an objection?
This is a comment, Your Honor. The witness repeatedly testified that he was appointed only in February 2026 and that all his testimonies pertaining to the first investigation are based on records, Your Honor. And this is allowed. As a matter of fact, under the rules, entries in official records are considered as prima facie evidence of the contents thereof. And thus, it's exactly the basis of the witness in answering the question of the defense. All his knowledge pertaining to the first investigation are based on records.
Short rejoinder, Your Honor.
No need, counsel. Distinguished lead prosecutor, the counsel for respondent did not object to the line of questioning of the lead prosecutor earlier, based exactly on the ground cited by the lead prosecutor. The presiding officer will give sufficient leeway to the counsel for respondent to establish his point. I think you also see what he is trying to establish. That's why he made a continuing objection in relation to it. I'll give you some leeway, counsel, but go to your next topic as soon as you're done with this.
Thank you, Your Honor. So, again, based on this rule, a witness can only testify based on his personal knowledge, correct?
Tama po, pero meron pong mga exceptions sa rule.
All right, okay. If not based on personal knowledge, then that is hearsay, correct?
But it's not an absolute rule po dahil may exceptions nga po.
Okay, now, I'm trying to look for the Filipino term for hearsay. Ano ba yung hearsay sa Tagalog? Sabi-sabi or chismis? Is that a fair translation? What is a fair translation to you of hearsay? in
Your Honor,
Filipino?
the question of the defense is misleading. He never testified that that is hearsay.
No, I'm not
As a
asking
matter
him.
of fact, he's trying to raise the exception to hearsay.
I'm not asking about the exceptions of hearsay. I'm asking a translation of hearsay. Your
May
Honor.
we know-
Anyway, I'll move on to.
If the witness
If the
knows, if he does not know, he may say so.
Hindi ko po alam kung anong translation dito sa Tagalog.
Okay, so I'll just use my own translation, chismis. Anyway, at any rate, kung wala kang personal knowledge, chismis lang yon, tama?
Hindi ko naman po naririnig sa korte, ako'y nag-practice din, kahit di translate sa Tagalog, kahit minsan ko po, hindi ko po narinig ng hearsay ginamit ang salitang chismis.
Alright, I'll move on. Now, the main material that the NBI used in its investigation was the video of the November 23, 2024 press con, correct?
Tama po.
Did you watch that whole video yourself?
Napanood ko po.
The whole video?
Well, yung pong importanteng bagay dyan ang aking tinutukan pero napanood ko po.
Alright. Now, let me ask you, do you confirm that in that virtual press con, VP Sara spoke about a lot of topics?
Tama po.
Alright, I'll show you a portion of that video and then I'll ask questions thereafter. Now, Your Honor, we beg the indulgence of this honorable court. Again, this video is a little lengthy, but we will only show one video, Your Honor.
Counsel may proceed.
Kainin niyo, buffet, dyan, ito, sa House of Representatives. Alak. At ang mamahaling wine. Yan. Yung taong bayan na prinamisan ninyo, 20 pesos na rice. Yung taong bayan na hindi ninyo pinupuntahan sa mga komunidad nila, ano sabi nila? Ganyan ang bayan natin. Okay na lang kami sa asin. Sa kung ka nakahanap, bayan, na ang tao, because of their hopelessness, because there is no functioning corporate, okay na lang sa asin. Ng abogado si Atty. Lopez eh. Kasi alam niya kung ano sasabihin niya doon sa mga
Your Honor, it appears that we're having technical difficulties. Can we just replay that part, Your Honor?
Nakawin yung cellphone.
Your Honor, may I make a manifestation first?
Can the tech kindly pause and rewind a bit with respect to the portion? Just a bit.
Your Honor, this is part of the question, Your Honor. Can we ask that the manifestation be made after the playing of this video and the asking of the appropriate question?
Your Honor, the manifestation concerns the very video that they are presenting.
We're already playing it, lead counsel. We will recognize you after the video is played. Kindly proceed with the playing of the video.
ng cellphone. Saan ka nakahanap? Papasok ka, nanakawin mo yung cellphone, dadalhin mo pa yung tao. Diba? Princess, you're raising your hand.
Hello? Naririnig po ba ako, Princess Maui?
Yes.
Oh, thank you. Good morning po, Madam Vice President. Thank you so much nga po pala sa dala niyong hopya nung hearing na pumunta kayo for PRRD. Kami yung nasa likod niyo po, yung tinawag nilang bastos kasi pumalak pa kami because of Congresswoman Cardema. Thank you, ma'am. Nakakain kami. Ako po ay natatakot kumain ng pagkain doon baka mamaya. Ma'am, mag-iingat po kayo. Nasa teritoryo kayo ng kalaban.
Okay
Nag-aalala
lang
po kami para
ma'am, kasi sila naman sila talaga yung bastos eh. You reap what you sow.
Yeah. Mag-iingat po kayo kasi sa dinami-rami po ng inyong mga pasabog ngayong gabi, it seems like marami po talaga kayong alam about them, no? Dahil sa pagkakasama niyo sa kanila during the campaign and during the 2022 elections. Baka po mamaya kasi totoo yung mga naririnig namin o yung, I don't know if it's true, na meron daw silang Operation Romanovs and baka bala kayong ubusin ang inyong pamilya dahil hadlang kayo sa kanilang mga balak in the future. So mag-ingat po kayo. Kami po kasi kami ng EDSA Friday Through, kami yung bumababa every Friday dyan sa EDSA because we believe yan yung tamang venue sa dinami-rami na ng problema natin. Ang kaya lang naman po namin gawin ay manawagan na bumaba na yan. Eh ano po kayo ang remedy naman ninyong mga nasa posisyon or ng mga kayang labanan itong napakarami na pong ginagawang korupsyon at krimen laban sa taong bayan. Ano po ang pwede nyo maging remedy para matapos na ito? Lalo't nagsisigaw na po ang taong bayan na mag-people power.
Yes. Huwag kang mag-alala ma'am sa security ko kasi may kinausap na ako na tao. Ito sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta at si Martin Romales. No joke. No joke. Nagbilin na ako, ma'am. Pag namatay ako, sabi ko, huwag ka tumigil ha. Hanggang hindi mo magpatay sila. And then he said yes. So, alam mo ma'am, yan ang lagi kong sinasabi sa mga kabayan lang. Ang laban, wala dyan sa EDSA, ma'am. Wala dyan sa mga highway. Ang laban, ma'am, nandun sa loob ng palasyo. Yan ang problema. We appreciate yung expression ninyo ng disgust, ng pagkamuhi, ng hopelessness, kasi it reflects kung ano yung nararamdaman ng marami, milyon. Alam ko yan, ma'am, kasi kahit saan ako pumunta, ako ang binoto namin yan dahil sinabi mo, iboto namin. So, yes, ma'am. Maraming salamat sa ginagawa ninyo. Dahil sa ginagawa ninyo, I'm sure nakikita yan ng taong bayan. Ina-appreciate nila yan. Marami sa ating mga kababayan ang gusto sumali sa inyo. Pero sa sobrang hirap ng buhay ngayon, hindi nila maiwanan yung mga trabaho nila at hanap buhay nila para pumunta sa daan. Bakit sila naghihirap? Bakit? Dahil sa gobyerno. Hindi ba dapat yung gobyerno natin ang nagpapagaan ng buhay ng tao? Bakit ang gobyerno natin ang nagpapahirap lalo sa tao? Kasi gusto ba nila lagi na lang mahirap ang mga tao para madali mapasunod? May mga lugar kami sa Mindanao na ganyan ang mga politiko. Gusto nila mahirap lahat. Ibahugan lang nila ang kwarta. Governor na sila, mayor na sila, congressman na sila. Hanapin niyo, ma'am, yung mga lugar na sobrang hirap sa Mindanao. Tingnan niyo anong gawain ng politiko. Pinapakain lang ng pera ng tao. Pinabastos yung kanilang pagkatao. Dahil wala silang pakialam.
All right. For the benefit of this court, that is timestamp 1-12, 1:12:43 onwards of the video recording with accompanying transcript.
With the
This is
permission of
exhibit-
with the permission of the counsel for respondent, the lead prosecutor is recognized for her manifestation.
Your Honor, I wish to manifest that the video which was played is unmarked and spliced video, Your Honor. That is for the record.
The counsel for respondent just mentioned the timestamp and the marking as well. Counsel for the respondent may proceed.
All right. Now, Director Matibag, these are my questions about the statements of VP Sara in that video. Do you have personal knowledge of the theft incident involving Attorney Lopez's cell phone?
Wala po.
Wala. Do you have personal knowledge on the buffet in the House of Representatives?
Wala po.
Wala. Do you have personal knowledge on the communities na asin lang ang kinakain?
Wala po.
Alright. Do you have personal knowledge on the person whom VP Sara talked to regarding BBM, FL, and the former speaker?
Wala po dahil
Wala.
siya nakipag-usap.
Alright, okay. Thank you for that. So, now, you mentioned that you watched the whole video. My question to you is, did the NBI conduct any separate investigation regarding the various acts of corruption alleged acts of corruption of BBM, FL, the former speaker, and the congressman as mentioned by VP Sara?
Marami pong iniulat sa akin na mag-investigasyon, subalit hindi naman po kasi binanggit doon sa video sino ang mga particular na kailangang imbestigahan. Kaya naman po yung investigasyon na ginagawa ngayon ng NBI, maaaring tumutukoy na po sa mga taong binabanggit po.
Right, but as NBI director now, you have the authority to investigate alleged cases of corruption, correct?
Tama po yun.
All right. In fact, you came out in the news recently stating that you will investigate the 2019 SEA Games, correct?
Tama po.
All right. And the 2019 SEA Games came prior to this 2024 press con, correct?
Tama po.
Okay. Do you intend, my next question is this, do you also intend to investigate the alleged corruption involving the unaudited confidential funds of the OP, Office of the President, also mentioned by VP Sara?
Kung meron po mga ebidensyang ilalatag sa amin para amin pong sundan, hindi po magdadalawang isip ang NBI sapagkat ito po ang mandato ng NBI.
All right, thank you for
mag-imbestiga ng mga krimen po, amin pong nakikita.
All right, thank you for that answer. Now, do you also intend to investigate the alleged corruption involving the former speaker going around the country and giving government funds to people, also mentioned by VP Sara in that video?
Your Honor, may I comment, Your Honor?
What is the comment of the lead prosecutor?
We are objecting to that question, Your Honor, as the same is misleading.
Your Honor, if he knows, he said he watched the whole video, he listened to the statements. There was a statement there.
Witness may answer if he knows.
Well, kung meron po mga ebidensyang pumapasok tulad ng lahat ng aming ginagawa, we are driven by evidence and the process and the law na dapat pong sundin.
All right. Now, my next question is, your wife is also a member of the House of Representatives.
That is correct po.
And she is Representative Maria.
Your Honor, with all due respect.
This is cross your honor. Maybe given leeway, Your Honor.
Allow the counsel to finish the question and then you may make your objection afterwards. Finish your question, counsel for the respondent.
She is Representative Maria Rene Ann Lourdes G. Matibag. correct?
Before
I
the witness
object, Your Honor.
answers, what is the objection of the lead prosecutor?
The questions, Your Honor, of the defense with regards to the wife of the witness is totally irrelevant.
Your Honor.
And that should not be allowed.
Your Honor, these are
the,
credibility testing questions, Your Honor, which is always relevant.
The objection is overruled. It tests the freedom from bias, if any, of the witness regarding his testimony, and the chair will
Nevertheless,
allow
Your
it. Witness may answer.
Your Honor, may I just enter
there
a
was already-
continuing objection on the line of questions pertaining to the wife of the witness, Your Honor.
So noted. Witness may answer.
Opo.
All right. Now, let me direct your attention to House Resolution number 989. This is also part of the records of this case, entitled Setting Forth the Articles of Impeachment Against Vice President Sara Duterte. Permission to use a pointer, Your Honor. Now, it appears that from this document...
Counsel may do so.
that your wife is one of the endorsers of this House resolution. Can you confirm that?
Yes, the name is her.
It's there. Okay. Now, there's a signature page also. This document is not numbered, but it appears that it's around page 19. Can you confirm if this is your wife's signature?
I think I have no authority to confirm the signature even if she is my wife.
So you can confirm the signature of your NBI agent, but not your wife?
It's appeared to be her signature, but I have not confronted with the document so that I can compare it.
At any rate, Your Honor, may we allow?
With the NBI, it's different. I testified earlier that it was presented to me, and I asked him if he signed it, and I'm familiar to his signature because he's always making submission to my office.
All right. That's okay. At any rate, Your Honor, may we request, Your Honor, that we be allowed to submark this particular portion. Again, this is already
may we
part of the
request, Your
records.
Honor, that the witness be confronted first with the document, and
We
may
will
we
do that,
request
Your
as well that the assisting counsel for the prosecution be allowed to approach.
We will do
Assisting
that, Your
counsel
Honor.
for the respondent may please confront the witness with a document in the presence of assisting counsel for the prosecutor before counsel for respondent requests it to be marked. Witness will kindly look at the document and answer the question.
May I first manifest, Your Honor, that the photocopy, the document being presented to the witness is a photocopy.
Your Honor, if at all we can agree that the court's copy be submarked, Your Honor. And we request, Your Honor, that the first page that we showed and this signature page around page 16 be submarked, even at later, Your Honor, before the clerk.
It shall be done at a later time. In the meantime, by the oath of respective counsels, I believe we can rely on this copy, subject to confirmation in the marking of the actual copy that the court has.
And
of the you're referring to the impeachment resolution on impeachment, right?
Yes, Your Honor, but Your Honor, insofar as the identification of this witness, we are relying actually on the transmittal by the Committee on Justice, which was received by our office on May 11, 2026, Your Honor.
Not
So
by
it is-
my office, but by the Secretary General of the Senate. Kindly confront the witness with the document so that he may answer intelligently.
If you know only, Director
Your
Matibag.
Honor, respectfully,
That is the
if I may say something, if the court
Yes,
will allow me.
Director Matibag.
In order to save time and the questioning of the defense counsel, I think he's going to the position if my wife endorses the article of impeachment so that we save time and it's on record. It's a matter of public notice. Yes, my wife is one of the endorsers of the impeachment.
Duly noted. Counsel, move on.
All right, thank you for that admission, Director Matibag. And despite that spousal relationship that you admitted, you decided to appear and testify today, correct?
My decision to be a witness is by virtue of a subpoena issued by the Honorable Court and by invitation of the Committee on Justice, the prosecution. However, the job of my wife as a legislator is totally detached from me being the director of the National Bureau of Investigation.
Okay, my next question is, but the court did not issue a subpoena for you to appear today.
Actually,
Are you saying that you receive a subpoena despite this honorable court not issuing a subpoena for you?
even if there's no subpoena in the pre-trial order, I was mentioned to be a witness. And I was invited by the prosecution to be a witness. And from my understanding, in the pre-trial order, I was also listed by the defense. I will be gladly witness for the defense as well if I will be called upon.
All right, but which is which? Are you appearing today by virtue of a subpoena or without a subpoena?
I'm appearing today as a witness as called upon and announced by the Honorable Court and by the invitation also of the
No, that's
prosecution.
not my question, Director Matibag. You're a lawyer, you know this. Are you appearing today by virtue of a subpoena or no subpoena?
There's no written subpoena, but there is a verbal announcement from the Honorable Court that I will be a witness in today's hearing.
Your Honor, the question of the defense is misleading. It is apparent that last week a subpoena was issued to the witness, Your Honor, and it is because of the other matters that was heard and addressed by the impeachment court. The schedule of the witness was scheduled to today.
Your Honor,
The objection is overruled. First, asked and answered, and for the record and information of the senator judges, the presiding officer confirms that no subpoena was issued to Director Matibag. In fact, I asked if one was needed, and the response I got was that it was not necessary. But indeed, the chair also confirms that the name of Director Matibag was requested to be invited by the counsel by the prosecutors, and he was so named by the presiding officer to attend in, I believe, yesterday, supposedly, and today's trial dates. Move on, counsel.
Just one last question on this point. So considering that there's no subpoena, I'm just wondering how it works. Did you coordinate with any of the prosecutors in relation to your appearance in today's proceedings?
Well, we conducted some meetings on this matter.
You mean prior to your appearance to this honorable court, you met with members of the prosecution?
Yes, twice when I was informed that I will be a witness on the pretrial order.
All right. Did you meet with the private prosecutors or the public prosecutors?
With the chairman of the committee, with the Congresswoman Jerry Miller.
And you are confirming in open court that you discussed or you were briefed in that meeting based in your testimony? What was the, okay, you can explain.
Yeah, well, I'm a lawyer and I know where you're going. There was no discussion or coaching. We just discussed matters that's supposed to be covered by my testimony. Because I'm a director, I will be testifying. Of course, they will want to know what will be the nature of my testimony. In the same way that when you want to present me as your witness, I will be more than willing to sit down with the defense counsel.
Your Honor, I take exception to that. I don't think Director Matibag knows where I'm going. In fact, I'm moving on to a new point. At any rate, Your Honor, I don't think we are calling him as a witness. So these are facts that only he assumes. No, but I want to state that for the record, Your Honor.
Witness will not argue with the counsel.
I'm sorry, Your Honor.
Kindly move on,
Yes, sir.
counsel, for the respondent.
All right. Let's just move on, Director Matibag. The NBI is under the DOJ, correct?
That is correct.
All right. And the DOJ is under the Office of the President, correct?
That is correct.
Now, BBM, in short, BBM has control and supervision over both NBI and the... Your Honor, sorry, I'm hearing comments from the prosecution. I don't mean any disrespect to the President. It's just for purposes of abbreviation, I'm just calling him BBM. But at any rate, I'll move on to my question. So BBM has control and supervision over both the NBI and the DOJ, correct?
That is not exactly correct. Only on the matter of appointments, but we enjoyed independence in the matter of investigation.
I'm glad you mentioned that. Do you confirm that you're an appointee of BBM?
Well, it's only the president who can make an appointment. I think it is provided for in the law.
What's the answer?
Yes.
Yes, okay. And so my question to you is this. Did BBM participate in the NBI's investigation in any way?
No.
No. All right. So don't you consider your appointment as NBI director as participation on the part of BBM?
No.
No. Okay. All right. You mentioned a while ago that after the affidavit of investigation, it was submitted to the DOJ for evaluation, correct?
For their evaluation and finding if there's enough reason to file a case before the regional trial court or the proper courts.
All right. And during your direct testimony, you also mentioned that as we speak, it is still pending, correct?
That is correct.
All right. Now, in other words, in terms of formal charge to be filed in court, that is still not available at this time, correct?
It's in the jurisdiction of the National Prosecution Service, which is under the Department of Justice.
But insofar as the case that the NBI filed with the DOJ, is it not the case that that charge does not include contracting for the assassination?
That is correct. What was filed was grave threat and inciting to sedition.
So in other words, at this point, VP Sara is not being made to answer for contracting for assassination, correct?
That is exactly what that my testimony covered. That she is being investigated for contracting a person to kill the president. And that is a continuing threat not only to the life of the president, but to the national security of our country.
Not responsive, Your Honor. My question is if she's already being made to answer to that particular charge.
Made to answer, counsel, meaning
Subpoenaed.
has she been subpoenaed?
I'll be more specific. Has she been subpoenaed in terms of contracting for assassination?
Well, in this impeachment court, she is being on trial. And that is very well covered by the articles. To me, as a lawyer, not only as an NBI director and as a former dean, that is a betrayal of public trust to me because she made an oath of office that she will protect, defend the Constitution, execute laws, do justice to others.
Director
and
Matibag, let
to
the
self.
court intervene at this juncture. That is not responsive to the question of counsel. Kindly just answer the question. Has the NBI issued a subpoena against the Vice President with respect to the crime of contracting a killer, allegedly?
At this point, Your Honor, not yet.
Not yet. Okay.
Please proceed, counsel.
That's enough. So no subpoena as of now. But in other words, has there been any affidavit of investigation relating to contracting for assassination?
My understanding is there was a subpoena issued at that time during the investigation to the Vice President, and the lawyer submitted an affidavit.
No. Again, not responsive, Your Honor. I'm talking about an affidavit of investigation executed by the NBI.
Not
in
yet.
terms of not yet. Okay, so at this point, would you agree with me that the DOJ has not found any basis for contracting for assassination?
Wala pa po sa
Wala
ngayon.
pa. All right. So at this point, as of today, there's simply no evidence to warrant the filing of a formal charge for contracting for assassination, correct?
That's why kung babalikan po natin yung aking testimonya, this is a continuing and an open investigation as to the contracting a killer.
So in other words, the reason why these are not present at this time because your investigation is still ongoing.
It's a case build-up and an open, active investigation.
All right. Very well. Now, you mentioned about grave threats and inciting to sedition. My question to you is, these subject matters fall under the category of felonies, correct?
That's correct.
Yeah. Now, in fact, based on the penalties involved as provided by law, these fall under the jurisdiction of the first-level trial courts, correct?
Yes.
All right. Now, moreover, for one to be declared guilty of these felonies, the burden of proof is guilt beyond reasonable doubt, correct?
That is correct.
Now, guilt beyond reasonable doubt, is this a low threshold or a high threshold?
Beyond reasonable doubt, of course, it's a high threshold.
In fact, it is the highest threshold in
That is
criminal law,
correct.
correct? So in other words, para lang for the benefit of the Filipino people watching, so hindi ka pwedeng magsampa ng kaso nang hindi mo kayang patunayan, correct?
Tama po yun. Dahil meron pong Memorandum Circular number 20 ng Department of Justice kung saan sinasabi that when you file cases, there should be a reasonable certainty of conviction.
Thank you for that clarification. So if the threshold is guilt beyond reasonable, if this threshold of guilt beyond reasonable doubt is not reached, then the accused must be acquitted, correct?
Tama po yan.
And insofar as grave threats or inciting to sedition, it is the trial courts that will decide that, correct?
That is correct.
Not the DOJ.
The DOJ will submit the information and the resolution for prosecution. At the end of the day, it will be the court who will say whether it's guilty or not.
All right. Now, in your testimony earlier, you mentioned that there are leads on the alleged person that VP Sara talked to, correct?
Yes.
But let me ask you this. During that press con, did VP Sara mention the word assassin?
Wala po.
All right. Now, the investigation on these leads, are these already final?
Pakiulit po.
The investigation based on these leads that you mentioned, are these already final?
Hindi po.
Hindi pa
Malinaw po sinabi ko that this is a continuing and open investigation po.
All right. So, in other words, you haven't given any opportunity for VP Sara to confront this alleged person, correct?
Hindi pa po.
All right. But will you agree with me that confronting this alleged person is part of due process?
Tama po. Kaya mas maganda nga po kung si VP Sara mismo magsabi dito kung meron siyang kinausap at kung sino kinausap.
But is that part of the SOP also, that you give an opportunity for VP Sara to confront?
Tama po. Pag natukoy na po namin kung sino ang taong kanyang kinausap, that is the time na siya po ay aming kukomprontahin para siya po ay masagot niya kung itong taong talaga ito ang kanyang kinausap para patayin ang Pangulo.
All right. My next question is very simple. So you offered your testimony before this impeachment court, even you performed SOP or giving opportunity to VP Sara to confront?
Malinaw naman po yung sinabi ko. Pag nakita po namin kung sino ang taong kinausap, saka po namin siya kukomprontahin, kasama po ang taong iyon at kasama po ang mga willing na nagbibigay ng UN Intel para harapin po ang akusasyon na yun.
So considering that you're still pursuing those leads, don't you think that your testimony today is premature?
Hindi po. Sapagkat malinaw naman po sa statement ng ating Vice Presidente na meron siyang kinausap para patayin si Bongbong Marcos, si Lisa Marcos Araneta, si Martin Romualdez, at sinabi pa niya na walang biro to us sa law investigation, applying po namin yung pong methodology na ginagamit ng Secret Service sa Amerika, ay papasok po rito na ito isang malinaw na confession ng isang tao na meron siyang isang plano na pagpatay.
Okay, I'll move on, but I'll ask you, isn't that a trial by publicity which is not sanctioned by our laws?
Hindi po. Sapagkat kaya nga po namin hindi nilalabas yung aming pong mga confidential at secret na investigation. Lamang nga po, tayo ay pinatitistigo rito na kailangan natin pong sabihin kung ano na ang naging takbo ng investigasyon. At malinaw naman po sa aking testimonya na dito sa continuing open investigation, active investigation, na kung saan meron pong mga persons of interest. At pag tinanong po natin ito sa mga nakakaunawa ng law enforcement, ganito po talaga ang practice ng law enforcement.
In fact, you mentioned during your direct testimony that you cannot give further details, correct? It's
Tama
classified. Okay. So, with all due respect, I'll ask this in Filipino, with all due respect to you, Director Matibag, kung hindi nyo pa po pala kayang magbigay ng detalye, bakit nyo pa po nilabas na may leads kayo in the first place?
Sapagkat gaya po ng sinabi ko, malinaw naman na yung pagsasalita ng ating Vice Presidente na siya ay kumausap ng papatay at pumayag yung papatay na patayin ang mga individual na ito, meron na pong pagkakasundo na gagawin po ang isang krimen.
Yeah, but my point is, wouldn't that prejudice your ongoing investigation that you come out here and you make statements that you already have leads?
Objection, Your Honor. That is speculative.
Witness may answer.
Kaya nga po ang dahilan na hindi ko mabanggit kung sino po yung mga persons of interest dahil doon po makukompromiso ang investigasyon na gumugulong.
Okay, at any rate, if this ongoing investigation progresses, that is the only time that a different charge will be executed against the Vice President.
Babalikan ko po ulit. Para po sa amin, malinaw na ang pagkontrata sa pagpapatay o ng papatay sa mga pangalang binanggit ay nandoon na. applying the methodology ng Secret Service na binanggit ko po kanina. Ang hindi na lang po natin nakikita ay kung sino ang taong kinausap. Kaya ito po ay still open and continuing investigation.
At any rate, it's not yet final, correct?
Tama po.
All right. Now, you mentioned that the NBI is still conducting an investigation, ongoing investigation. Do you still use the video of the November 23, 2024 press con in this ongoing investigation?
Isa po ito, sabi naging batayan para po dun sa 5-point the standard na tinitingnan po namin ay amin pong matugunan.
All right. It's an almost 2-year-old video now. Do you think it's still relevant to your ongoing investigation?
Hindi po. Sapagkat hanggang sa ngayon nga, ay hindi pa natin nahanap kung sino ang taong kinausap po ng ating Vice President.
Okay, very well. Attorney Matibag, do you know Mel Sabio?
Opo.
All right. Now, about 2 months ago, an old audio-video file of the two of you circulated online. By the way, we won't show that video out of respect to your to the party's rights, as well as I saw your wife here also, out of your family members' rights and also out of Mel Sabio's rights. I'll just ask you a few questions. This video circulated online, and you already came out in the media admitting that it was you and Mel Sabio who were involved in that video, correct?
Tama po yun. That is a private conversation sa dalawa pong magkaibigan na hindi nagkakasundo.
All right. And my only question to you is this. Did that incident demonstrate an emotional outburst on your part?
Kasama na po yun, combination na ng galit at disappointment. At ako naman po inamin ko na yan ay isang pagkakamali na akin pong tinanggap na rin at tinagsisihan.
All right. Could you recall what you said in that video?
Masama po yung aking mga sinabi. Meron pong hindi talaga kaya-aya.
Can you recall, just to give an idea of those who were not able to watch?
I cannot exactly recall because that was a really long time ago.
That's okay. Now, on July 10, 2026, you wrote a letter to Representative Luistro. Do you confirm this?
July 10,
2026.
Opo.
All right.
Opo.
And in that letter, we can confront you with a hard copy, but we can also flash. In that letter, you mentioned, and I quote, "As Director of the Bureau, I will personally attend to represent the NBI at this summit of Director and Commissioner General level law enforcement leaders across the Asia Pacific, which will require my travel and attendance on those dates." Now, those dates pertain to July 21 to 22, 2026. So today and tomorrow. Do you confirm this?
Opo.
All right. Now, in that letter, there was a prior letter to that, correct? Which you received from FBI Director Kash Patel.
Tama po.
Do you personally know Kash Patel?
Hindi po, pero hindi po siya personal kong kilala.
All right. And did you inform him at any point that you're a lawyer?
Hindi ko po alam kung alam niya na abogado.
Okay. That's interesting because in the letter, and I'll use my pointer again, he referred to you as Dear Director Attorney Matibag, which in this record was submitted to this honorable court through the prosecution on July 13, 2026. Now, just a manifestation, this now forms part of the records of this case. So, are you friends or did he just research about your being a lawyer?
Ganito po kasi ang nangyari dyan. Meron pong high value target. One of the top 10 most wanted. Si Henry Kimball, ang pangalan po niya, who scammed the government about 2.8 billion. Number 2 po siya sa 10 most wanted. And we have a coordination meeting with our local counterpart ng US Embassy na FBI station in Manila, si Ma'am Courtney, asking for our help for the extradition of this person who happens to have a problem in the court in Makati. They were expecting na ito pong taong ito ay matagal pa bago ma-extradite sa kanila. Lumapit po sa atin sa NBI at dahil natulungan po natin na yung inaakala nilang buwan ang lilipas bago ma-extradite, inatulungan po natin sila sa loob ng 2 araw ay na-extradite po. Kung kaya nung na-extradite po, ito pong si Henry Kimball Ako po ay tinawagan ni Ma'am Courtney ng FBI nang siya nasa Amerika at sinabi na nagpapasalamat. Katunayan po, nagpadala po ng letter of gratitude ang FBI. At yung pong pag-attend ko sa Bangkok, hindi naman po basta lang ako attend doon sa conference. There was an opportunity on the side na magkaroon po kami ng pagpupulong po ng personal ni Director Kash Patel.
Yeah.
Kaya po gusto ko sana makadalo doon.
Thank you for that clarification. Anyway, I'm just asking because the schedule of the court actually changed or was altered because of this letter. Just a few questions on this. Now, upon perusal of this letter, it appears na sinulatan kayo na diretso ni Director Kash Patel and walang address yung NBI. It just says Manila. Do you confirm the receipt of this letter?
It was sent through an email.
Through email. Okay. Now, of course, before you wrote Representative Luistro, you first confirmed your attendance with FBI Director Patel. Am I right?
Wala pa po na confirmation. Dahil malinaw naman po, sinasabi ko nga po kay Congressman Luistro na 2 event siya na magkasabay. Sayang yung opportunity na maaari kong makausap yung FBI Director sapagkat it's very rare that an FBI Director will talk to an NBI Director.
Yeah.
So sinabi ko na baka naman pwede na mas mapaaga. Kung pwede lang at kung makikita naman po doon sa liham ko, respectfully I'm requesting. Pero lininaw ko po kay Congresswoman Luistro na 2 event yan at in order of priority, ang aking pong priority ang tumistigo po dito po sa impeachment court. At sabi ko naman, pinabot ko po through Ma'am Courtney that probably we can arrange another day na magkausap po kami ni Director Kash Patel.
Okay, thank you for that clarification. At any rate, you're admitting that before you wrote Representative Luistro, hindi pa final yung confirmation mo dito kay Director?
Meron na pong arrangement.
May
Pero
arrangement
alam po nila na ako'y magtitistigo. So kung malilipat po, that is the only time na ako po ay pupunta sa Bangkok po.
No, I'm talking about may confirmation na kayo ni Director Kash Patel before you wrote Luistro, wala pa?
There was already an invitation and information channeled to their local representative, si Ma'am Courtney po.
Ma'am, sino yun, ma'am?
Siya po si Courtney, siya po yung FBI representative
Okay.
dito.
At any rate, my question is, do you maintain that this is an official invitation from FBI?
Yes.
Kash Patel?
Opo.
All right.
Katunayan, meron pong dumalo ngayon doon, yung pong aming representative ng IOD.
And it's also director or commissioner level?
Ano po, siya po ay division level po.
Are you at liberty to disclose the name? Or?
Yes, opo, Attorney Chris Hernandez.
Nandun siya sa Bangkok ngayon?
Nandun po siya ngayon.
Would you know kung si Director Kash Patel nag-attend dun sa Bangkok ngayon or nag-cancel din siya?
Hindi ko po alam. I have
Ayun
to
ba?
get the information.
All right. Now, just one last manifestation, Your Honor. Again, these documents comprising of 3 documents, June 24, July 10, and July 13, were introduced by the prosecution and then are now part of the records of this case. If I may be allowed to proceed, Your Honor. Now, I'll show you one last graphic and then I'll ask you a couple of questions thereafter. Can we show the graphic? All right. So, this is from the Daily Tribune.
Your Honor, please.
No question yet, Your Honor.
Yes,
Let counsel finish with his question
All right.
and then the lead prosecutor may make her objection.
All right. This is from the Daily Tribune. Okay. And this is the entitled Public Trust Rating. I'll just focus on the green, not the red. No, but Vice President Sara Duterte, it says they're 57%. And this was conducted by the Social Weather Station's SWS survey. Okay. Now, my question to you is this. You mentioned that you have an ongoing investigation. Do materials like this, insofar as how Filipino people view or trust VP Sara, have an effect in your investigation?
Objection,
Before
Your
the
Honor.
witness answers, lead prosecutor is recognized for objection. What is the basis of the objection?
Your Honor, the defense is showing a picture of the president and the vice president with a certain rating at the bottom. This has no relevance at all, Your Honor. with respect to the subject matter of this impeachment trial.
I think he
And
has...
we are objecting to the presentation of this picture, Your Honor.
I think it has... Just a short rejoinder, Your Honor.
Kindly allow the lead prosecutor. Are you done, ma'am?
Yes, Your Honor.
Just a short rejoinder, Your Honor.
Attorney Vinloan is
The
recognized.
witness mentioned the term betrayal of public trust. And we can run the TSN back. Your Honor, of course, we're allowed, this is cross-examination, we're allowed to present controverting evidence to that statement.
The chair will allow the witness to answer despite that there is no date when the survey was taken. Kindly answer if you know, Director Matibag.
Gladly, Mr. Presiding Officer. Alam niyo po, survey yan. And all of us know, or for the information of the public, a survey is just a snapshot of something. It doesn't necessarily follow na yung survey na yan is kumbaga nakataga na sa bato. Pangalawa po, may mandato po ang NBI. We cannot be swayed by public opinion o kaya po ng aming personal na opinion. Kami po ay nag-iimbestiga, nababatay sa batas, nababatay sa proseso, at nababatay po sa ating itinakdang mandato base po sa pagtatatag ng NBI.
So the short answer to my question is no, it doesn't affect.
No, it
All
will
right.
not.
Okay. I mentioned Daily Tribune. You write editorials for the Daily Tribune, correct?
Tama po, long time ago po.
Long time ago. And in 2024, you wrote at least 3 editorials about VP Sara. Is that, can you recall?
Mari po, mayroon po akong mga sinulat tungkol kay Vice President.
I'm showing you these, no, not that one, the editorials, all right, from the Daily Tribune. And we have copies, hard copies that you can refer to. But it says here, Director Belvin Matibag. Do you confirm that it is you who authored these editorials?
Yes.
All right. Now, I'm showing you the first one entitled Inday Sara, the Bratinella, dated September 12, 2024. Do you confirm that you wrote this editorial?
That's correct in my opinion column.
All right. And you also wrote, the Bratinella is a flat spare tire, dated October 24, 2024. Do you confirm this?
Yes.
All right. And you also wrote, Bratinella Sara and her bad habits, dated November 7, 2024. Do you confirm this?
Yes.
And in these editorials, you shared your opinions against VP Sara. Is that correct?
Well, unang-una po, siguro dun sa title na Bratinella, that is not my original. In fact, kaya ko po nasulat yan, yan ang mismong naririnig ko nang kami magkakasama nila dating Pangulong Duterte nang tawag niya kay Inday sa Bratinella.
Alright, so my only question is, before you testified today, there were already instances in the past that you shared your public opinions against VP Sara.
Well, that is a opinion column.
Alright.
At meron po tayong mga pinagbabasihan dyan.
Okay. In fact, let me read one line from your editorial. It says there, as Inday Sara is being unmasked in the legislative inquiries and by her own mouth as an ill-bred Bratinella, her public trust crumbles. You confirm that you included this statement in your editorial?
Yan po yung nakasulat.
All right. And despite this position and the recent surveys show that VP Sara was even gained positive trust rating, as shown earlier, a positive 57. Do you confirm this?
Well, again, I'm saying na nung sinulat ko po yan, that is my opinion as an opinion writer.
All right. Now, despite this positive trust rating by VP Sara, do you still maintain that, and I quote, her public trust crumbles?
Well, para sa akin po, na ako yung NBI director, palagi ko po hindi po material itong ating pinag-uusapan sapagkat sabi ko nga, ang ating po pag-iimbestiga ay nababase sa batas, nababase sa ebidensya at prosesong nandoon na nang ako'y dumating po bilang NBI director.
All right. One last question on this before I let this point go. So considering the positive trust rating of VP Sara, can one really say that she betrayed public trust?
Magkaiba po yan.
Speculative, Your Honor.
Can we get a ruling, Your Honor?
Witness is knowledgeable enough to answer. He can handle himself. Director Matibag, you may answer.
Magkaiba po yan. Again, I'm saying, and I'm sure marami rin po rito nakakaalam na umaasa sa mga survey. A survey is just a snapshot of what's happening. It doesn't necessarily follow na pagka yun ang lumabas, ay yun na yung totoo. Pangalawa, pagka po ating pinagbasihan ng popularidad, ang ibig sabihin po ba nito, ang isang pinakakilala at popular na tao pwede lang gumawa ng krimen at hindi natin papapanagutin?
Your Honor, at this point, Your Honor, the defense is constrained to ask for a continuance, and we have our grounds therefore. Number one, Your Honor, the testimony of Director Batibag earlier consisted of a lot of new topics, and it is we believe that it is the right of the respondent to intelligently cross-examine him on those topics. Again, Your Honor, those topics are not included in the articles of impeachment and are considered new. In fact, Your Honor, as earlier stated, we feel that these new topics are a violation of the respondent's right to be promptly and fully apprised of the exact charges against her. So we will need time, Your Honor, to go through those new materials and new points. Secondly, Your Honor, during direct examination, a document, a 100-page document was introduced and allowed by this court. And that document is unsigned and unnotarized. And we feel like for us to intelligently cross-examine the witness on this document that he mentioned, we need that there's a need, we feel that there's a need for a continuance, Your Honor.
What
With all
does the
due
lead
respect,
prosecutor
Your
say?
With all due respect, Your Honor, we object to the motion for continuance of the defense. The defense already started and propounded a lot of cross-examination questions to the witness, and the witness is simply answering completely, accurately, the questions which are being raised and propounded to him. We do not understand, Your Honor, why they will move for continuance after already raising a lot of questions to the witness, Your Honor. We would like, Your Honor, the defense to finish the cross-examination today. And if the impeachment court will still allow, we will immediately proceed to redirect after the cross-examination, Your Honor. With all due respect to our honorable senator judges.
The objection of the lead prosecutor is noted. However, this is the first time that any counsel for the parties is asking for a continuance. The chair is inclined to grant it and will so grant it as well. Should the counsel for the prosecutors or the lead prosecutor or panel of prosecutors require it at some point in time in this trial or hearing. But let it not be the rule or let it not be a habit on the part of either counsel for the parties to do so, to ask for a continuance. But at this time, the chair will grant a continuance requested by the defense. And in the meantime, since it's only 5:55, with the indulgence of our senator judges, we may proceed to the interjections and interventions of the senator judges.
One last point, Your Honor, before the interjections.
Before recognizing the senator judges, yes, what is the pleasure of Attorney Binlon?
Your Honor, considering that the witness introduced, as I said, a lengthy document, can we ask for a copy of the Las Cañas material that he provided?
The chair already earlier ordered that, I believe. During the interregnum, the prosecutors are directed to kindly furnish the counsel for respondents with a copy of the, I believe, over an inch or little less than 2 inches of affidavit of Mr. Las Cañas. So ordered. Chair will now recognize, prior to Senator Judge Rafi Tulfo earlier, Senator Judge Villanueva indicated his desire to interject or make interventions. Thereafter, Senator Judge Rafi Tulfo. Thereafter, Senator Judge Risa Ontiveros. You have 2 minutes, sir, and you may proceed when you're ready.
Mr. Presiding Officer, before I ask some questions, I can see that my time is already running. Let me just ask a procedural inquiry, Mr. Presiding Officer. And respectfully, this representation seek the guidance of the court on a procedural matter. Because earlier today, I heard our witness who made mention several times that the investigation is still ongoing. It's a continuing investigation. May we know, Mr. Presiding Officer, in this particular aspect of the NBI's investigation that remains ongoing, just for the guidance of this representation, and I'm sure for the guidance of both parties, kung matatapos na po yung investigasyon o yung presentation of evidence dito po sa Article 4 at magkakaroon po ng significant development na maaari pong material sa atin pong proceedings, ano po ang tamang proseso para maipabatid at kung kinakailangan maiharap po ito sa impeachment court, considering na isasara na po itong presentation of evidence sa Article 4.
Senator Judge Villanueva, as a rule, the court is a passive body. Hindi panghihimasukan ng husgado kung ano man ang pwede, balak o gustong gawin ng magkabilang partido, prosecution man o sa hanay ng respondent, kung mangyari man yun. And the court will not speculate with respect to that hypothetical situation should it arise, lest we be accused of prejudging or deciding certain matters for the parties that they should be the one deciding should that happen.
Thank you very much, Mr. President, Mr. Presiding Officer. And in fact, I would suggest na kung maaari ay i-consider, because we feel that the suppletory application of the revised rules of court under Rule 6, most directly po doon sa Section 24, Rule 119 of the Rules of Criminal Procedure, provides, and I quote, "At any time before finality of the judgment of conviction, the judge may motu proprio or upon motion with hearing in either case reopen the proceedings to avoid a miscarriage of justice." Close quote. So just to put on record, Mr. Presiding Officer, na ito po yung magiging proper procedure. Marami pong salamat.
That is an option that the court may take, as the rule itself suggests. But at this juncture, the presiding officer would rather leave it to the parties, given that this is an adversarial proceeding, and the parties should know what they should do for the interest of their respective clients. You may proceed, sir, with your questions. You have 2 minutes.
Thank you, Mr. Presiding Officer. Thank you, Mr. President. Just one question to our witness, Director Matibag, for the benefit of the court and this representation. Maaari po ba ninyong ipaliwanag kung paano ini-evaluate po ng National Bureau of Investigation ang isang aligasyon na ang isang tao ay nag-utos o kumontrata ng iba upang magsagawa ng isang krimen? Bilang bahagi po ng inyong investigasyon, tinukoy po ba ninyo kung ang ganito pong aligasyon ay maaaring pumasok sa mga umiiral na probisyon ng ating revised penal code o iba pang special penal laws? Director Matibag, I'd like to ask this question because I believe, I don't know if you would agree with me, that the Bureau's role is to determine whether the facts may actually give or the facts may give rise to a criminal liability under our penal laws. Now, the constitutional function of this court, however, is different. We are not sitting as a criminal court to determine guilt beyond reasonable doubt. Rather, we are called upon to determine whether the respondents' alleged acts constitute impeachable offenses, including betrayal of public trust. So magkaiba po yung binabanggit natin na criminal liability at constitutional accountability. Hindi po lahat ng maaaring maging batayan ng impeachment ay kailangan tumutumbas sa isang krimen, sapagkat ang impeachment ay hindi naman po usapin lamang ng paglabag sa batas, kundi paglabag sa tiwalang ipinagkakaloob ng taong bayan. Ano pong masasabi niyo dito, Mr. Witness?
Your Honor, tama po yun. doon po sa uling sinabi ninyo na hindi naman nangangahulugan no, kung may krimen na nangyari, ito ay impeachable offense. Pero ilagay po natin sa pangyayaring to, kaya naman po, yung pong investigasyon doon sa grave threat at doon po sa inciting to sedition, malinaw po ito na napapaloob sa revised penal code. E yun naman po pag-iimbestiga at paghahanap doon sa taong kinausap para pumatay, hindi po ito napapaloob sa revised penal code dahil yung pong pagpaplano ng pagpatay, hindi naman po pinaparusahan yan kung hindi nga nagawa. Subalit doon na po papasok yung sinasabi nga natin na meron pong sinasabi na sa impeachment, tinitingnan po at para sa akin nga, yung betrayal of public trust, dito po papasok. Bakit po? Dahil meron po siyang sinumpaang tungkulin. Doon po mismo sa kanyang oath of office bilang Vice President. Sinabi niya that protect and defend the Constitution, execute the laws, do justice to everyone, and consecrate herself to protect the nation. Pero doon po sa sinabing execute the laws. Dito po natin nakikita, hindi po execute the laws yung pag-usap ng papatay. That is to execute the president. Kaya doon po papasok yung magkaiba na betrayal of public trust.
Naintindihan ko po yung binabanggit nyo, yung role ninyo na limitado doon sa criminal investigation. At yung findings po ninyo, hindi po, again, I think binabanggit nyo nga po, hindi po ibig sabihin ay impeachable offense kaagad-agad.
Tama po.
And again, that's why I'm putting into the records na this is not a criminal proceeding, but an impeachment na proceeding. Last but not the least, no, dun sa binanggit po ninyo, there is a difference between saying that an individual has not yet been identified and saying also that no such individual exists. So, ang una, nangangahulugan na nagpapatuloy pa po yung Bureau sa pagberipika at pagbavalidate ng impormasyong mayroon ito. Sa ikalawa naman po ay isang konklusyon na matapos ang isang investigasyon. Director Matibag, maaari po ba ninyong ipaliwanag yung kahalagahan ng distinction na ito sa point of view of the NBI sa inyong pag-iimbestiga?
Doon na po natin dihiwalay.
Before the witness answers, kindly wind up after that question, Senator Judge Joel. Witness may answer?
Yes.
Doon nga po natin inihiwalay yung investigasyon na nangyari doon sa grave threat at inciting to sedition. Pumasok na po tayo doon sa pag-iimbestiga kung saan hinahanap natin yung kinausap. At bakit po tayo naniniwala na may kinausap? Sapagkat dun sa pronouncement po mismo ng Vice Presidente na may kinausap siya at pumayag. Ang naging basehan nga po dito, yung aking pong testimonya kanina na yung 5-point field po na pinagbabasihan ng National Threat Assessment Center na ginagamit po ng Secret Service po ng Amerika.
Okay po. Siguro hilingin ko na lang, Mr. Presiding Officer, at sa ating witness, kung matapos po yung inyong ongoing at sinasabi niyo nga pong continuing investigation, ay ma-inform lang din po ang korting ito. Maraming salamat, Your Honors, Mr. Presiding
Thank you, Senator Judge Villanueva. Senator Judge Tulfo Rafi is recognized for his interjections and interventions. You have 2 minutes, sir, for your questions. You may proceed when you're ready.
Mr. Witness, are you familiar with the case of Ronel Mas?
Opo. Napanood ko po yan.
At that time, hindi pa kayong NBA director or not connected to NBA whatsoever. So, tell us briefly dito sa kaso ni Ronel Mas.
Sa pagkaalala ko po rito, itong si Ronel Mas ay isang guro na kung saan siya ay nagsabi na kung sino ang papatay sa dating Pangulong Rodrigo Roa Duterte ay papabiyaan niya ng 50 million. At sa pagkakaalala ko po, ang National Bureau of Investigation rin po ang tumugis at tumuli sa kanya, particularly po ang aming pong opisina sa Region 1. At siya po ay kinasuhan po ng pagbabanta at itinuring po na ang threat niya isang malaking threat po. Hindi lamang sa dating Pangulo, kundi po sa ating pong national security.
In other words, pinalin siya ng case ng inciting to sedition. And he was arrested warrantless. It was a warrantless arrest, right?
Tama po.
Okay, so isang guro nagbanta sa dating Pangulo, agad-agad inaresto ng walang warrant. Now, Etong yung VP Sara, si Vice President Sara Duterte, na nagbanta rin kay Pangulong Duterte at kay Pangulong Marcos. Anong difference ng dalawa?
Well, ang pagkakaiba po nila, itong si Renema sa isang guro, si Vice President, isa naman pong Vice President, at siguro po ito ang naging konsiderasyon kung bakit hindi siya inaresto agad.
So ibig sabihin ng NBI pala ay tumitingin sa tinatawag na special treatment.
I cannot
So ibig sabihin hindi pala patas sa NBI. Bakit nung panahon ni Pangulong Duterte, isang guro na nagsabi may patong sa ulo na 50 million si dating Pangulong Duterte, kung sino man makapagpapatay sa kanya, agad-agad inaresto ng walang warrant of arrest. And then ito naman si VP Sara na sabi nyo, allegedly nagbigay ng death threat against President Marcos at hindi inaresto.
I cannot speak for the NBI at that time, Your Honor, sapagkat yung mga pangyayari pong yan, wala naman ako sa NBI pa po. Subalit, ang ari ko pong ibahagi sa inyo, ipamarapatin po ninyo, yun na nga pong aking pakikipagtalastasan sa aming pong mga foreign counterparts na aking din napag-aralan at sinasabi nila na sa kanilang jurisdiction, kung merong isang pagbabanta na ginawa ng Vice Presidente, ay maaaring agad na ikulong at matanggal ka agad po sa pwesto. Pero again, respectfully, I cannot speak for the NBI noon po at saka yung pangyayari po noon po.
Okay, ano ibig sabihin po ni para sa inyo, Mayor Baste, nung sinabi niya sa isang Rage Coalition gathering, isang ulo lang naman ang kailangan namin at ang ulo ni BBM or Bongbong Marcos. What does it mean to you?
Well, kagaya po ng aking naging testimonya, itrinato po namin ito na isang threat sa isang banta sa ating Pangulo that transcends also to a threat to our national security.
So is it the same as saying may patong sa ulo ang isang tao, like a reward, whoever can capture this person, dead or alive or something to that effect?
It could be that way or it can be in many ways, pero ang sa amin po, ang namin naging interpretasyon nga dyan, isinama po namin ito sa maraming banta sa seguridad ng ating Pangulo at sa seguridad po ng ating
So again, kung tinuturing yung threat, itong salita na binitiwan ni Baste or Mayor Baste Duterte against President Bongbong Marcos, anong difference niyan dun sa binigay naman na threat ni yung teacher na si Ronel Mas kay dating Pangulong Duterte?
Yung pong naging banta ni Mayor Baste Duterte, ipinasok po natin sa mas maaba pang pagsusuri, kaya po isinama natin ito po doon sa ating continuing threat assessment po.
So why was he not arrested? Tulad na nangyari sa teacher na si Ronel Mas.
Ang warrantless arrest po kasi, kagaya na nangyari kay Ronel Mas dahil naging warrantless of arrest, siya po ay na-dismiss ang kaso. So yan din po yung iniingatan namin na kung kami ay gagawa ng warrantless arrest, ay maaari pong ma-dismiss ang kaso. Ngayon po, kasama po yan sa case build-up namin na maaaring magdulot po ng pagpapile po ng nararapat po na kaso.
Thank you, Mr. Witness.
Thank you, Senator Judge Raffy Tulfo. Senator Judge Risa Ontiveros is recognized. You may proceed, ma'am, when you're ready, and you have 2 minutes.
Salamat po, Mr. Presiding Officer. Mr. Witness, nung nakaraang hearing po, paulit-ulit na binabanggit ang pangalan ni Princess Maui. Sino po ba yung taong yan? Background po niya, profile po niya?
Sa pagkakalam ko, isa po siyang vlogger.
Mm-hmm. Ano pong background niya? Paano siya naging vlogger?
Well, base po dun sa patuloy na pagmamonitor, siya po ay isang kritiko na madalas nagbablog at nagpo-promote po ng yung pong tinatawag natin at alam naman ng lahat na DDS po.
I see. And ano po yung bukod doon na vlogger siya dun sa panig na iyon, meron pa bang ibang profile itong Princess Maui bilang vlogger?
Katunayan po, I was informed that she or he was invited to the NBI pero hindi po siya dumalo. At yan po ay kasama rin po sa patuloy na sinusubaybayan po ng ating pong Cybercrime Division po.
Alright, salamat po. Ngayon, nabanggit rin po yung Oplan Romanov. Sabi po ni Attorney Lotok, ang alam niya ay banta ito sa presidente at pamilya nila na nagmula kay Mayor Sebastian Duterte. Sa kabilang banda, ayon naman kay Princess Maui, ay banta daw po yan sa buhay ni Vice Presidente at pamilyang Duterte. Pareho po ba yang iniimbestigahan ng NBI?
Ang alam ko po, na-cover na po ng NBI noon yung investigasyon dun sa aligasyon na yung Oplan Romanov ay banta sa Vice Presidente dahil nagpadala nga po ng subpoena kay Princess Maui at kay Vice President. Subalit, fortunately, hindi po yata sila dumali dyan. Pero nung yan po aming sinusuri din, yung binabanggit nyo po na Romanov, I think that was the January 18, 2024 na pahayag po ni Mayor Baste Duterte na kung saan na sinabi niya, let me tell you this, Mr. Bongbong Marcos, hindi ko lang po man yung exact words, but I remember that before you go to sleep, remember the Romanovs and the Mussolinis and what happened to the Marcos family in 1986. Yung po yung nakita natin na isa na naglilink po dyan sa Romanov. Kaya recently, narinig ko rin po yung dating director na sinasabi niya ng Oplan Romanov ay tunay na banta sa pamilya ng mga Marcoses at hindi po kay Vice President Sara Duterte.
So, base po sa investigasyon ng NBI, ang Oplan Romanov po ba ay banta nga sa buhay ng presidente o sa buhay ng vice-presidente?
Your Honor, yan po ay kasama pa rin sa aming tinutukoy po ngayon. Kaya po meron kaming task force, kasama po yan sa aming continuing na surveillance at active investigation po.
Alright. May actionable intelligence po ba ang NBI na posibleng patuloy pa rin ang panganib sa buhay ng presidente dun sa linyang iyon ng inyong investigasyon?
Tama po yan, sapagkat binanggit ko nga po kanina yung ginagamit sa National Threat Assessment Center po ng Secret Service ng Amerika, ay pumapasok po doon yung mga obserbasyon na yan. At katunayan po, lalo pang lumawig o lumawak yung mga banta sa presidente, namin pong namomonitor. Pati po mga ordinaryong tao ngayon, ay napakadali po na magbigay ng banta. At para sa amin po, hindi lang naman po yung banta sa ating Pangulo ang aming binabantayan, kundi yung pong bantayan natin ang kaligtasan ng ating mga kababayan at isiguraduhin natin na ang democratic process po ay umiiral sa atin base sa atin pong konstitusyon po.
At sa kabilang banda naman po, may actionable intelligence din po ba ang NBI na may totoong banta sa buhay naman ng vice-presidente?
Sa ngayon po, hindi po namin tinitingnan kung totoong may actionable intel. Pero base po sa aming mandato, kasama po sa mandato namin na proteksyonan po ang seguridad ng Pangulo, ng Vice Presidente, ng Senate President, ng Speaker of the House at Chief Justice. Kaya kung wala man pong task force, tuloy-tuloy naman po ang aming pong pagpamonitor dito.
Pero sa ngayon, kung isusuma po natin, may actionable intelligence na may patuloy na panganib sa buhay ng presidente, pero wala pang actionable intelligence na may banta din naman sa buhay ng vice-presidente.
Malinaw po yun sapagkat lumabas lang naman po yun doon sa sinasabi nitong si Princess Maui.
Salamat po, Mr. Witness. Salamat po, Mr. Presiding Officer.
Thank you, Senator Judge Luis Ontiveros. Next to interject and make his interventions would be our Senate President, Sherwin Gatchalian. He is recognized. You have 2 minutes, sir. You may proceed when you're ready.
Maraming salamat, Mr. Presiding Officer. Tama po ba, Director Matibag, na after 1 year and 8 months, wala pang nakikitang NBI na nakontratang papatay?
Wala po pong specific na personalidad.
Wala pang specific na nakikita.
Apo.
Pero kanina narinig ko sa inyong testimonya na may sinabi kayong hindi banta kundi isang plano talaga. So may plano.
Yun po ang base sa mismong pahayag ng ating pong Vice Presidente na siya ay may kinausap at yung kinausap niya ay pumayag para patayin po ang mga taong nabanggit. Para sa akin po, this is actually a public confession na dahil sa sinabi niyang ito, nalagay po sa alanganin hindi lamang po ang seguridad ng presidente, kundi po ang ating pambansang seguridad.
Sino ang kaplano niya? Kung magpaplano, obviously may kasama siya sa pagpaplano. Sino na ang natukoy ng NBI na kasama sa pagpaplano?
Yan na po yung binabanggit namin na persons of interest based on the open source intel and the human intel po na ibinabato po sa amin, na yan po ay reported po sa atin ng ating pong task force na itinayo po.
Itong persons of interest kasama sa pagpaplano at inamin sa inyo na merong pagpaplanong ginagawa para pumatay.
Meron po silang impormasyon na magtuturo po dito sa pagpaplanong
Hindi
ito po.
sila yung kasama sa pagpaplanong pumatay.
Sa ngayon po,
Magtuturo lang sila.
Doon po sa iba persons of interest, meron po kaming kinukonsidera doon na maaaring siya po ang kausap mismo ng Vice
And anong
Presidente.
ebidensya ang magpapatuloy na kasama siya sa pagpaplano o kaya niyang ituro yung pagpaplano?
Yan po ang ating kukunin na impormasyon pa sa ating pong mga persons of interest, na ating pong sinusurveillance. Katunayan po, as we speak, tuloy-tuloy po yung ating pakikipag-usap. Pati po doon sa mga malalapit sa taong aking pong binabanggit.
Okay, so tuloy-tuloy pa ngayon ang inyong investigation.
Tama po.
Ngayon, nakita ko na bumuo kayo ng task force. No? At task force, temporary in nature lang yan. Diba? Kailan matatapos ang inyong investigasyon? Dahil nga nasabi ko 1 year and 8 months na ito, ngayon may bagong task force. So kailan matatapos itong investigation?
Ito po ay matatapos finally pag atin pong na-locate specifically ang taong kausap ng Vice Presidente. At ito naman pong task force, bukod po sa seguridad ng Presidente, we are also guarding po na walang gulo, na yung pong mga destabilization ay atin din pong mabantayan.
Pero kailan matatapos yung investigation para matukoy kung sino yung nakontrata?
Only in the time po na atin pong matukoy na finally yung ating pong...
Kailan ngayon? Do you have a time frame? Base doon sa pag-uusap nyo dito sa persons of interest nyo. Kailan? Kasi like I said, no, November of 2024 to, may bagong task force ngayon. But in your opinion, no, gusto ko kasi malaman, malapit na ba o malayo pa?
I cannot give the exact time, but the task force was established on April 16 and it's doing a great progress po. So sa palagay ko po, malapit na rin natin itong mahanap itong taong ating punto.
Can you give me an explanation on yung great, quote-unquote, great progress?
Marami pong report na pumasok po sa atin at may mga pangalan po talaga na na-identify natin pong pinupuntahan po.
And can you give me a time frame kung within 3 months, 6 months, matutukoy na itong kakontrata?
As
Can
we
you
look
give me
at
a time frame? An indicative time frame?
As we go on to the progress, probably po within the 3 to 6 months, magkakaroon po tayo mas malinaw po na data tungkol po dito.
But in 3 to 6 months, matutukoy na natin yung kakontrata.
Yun po ang ating inaasahan.
Okay. In the meantime, nasabi nyo kanina na merong kinetic force. No, ito ina-assume ko na may nai-impluwensyahan. Diba? Sino na ho ang nakausap nyo na na-impluwensyahan tungkol dito sa mga sinasabi nitong mga sinasabi ng Vice President at yung iba pa?
May mga ilan na po kaming pinuntahan at katunayan, may ilan na po kaming sinampahan na rin ng mga kaso. At yung pong mga nagbanta through social media ay atin na rin pong nakausap. At yung iba naman po sa ngayon ay kasalukuyang humaharap po sa investigasyon po.
So, last question. So itong dahil sa kanilang pananalita, nagkaroon ng kinetic force at na-influensyahan ito. At base sa inyong, paano nyo nasabi na influensyahan itong mga taong ito?
Kagaya po nung aming mga nakausap, malinaw din po that they're always targeting the head of the president. May correlate po natin doon sa statement mismo ng mayor at ng ating pong Vice Presidente po.
Maraming salamat, Mr. Presiding Officer.
Thank you, Mr. Senate President. Will Senator Judge Allen make an interjection or will he make a manifestation regarding another matter? Then the presiding officer will first recognize Senator Judge Aquino for his interjections and interventions. You may proceed, sir, when you're ready. You have 2 minutes.
Thank you, Mr. Presiding Officer. Very quickly lang, Director Matibag. Kapag sinasabi kasing bukas pa ang isang investigasyon, posibleng meron, posibleng wala, di ba? Pero ito po, just one question. sa inyo pong professional assessment, anong porsyento, what percentage is the probability na meron ngang nakausap na tao ang Vice Presidente para gawin yung mga pagpatay sa inyo pong assessment? Hindi nyo pa po masasabi, may kailangan pa kayong ilang buwan, pero sa inyong assessment po ba, anong porsyento po na meron talagang nakausap ang Vice President?
Base po mismo sa pahayag ng Vice Presidente, nakasisiguro po na mayroong kinausap.
Anong percentage po? 70%?
100% po, sapagkat siya na mismo ang nagsabi ng kanyang plano na siya'y may kinausap ng papatay at pumayag yung papatay sa kanilang pag-uusap.
Okay, maraming salamat, Mr. Presiding Officer.
Senator Judge Cayetano Alan is recognized for his interjections.
Before that, on the same point of Senator Bam, may I just manifest that I have submitted, Presiding Officer, Mr. Senate President, written continuing objection to the ruling on the Presiding Officer dated 20 July 2026 on the subpoena. But according to the journal service, it will not be included in the journal. May I move that it be included in the records? In the records, whatever is more convenient for everyone.
It will definitely be in the record and transcript, Your Honor. We will see what we can do about the journal. Can we get back to you?
Yes.
Because there's a technical difficulty, I
We
believe.
were just under the impression na until today. That's why hinabol ko ng 5:31, then nilagay ko na lang possible supplemental. But whatever is more convenient for the clerk of court.
The chair will entertain a motion to reconsider the approval of the journal earlier so that we can include this in the journal and then approve it. If you would like to make that motion, Your Honor.
Well, may I move that we reconsider approval of journal just so that we can include what we agreed on yesterday, which is the written objection.
There is a motion to reconsider the approval of the journal of yesterday, July 20, 2026, in order to include as part of the journal the written manifestation of Senator Judge Alan Cayetano, as we have done so with respect to Senator Judges Villanueva, Marcos, Go, Villar Camille, and Legarda. Absent any objections, the motion is approved. Journal is reconsidered. And the insertion of the manifestation of the Honorable Cayetano is so included, so ordered.
Thank you, dear colleagues.
Would you like to complete the process and move for the approval of the journal now?
We move
Senator
the
Judge
approval with the amendment, not an insertion.
The journal is approved as amended by inserting the manifestation of Senator Judge Alan Cayetano. Is there any objection? Hearing none, the same is approved sans the reading of the same.
Mr. Presiding Officer, just
Yes,
one
what is the
point.
pleasure
Just
of,
to make a
Senator
manifestation.
Judge Villanueva?
Yes, Mr. President. It's that, I just wanted to put on record that this representation is not objecting to the ruling of the chair yesterday, and that the only reason why I wanted to put into the records my manifestation with regard to the ruling of the chair, just to put on record. Thank you.
Duly noted. Senator Judge Cayetano may proceed with his interjections. He has 2 minutes. You may proceed, sir, when you're ready.
Good afternoon, Mr. Witness, Director, Attorney Matibag, schoolmate.
Good afternoon, sir, Your Honor.
Yeah, just on that point ni Senator Bam, I understand as a law enforcer, as an investigator, you have to take all threats seriously. I'll ask you the same questions I asked the two NBI officers, and I do understand they were not under your supervision during that time dahil dun pa sila kay Director Santiago. No? I won't ask all the questions, but you did review the whole video or just the portions relevant to the statement of the Vice President na no joke, yung November 23.
Your Honor, napanood ko po yung video, but you're correct. I focus mainly on the issue that is being undertaken.
So simple question. Paano naging process kung anong parts ng video at ng statement niya ang paniniwalaan mo or ng task force? So it's not personal. I mean, if you were in the task force or as you said, you created a task force now at duty nyo yung safety ng high government officials. Anong process nyo kung anong parts ng video ang paniniwalaan nyo at hindi? Ng statements niya, what I meant.
Well, ang ginawa po natin dyan, doon po mismo sa konteksto ng kanyang sinabi na humanap siya ng papatay at inutos niya na papatayin ang 3 individual at yun po ay pumayag yung papatay at sinabi pa niya no joke, doon pa lamang po ay pong nakita yung pong ating hinahanap po na mga pwede niyang pananagutan po sa batas.
Well, as an appointee of this government, as a lawyer, as an NBI director, I see your point and I get that. But what I meant is that before that statement, sabi kasi niya, kung papatayin ako, I mean, the record will bear out naman yung eksaktong sinabi niya. No? So this is my paraphrase. But ang pagkaintindi ko sa sinabi niya, kung papatayin ako, eto yung 3 papatayin mo. And ang impression ko, pinagbibintangan niya yung 3 na may plot against her. So yun ang tanong ko dun sa 2 previous NBI directors. If you're going to believe that she contracted or talked to, may kausap, no? Siya, if you're going to believe that may kausap siya at papapatay yung 3, will you not believe the previous nung sinabi niyang kung ako naman ang papatayin?
Hindi po ganon, sapagkat ang tinignan na nga po natin ay yung kanyang mismong pagbabanta. At sa amin po, sa ngayon, yung aking pong task force na nag-iimbestiga, ay malinaw po na ang tinitingnan ay kung ano na ang nangyari dahil doon sa pagbabanta. Okay. At sinasabi nga po namin, dahil po doon sa pagbabanta, ito po ay umabot na, doon na po sa level na ang national security nataya na po, na kompromiso na. Sapagkat marami na pong lumalabas, tuloy-tuloy na pagbabanta. So doon na po natin ito tinitingnan.
Yes. In the same video, she mentioned massive corruption. But wala pa dyan kasi yung maya kayo speech at flood control investigation. So same question, Director. Naintindihan ko, yun yung pinaniwalaan nyo. May kausap siya, no joke, no joke. Pero ang question ko, paano yung proseso nyo or anong naging thinking nyo na etong papapatay yung presidente, pinaniniwalaan ko. Pero etong siya ang papatayin, hindi ko paniniwalaan. At etong graft and corruption, hindi ko rin paniniwalaan. What's the process there?
Well, ang proseso po dyan ay tinignan naman natin doon po sa pagbabanta niya, kung sa grave threat po yung pag-uusapan natin, alam naman po natin na yung threat na yan is absolute dahil nandoon naman po yung elemento eh. Doon naman po sa sinasabi namin na tuloy-tuloy na pag-iimbestiga dahil ito nga po ay umabot na sa level lang na naapektuhan ng national security, we take into context yung mismong sinabi niya na meron siyang kinausap at yung kanyang kinausap ay pumayag. Yung po kanyang sinasabi na kung papatayin ako, that is supposed to be na statement niya sa aming pong pananaw just to cover yung kanyang pagsasabi na siya may kinausap para patayin ang ating Pangulo.
Okay, I won't argue with you, yun yung proseso nyo. But in the meantime, there were 3 statements. Massive corruption, kung papatayin siya, patayin. So, focusing dun sa patayin yung 3 kung papatayin siya. In the meantime, tumutuo yung yung massive corruption, lumabas afterwards, di ba? So, just one other point. At the beginning of the prosecution's questions to you, and I think the defense had a question about what can you investigate. Can you repeat your answer? As the NBI director and the NBI can investigate, did you say all crimes o yung mga crimes?
Lahat po ng mga pumapasok sa amin na mga krimen ay amin pong pwedeng imbestigahan, mutu proprio. Ganon din po yung mga krimen na meron pong nagreklamo na araw-araw na may pumupunta sa aming tanggapan para magreklamo. Ito po yung aming iniimbestigahan. At meron din pong mga iniimbestigahan kami na inutos po ng Department of Justice. And by the very nature, under the Constitution po ng Office of the Ombudsman, they can delegate the National Bureau of Investigation to...
So as a general rule, you can investigate any crime motu proprio?
More than the investigation of the crime is also the protection of our nationals. Yes. Saka po siyempre siguraduhin na promote ang ating demokrasya hindi nakukompromiso.
Yes, but sa investigation lang. So you can investigate any crime.
Tama po.
Yeah. Isn't that against the Republic Act 10867? The statute that gives you power? The act reorganizing and modernizing the National Bureau of Investigation. Sabi dito sa inyong Section 4, the NBI shall have the following powers and functions. undertake and investigate the detection of crimes and offenses enumerated under Section 5. Section 5, may enumeration, human trafficking cases in all airports, extrajudicial, extralegal killings committed by state security forces against media practitioners' activities, killings of justices and judges, violation of 100175, otherwise known Cyber Crime Prevention Act, cases against Interagency Graft Coordinating Council, and violations of the anti-dummy law. Tapos, cases involving threats, security assaults against persons of the President, Vice President, Senate President, Speaker of the House, Chief Justices. Walang congressman, senators, unlike judges lahat. Transnational crimes pursuant to existing international agreements, identification of dead victims in case of mass fatalities, incidents caused by natural disaster, and violation of commercial, economic, financial, white-collar crimes, nakadyan yung law. So, exclusive yung enumeration. Then, provided, however, if that the President or Secretary of Justice may direct the NBI to undertake investigation of any crime when public interest so requires. So, hindi ba limited ang pwede niyong imbestigahan except that ang DOJ at President ang pwede mag-atas? That's my last question.
Yes. Kindly wind up.
Well,
Witness may answer.
Yes. Yung pong ating listahan na yan, tama po, nandiyan dyan. Subalit, hindi naman po sinasabi na nalilimita dyan ang aming pong pag-iimbestiga. Sapagkat malinaw po ang mandato ng NBI that we are the primary investigating body. Yun lamang nga po, merong mga kaso kung ito po ay bumagsak na sa jurisdiction halimbawa ng PNP na kanilang iniimbestigahan, we can still help and coordinate at the same way na kung kami po ay nag-iimbestiga at ang PNP pwede rin pong tumulong
Well,
po sa amin.
Director, if that's your interpretation, that goes against what they taught us in law school, na pag exclusive yung enumeration, you cannot add. And at the end of the enumeration of Section 5, nakalagay nga dito, however, the President and Secretary of Justice may direct you to undertake investigations of any crime. Why do they have to say any crime if you can do it any crime, if you can investigate any crime after all? It seems that you're expanding your jurisdiction by yourself.
Well, we'll be doing po yan sapagkat we have also our primary role to make sure that law and order is being promoted through the NBI din po.
Senator Cayetano can avail of the second round. Later or tomorrow, since I believe Attorney Matibag, Director Matibag, forgive me, will still be here for the continuation of cross. Senator Judge Rafi Tulfo thereafter. Senator Judge Pangilinan. Senator Judge Rafi Tulfo, you have, I believe, one question, right?
Actually, two questions, Your Honor.
You may proceed, sir. You have 2 minutes, actually.
Naku, na-stress na ako kanina. 5 minuto ako. Minamadali. But anyway, going back to Ronald Mas, what was the justification of the NBI back then when Mr. Ronald Mas was arrested without warrant?
Well, they consider po that the threat is live and alam nyo nga po, yung sinasabi na lahat po ng threat ay hindi po, ito po yung siniseryoso.
So may nag-order sa na-arrestuin si Ronald Mas?
I don't have that recollection. Hindi ko po alam, but the arrest was made by the regional office po of Region 1 po.
So would you admit now na illegal yung ginawa ng NBI noon na pag-aresto kay Ronald Mas na walang warrant?
Well, si Ronald Mas po was released precisely the reason why meron pong lapses po dun po sa procedure.
Okay. Would you also consider na the fact na merong ginawang pagbabanta si Baste Duterte na similar dito kay Ronald Mas, na dapat umaksyon din yung NBI tulad ng pag-aksyon nila sa isang guro?
Kaya katunayan, yan nga po yung aking binabanggit na tuloy-tuloy po yung investigation sapagkat alam nyo po yung warrantless arrest, lesson nga po dyan kay Romel Mas yan na dapat po kasi immediate po yung pong pag-aresto. Pag yan po ay lumipas na, hindi na po tayo pwedeng mag-aresto under the law sapagkat papasok po ito sa illegal arrest po.
Last na lamang. So, make a comparison ngayon. Bakit yung isang guro na nagbanta kay dati Pangulong Duterte agad inaresto at bakit itong isang Vice President na nagbanta kay Pangulong Bongbong Marcos hindi inaresto ng NBI?
I can only second guess po na maaaring may pagkakaiba po ng proseso or tinitingnan po ang administrasyon. ng panahon na yun at ng panahon po ngayon.
Maraming salamat po.
Thank you, Senator Judge Rafi Tulfo. Senator Judge Pangilinan is recognized. You may proceed with your intervention, sir. You have 2 minutes.
Thank you, Mr. Presiding Officer. Magandang gabi, Ginoong Direktor. Kanina tinatanong sa inyo yung usapin ng trust rating. Na mas mataas yung trust rating ng Vice President kaysa sa Presidente. Bilang abogado, tinanong sa iyo ito kanina, may kinalaman ba ang approval sa trust? Kung mas mataas ang trust rating, ibig sabihin wala ng betrayal of the public trust.
Well, wala po. Sapagkat sabi ko nga, sa akin pong pananaw, sa akin din pong kaunting eksperyensya bilang isang political advisor din po, yung ating pong mga survey is only a snapshot na mga pwedeng nangyayari. Alam naman po natin, ang tinatanong dyan, ilan lang o magpipili ng lugar kung saan po gagawin yung survey. Hindi po natin pwede itong maging basihan sa pag-imbestiga sapagkat pagkaganyan po yung ating ginawa, magkakaroon po tayo ng problema sapagkat ang mangyayari sa atin dyan, yung tinitingnan pala natin ay yung numero. At without accusing anyone, alam naman natin there are surveys that can be manipulated po.
No, but having said that, kaya ako lang tinanong yun kasi baka yung mga nakikinig nating mga kababayan ay malito dahil hindi ba tamang sabihin na iba yung trust rating, iba yung betrayal of the public trust.
Tama po.
Tama?
Yung trust rating po ay base sa numero dahil sa survey. Yung betrayal of public trust, malinaw naman po yan na nakasaad sa konstitusyon na ito ay isang basihan ng impeachment. At saan po pumapasok ang betrayal of public trust? Pag meron ka pong ginawa na pag-violate, not necessarily criminal, hindi kailangan ng conviction, kundi sinasabi po, pag tinignan natin yung discussion po ng ating Constitutional Committee ng ginawa yan, binabanggit nga po dyan yung betrayal of public trust, yung hindi mo pagtupad sa yung oath of office, that will qualify as a betrayal of public trust.
In other words, negative yung trust rating mo o 100% yung trust rating mo, base sa batas, base sa konstitusyon, pwede kang ma-convict. Whether negative or positive trust rating, pwede ka pa rin ma-convict o ma-acquit. Depende sa ebidensya sa usapin ng betrayal of the public trust.
Tama po. Wala pong kinalaman ang survey on the trust rating kundi kung ano po ang ebidensya na ipinasok po sa ating pong impeachment court.
Maraming salamat.
Senator Judge Pia Cayetano is recognized for her interjections and interventions. You may proceed, ma'am, when you are ready, and you have 2 minutes.
For the prosecution, do you consider Las Canas an important witness for you, for the prosecution?
With all due respect, Your Honor, the purpose of the testimony is to present what transpired during the investigation of the Special Task Force. As to whether or not what probative value it holds, it is not part actually of the decision of the prosecution, as what we are intending to do here is to present only what happened during the investigation of the NBI, Your Honor.
Mr. Presiding Officer, the rules of evidence are very clear. You either present a witness who provides your testimony or you present a document. And in terms of documents, Rule 132, Section 19 says there are two classes of documents, public documents and private documents. Included in public documents are documents acknowledged before a notary public. Yung pinakitang document is not acknowledged by a notary public. Pwede naman din ang private documents, that's the other class. If it can be shown and authenticated in any of the following manner. The person saw the document executed or written. Nakita ba ng witness mo na sinulat yon? Nakita ba niya?
Your Honor, we can...
No, please answer my question.
No, Your Honor.
Oh, the next manner of authenticating by evidence of the genuineness of the signature or handwriting of the maker. The defense said ni walang original signature doon. Do you disagree with that?
We don't, Your Honor.
Okay, and the third, by other evidence showing its due execution and authenticity, did you provide?
No, Your Honor.
Okay, so simple lang, Mr. Presiding Officer. They're trying to prove something by showing a document that any law student, even yung mga kababayan natin na nakikinig na ngayon na ang dami ng alam sa procedure, will tell you na hindi acceptable yon. And with all due respect, katulad din nung kahapon na humingi ako ng payo sa inyo, again, I will not name names, we had a discussion in caucus na you cannot unsee what you see. You cannot unhear what you hear. So pinalabas yun. Wala akong problema na palabasin yun, pero do your job and present the proper witness and the proper documentation to do that. Do your job. I'm addressing this, Mr. Presiding Officer, to us as a body. Kasi hindi tama yun. Magdidesisyon tayo, you warn us, pero pinabayaan natin na makita yun. Minamarkahan pa, submarkings. What's the purpose of all that?
May I respond, Your Honor?
Not really.
I don't believe
because
there
I
was a
already
question.
answered. I already asked you the questions, and you had a chance to respond. Yes.
There was no question posed, sir. I was
There's none, yes.
telling the lead prosecutor.
I move to my next point, Mr. Presiding Officer. Our jurisprudence is very clear, no? A witness must be competent and credible. Di ko na babasahin lahat yung jurisprudence natin dyan dahil kompleto na yung record natin dyan. But there is also a also included in our rules, Rule 132 on the rules of evidence, and I'll read it. A witness may be impeached by the party against whom he or she was called by contradictory evidence, by evidence that his or her general reputation for truth, honesty, or integrity is bad, or by evidence that he or she has made at other times statements inconsistent with his or her present testimony. So this is the rules, no? Siguro we can, well, I'm reading the rules, so we can take notice of this, that this is what our rules say, and I don't think anyone will contradict that. Again, there are lots of cases supporting this. So, just want to point out, Mr. President, that, just looking for my notes. Sorry, with the indulgences of the body, I'm just looking for my notes because I want to be accurate in my the next statement that I'm going to read into the record.
If the lady cannot locate it, she may avail of her time again tomorrow, since Director Matibag and the counsel for the parties will be
Pwede
here
naman,
tomorrow.
but if you give me a few more seconds, I might be able to dispose of this issue, Mr. President, Mr. Presiding Officer. Okay, I won't delay I can paraphrase it, but I think it would be best if I look at the record, so I will just avail.
The presiding officer will give the
witness will be
lady
here.
first crack at interventions by Senator Judge tomorrow after the cross-examination of the counsel for respondent tomorrow. Since Director Matibag will be here again tomorrow for the continuation of the cross-examination by counsel for respondent, the interjections and interventions of the other senator judges may proceed. Again, after the cross-examination, redirect and recross if any. So the senator judges have time until tomorrow. Unless there are other matters that the counsel for the parties would want to discuss, the court will wind down with some administrative matters. Yes, counsel for respondent.
Your Honor, aside from the Las Cañas document, we would also like to request a copy of the AO number 11, just for reference, Your Honor, to be used as AO number 11.
The counsel, the prosecutor is directed to furnish within
We can do
the
that
day.
after the proceedings, sir.
Within the day after the proceedings, a copy of AO number 11, signed by Director Matibag, dated, if I'm not mistaken, April 16, 2026. Any other points you want to raise, lead prosecutor?
Your Honor, it appears that there is standing subpoena for
I will rule on that in a bit. I will
Ms.
rule on that in a
Marivic
bit.
Pareja.
I will rule against who?
Ms. Marivic Pareja of Legislative Archive. We manifested yesterday, Your Honor, that we have yet to determine when we will be presenting this witness.
Yes, we will act on these at the proper time. This will be part of the chair's ruling before we adjourn.
May I inquire, Your Honor, if tomorrow we will be able to conclude the testimony of witness Director Matibag, whether or not we will be proceeding to present the first witness for confidential fund, Your Honor.
The court will address that in a bit before we adjourn, counsel. Any other points, counsel, for the respondent?
No more, Your Honor.
Court will now dispose of some administrative matters. We are in receipt of a request for subpoena ad testificandum addressed to Ms. Marivic Pareja, as well as subpoena ad testificandum addressed to Mr. Roderick C. Wamil and Ms. Eileen May Del Ocampo, both from the Commission on Audit. The chair, the presiding officer, defers action on these requests for subpoena and will act on them at the proper time and in due time. In regard to the subpoena ad testificandum and ducestecum issued to Ms. Violeta Constantino and Ms. Nenita Camposano, the chair in the meantime recalls the subpoenas issued to them without prejudice to reissuing the subpoena at a later time for a later date. Para po sa kaalaman, ang dalawang sinabpina ng Senadong ito bilang impeachment court na si Ginang o Binibining Violeta Constantino, Ginang o Binibining Nenita Camposano, hindi niyo po kailangan magpunta dito sa hukuman bukas. Binabawi pong pansamantala ng hukumang ito ang subpoena in-issue para sa inyo at mag-i-issue na lamang po kami ng panibagong subpoena kung kailan po kayo kinakailangan magpunta o magtungo dito sa impeachment court sa Senado. What is the pleasure of Senator Judge Zubiri?
Thank you very much, Presiding Officer. Just want to ask a question. You are withdrawing the subpoena because you feel that we might not take them up tomorrow, is that
Yes, that is correct, Your Honor.
correct? Haba pa ba to kay witness Matibag? You mean we cannot take it up tomorrow?
I would think so. That was pursuant to a discussion with both counsel for the parties earlier.
So
Senator
we're
Judge
looking
Zubiri.
at taking up that article on Monday.
Yes, that is correct, Your Honor.
Okay, thank you, Your Honor.
Also, in regard to the trial, the senator judges
SONA,
agreed.
Tuesday pala po.
I'm sorry.
Tuesday, sorry. Monday is the SONA. So Tuesday.
I will discuss that too, Senator Judge Zubiri. During caucus, the senator judges agreed for next week there will be no trial on Monday, given that it's the State of the Nation of the President. There will be no trial on Tuesday to afford the minority the opportunity to prepare and deliver their contra sona, which is a tradition in relation to the State of the Nation address by the President. So our next trial date, for your information, which we will clarify on Wednesday, tomorrow, will be on July 29. Now, on July 29, again, as agreed in caucus by the senators and the senator judges, the new time of the trial will be from 10 a.m. to 3 p.m. And the session of the Senate will be on or at 4 p.m. So to repeat, no trial on July 27, Monday. No trial on July 28, that's a Tuesday. On Wednesday, our trial will resume July 29 at 10 a.m. up to 3 p.m. with a break, short break for lunch, snacks, or the call of nature for anyone. Henceforth, after that week in August, we will be conducting the trial from Monday to Wednesday from 10 a.m. to 3 p.m. Counsel for the parties are asked to take note. So, to avoid confusion, Director Matibag, we expect you to come back and be here again tomorrow, not at 10 but at 2 p.m. To continue with your testimony via the cross-examination, redirect or recross of the counsel for the parties, and questions from the senator judges. Without issuing a subpoena, Director Matibag, do we get your commitment to be here tomorrow?
Yes, Your Honor, gladly.
Thank you very much. There being no other matters to be taken up and no other business to take up, the trial is hereby adjourned until tomorrow, Wednesday, July 22 at 2 p.m. in the afternoon.